Which begs the question, why would an officer ever let anybody out of the vehicle if they can broaden their ability to search these individuals by just simply making them stay in the car?
Hey everyone, I have got something They sleep until I decide to do something, then there's dogs everywhere. I just want to give you a little bit of quick background on this case because what we're going to hear is a motion to suppress, and it's a little too much to put in text because they don't really cover what happened and how it led up to this, just a little bit, but not enough. So this happened in Butler County, Kansas, back in January, and one of the sheriff's officers conducted a traffic stop on a vehicle that failed to yield. Another officer responded to the scene, so there was 2 officers on scene, and there was 5 occupants in the vehicle. And the driver was discovered to have a suspended license and no proof of insurance, so he was taken into custody. At some point in time during the traffic stop, one of the officers was actually a canine officer, or he was in charge of the canine officer because the canine's actually an officer too. So the canine was walked around the vehicle and hit on the vehicle. At that point, they took everyone out of the vehicle, and it's alleged that when the passengers were ordered out, Ms. Sizemore, who is the defendant, asked to take her purse with her and was told to leave her purse in the vehicle. The detective specifically said everything stays in the car, which included her purse. So the whole controversy here is a woman's purse allowed to be taken out of a vehicle with her, or is that part of the search of the vehicle? And there's a good bit of argument back and forth and some case law on whether that's allowed or not. So I'm going to let you get to it, and you're not going to hear me again. So everybody have a fabulous day. See you soon.
This is in the District Court of Butler County, Kansas. Case entitled State of Kansas versus Christina Lynn Sizemore. Case number 2023 CR 11. Brett Sweeney appearing for the state of Kansas. James Watts is defense counsel. Defendant Sizemore now appears in the office of her attorney, James Watts. This matter comes before the court at this time for hearing on a motion to suppress evidence. Mr. Sweeney, do you intend to present evidence at this hearing?
Your Honor, I've been kind of going back and forth on that because I think the facts are largely undisputed on both sides. I don't know. I may call Deputy Nitcher for just very few questions for a few things I want to establish.
Very well. Deputy Nitcher, you can join fully with audio and video.
I'm here, Your Honor.
Okay, very good. I'm going to administer an oath to you at this time. If you'd raise your right hand, please. You do solemnly swear that the testimony you're about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
You may question the witness, Mr. Sweeney.
Thank you, Your Honor. Sir, would you please state your name for the court, please?
Be Deputy Caleb Nitcher,
And Deputy Nitcher, who do you work for?
the Butler County Sheriff's Office.
And Deputy Nitcher, how long have you been a law enforcement officer?
7 years.
Okay. And I'm assuming in that course of your employment with the Butler County Sheriff's Office and also as a law enforcement officer that you had the opportunity to investigate and work traffic cases.
Yes,
How about drug cases?
I have.
Okay. I want to direct your attention, Deputy, to January 10th of 2023. Were you on duty and acting in capacity as a Butler County Sheriff's Officer on that day?
I was.
Okay. And officer, specifically at 10:49 a.m., can you tell me where you were located and if you had the opportunity to conduct a traffic stop?
I was on US 54 in Butler County, and I did conduct a traffic stop on US 54, westbound lane.
Okay. And talk to me a little bit about, I guess, why you pulled the vehicle over and then if you made contact with the occupants of that vehicle.
Yes. So we were traveling westbound, and what I noticed was the vehicle went from the left to the right lane without engaging its turn signal. And when it returned to the left lane and passed a semi-truck and trailer, after the vehicle passed the semi-truck, it turned to the right. It turned to the right using its signal immediately. causing the semi truck and trailer to lock up, causing the brakes. So almost caused an accident.
Okay. And I'm assuming then you pulled over the vehicle.
Yes, I did.
Okay. And I'm going to kind of try to cut right to the heart of the issue. I'm assuming you made contact with the occupants of the vehicle. How many people were inside this car?
There were 5.
Okay. The driver, what was his license status?
It was suspended.
Okay. Did the vehicle have insurance on it?
At the time, no. Vehicle insurance was later located. Someone sent it through a cellular device.
Okay. But at the time, he wasn't able to provide insurance?
No.
Okay. What were your intentions with the driver of the vehicle?
He was going to be going to the Butler County Adult Detention Facility for driving while suspended.
Okay. You were also the canine officer, is that correct?
Correct.
Okay, so you had the canine officer in your patrol vehicle with you?
I did have the drug dog in my vehicle.
Okay. At what point did you run the drug dog around the vehicle?
It would be before arresting the driver for driving while suspended. I left them in the vehicle.
Okay. At some point, did the drug dog hit on the vehicle?
Yes, the dog alerted to the odor of illegal narcotics when I deployed her at 11:04 hours.
Okay. Were the occupants of the vehicle left inside the vehicle during the running of the drug dog? And if so, why?
Yes, they were. It was a safety precaution with me and one other deputy on scene. There were 5 occupants. And I actually went up to the car and asked them to roll the windows up for that safety precaution as well, because the dog is a patrol dog, which has the potential to apprehend suspects. So for the safety aspect, I had them roll the windows up and stay in the vehicle.
Okay. Did you ask any of the occupants of the vehicle, I guess specifically Ms. Sizemore, for consent to search the vehicle before you ran the drug dog?
No, I did not.
Okay. And I'm assuming that once you got a hit on the vehicle, did you consider that to be probable cause?
Yes, once Deputy Canine Zeno alerted to the vehicle for odor of illegal narcotics, showing that positive alert by sitting down, I know from my training experience that I have probable cause to search the vehicle.
Well, probable cause and exigency, or just probable cause?
I'll need an education on that.
I'll just withdraw that question, Your Honor. That's probably beyond the scope of his training and experience.
Very well, Mr. Sweeney. Please continue.
Okay. So what was your next course of action once you had the drug dog alert on the vehicle? What were you going to do?
So I requested additional units due to the sense that there were 5 people in the vehicle and 2 of us on scene. When more units started showing up, we placed them in a detained status where they were detained for pending search of the vehicle because we had probable cause.
Okay. Now, I specifically want to direct your attention to any conversation that you may have had with the defendant, Ms. Sizemore. When she was ordered out of the vehicle, can you talk to me about any conversation that you may have had with her?
I don't want to say any comments specifically or in quotations due to it being so long ago, but when we have them exit the vehicle, she did have a purse and we asked that the purse stay inside the vehicle. There was weapons in the vehicle prior, and I actually observed them on my initial approach. So for the safety portion, we just had to ask them to leave everything in the vehicle.
Okay. I mean, you've been a law enforcement officer for 7 years. Is it a possibility that drugs could be contained in that purse as well?
Yes, it is a very strong possibility, as well as on the person, which later under Miranda, she had a meth pipe in her bra and she admitted and retrieved herself.
Okay, but this is after the search.
Correct. This is after this.
Okay, and Deputy, I just want to make sure that I have everything correct in the sequencing. At no point before the establishment of probable cause did she ever assert any privacy interest in that purse or anything, did she?
No.
Okay. And I'm assuming it's just like a over the shoulder purse with a long strap, something like that. Like to the extent,
I don't want to put in test. Yeah, it was a purse. I don't want to get into the extent because I don't want to say something incorrect.
that's fair. That's fair. And she had it and was trying to leave with it when you told her to leave it in the vehicle. To the best
Yes,
of your
yes, the best of my ability of recollection. She tried to get out with the purse, but everyone was being detained at that point in time because of probable cause.
Okay. And then I'm assuming the purse was left in the vehicle,
Yes, it was.
and then you searched the vehicle.
Yes.
Your Honor, I think for purposes of what today's hearing is, that kind of covers everything that I really needed to establish.
Mr. Watts, any further questions for the deputy? You'll need to unmute yourself, counsel.
Your Honor, I'm having a moment here. I was listening to the deputy's testimony and I have the video from what's as K White in front of me. I'm trying to find the section in here, and I know I watched it. I watched it with my client where the drug dog is walked by the car. Well, let me ask the questions, Your Honor, and I'll see if I can find it.
Okay, you may continue.
Officer, have you watched the body cam of what is labeled as K White video 1?
I have not. That looks like that'd be Deputy White.
Okay.
Put up on scene.
And Deputy White is at that scene, correct?
Correct.
And at that scene, and I know you can't see this, but I'm sitting here watching the video and I'm counting at least 4 separate officers at that scene. Is that incorrect?
I don't want to give a bad testimony. I can't remember the number of officers on scene. I know that we had plenty of officers show up. You are correct. There were, I think, 4 officers at some point, but I don't want to give you an incorrect answer.
Well, the reason I asked that is, and again, I have watched this with my client sitting here in the office, is that video, K White 1, also includes the dog walking down the car. We noticed it was unusual because the occupants were left in the vehicle, correct?
They were.
And your testimony that the officers were left, the persons were left in the vehicle because there weren't enough officers to assist and keep everybody basically controlled.
Control's a pretty strong word, Mr. Watts, I would say, but I see what you're saying of officer to citizen ratio for safety issues.
The reason I'm kind of hesitating here because I'm trying to skim through this video as I talk to you. I'm trying to find the spot in this video where the dog sniff is actually done to remind myself of when it takes place. Okay, well, Judge, I'm not going to take the court's time to try to review it again. It runs about 10 minutes long, and I don't know that it's all that relevant in the first place. What's important here, the occupants of the vehicle were left in the vehicle as the dog does the sniff. Correct?
Correct.
Okay.
Correct.
That is not the usual practice, is it?
It's situation dependent. There is no case law that says they can be in or out of the vehicle. It's situation dependent. The department.
I'm aware there's no case law. The case law on dogs is that dogs are magic and whatever the dog says goes. But the common practice in nearly every case is to remove the occupants from the vehicle. I can count on one hand the number of times I've seen a dog sniff where the persons are left in the vehicle and have fingers left over.
Again, that is situation dependent.
I don't think I have anything else, Your Honor. Thank you.
All right. Anything further for this witness, Mr. Sweeney?
No, Your Honor.
All right. Deputy Nitcher, you can stay with the meeting or leave it at your choice. If you do stay with
Yes,
the
Your Honor.
meeting,
Thank
I
you.
would ask you to mute yourself.
Yes, Your
Okay.
I know that's it.
Do you have further evidence to present, Mr. Sweeney?
No, Your Honor.
All right. Counsel, I'm aware of defendant's motion and essentially brief in support of the motion to suppress and the state's brief in opposition to the defendant's motion to suppress. I've also had an opportunity to review some of the case law that has been specifically cited by counsel in their various submissions to the court. So at this time, the court would entertain oral argument in respect to your various positions. Mr. Sweeney?
Yes, Your Honor. So, like I said previously to the court, I don't think the facts of this case are largely at issue. And I think it just is an issue of where this case falls in the intersection between all of these cases that involve purses and essentially the exception to the warrant requirement that applies here. So obviously it's not a search incident to arrest. And I think the place where this can be differentiated from Boyd is essentially that we're not dealing with a consent search. So obviously a consent search can be limited as broadly or as narrowly as the suspect wants it to be. That can be absolutely outright revoked. But that's not what we have here. I agree that if there was some statement that was made by Ms. Sizemore to Deputy Nitcher, one of the other officers on scene, prior to the establishment of probable cause, then surely we would have been in violation of the Fourth Amendment. However,
What statement would you expect her to make, Mr. Sweeney? She's a passenger in a car that's been stopped. She's supposed to roll down the window and holler at the officers, "I'd like to assert my Fourth Amendment rights to my purse"?
Well, at some point, presumably, Your Honor, when the officer Nitcher or any of the other officers are kind of detailing and chronicling what the situation is, including the suspended nature of the driver's license, the window would have been down. She could have had the ability to speak up at that point. But I get it. Maybe there's a limited opportunity for her to do that, but in the grand scheme of things, I don't know that it matters once the establishment of probable cause is made. Because once the establishment of probable cause is made, Your Honor, I think that the case law is pretty clear. And I think this is established through Houghton, I'm not sure how to pronounce that, Supreme Court case, and then also Ross, which is cited in my brief. But it's pretty clear that any container that could contain the contents of what the probable cause is for, and in this case it's drugs, and the testimony is pretty clear, and the court, I'm sure, is well aware, could be found inside a purse. Once that establishment is made, those items are left inside the vehicle. Now, Boyd, I would concede, is a bit confusing. And it's kind of talking about purses, and maybe there's some sort of additional privacy protection as it relates to purses. But certainly I think our case can be distinguished from Boyd. Hold on, let's see exactly where put it here. So Boyd, the interaction in Boyd, so that the consent interaction, whether or not that Boyd is going to consent to the search of the vehicle, she objects before the establishment of probable cause. And that's the key, Your Honor. Once we hit that portion where probable cause is established, I think the case law is pretty clear. And then it's also, I think, pretty clear in Grosjean as well, that if you've got probable cause, okay, any conversation about whether or not consent to search the purse or search the vehicle kind of ends right there, because you've already established probable cause. And so I think it's really the conflation here of two warrant exceptions, consent versus probable cause with exigency. Of course, we have the exigency. And I think this is really just a conflation of the two, and try to make the water a little murky, but I think it's pretty clear, given Deputy Nitcher's testimony, and I think what's agreed that the facts are in this case, that there was no objection, no consent. So we're dealing solely with the probable cause exception to the warrant requirement. And if we have that, I think you're in.
All right. Mr. Sweeney, I understand your analysis, but here's what troubles the court. The officer made a discretionary call in this case not to remove the passengers from the vehicle during the drug dog sniff, which is consistent with generally how this is done. I don't know if it's limited to just the number of fingers on Mr. Watt's hand or not, but nevertheless, it does appear to be a rarity that they leave everyone in the car while this drug dog sniff is going on. If he simply removes the passengers from the car, which is commonly done, are you arguing that he would still be able to use this probable cause determination based on the sniff to search the passengers and their purses standing outside the vehicle?
I am not, Your Honor, but I think.
Okay, but so if the officer pins the people in the car and doesn't let them leave it, they have less rights than if they are allowed to leave it. Is that correct?
I would say no, Your Honor. I mean, I think we're speculating as to what her response would have been if he asked for them to step out of the car so he could run the drug dog around the vehicle. I mean, I think
Okay. But let's presuppose that she would have done what she did anyway. She would wanted to take her purse with her. She and her purse would then be outside the vehicle. And are you saying that because the drug dog alerted on what was left in the vehicle, then you could search the passengers who are outside the car at that point and their personal effects, such as their purse?
I do not believe at that point, barring some personal safety exception on the part of the officer, which the officer I think actually testified to today, although that was, I guess, somewhat of a surprise to me. But no, I would say no, barring some sort of safety cursory search outside of the vehicle, to the extent that answers the court's question.
Which begs the question, why would an officer ever let anybody out of the vehicle if they can broaden their ability to search these individuals by just simply making him stay in the car? Does that seem fair, that discretion can be exercised to give law enforcement a greater power to search citizens than they would have if they let him get out?
You know, I mean, I
He
don't
made
know.
the call.
I guess
That's the importance. He made the call, not Miss Sizemore. He didn't give him an option, and she said, "Well, I think I'll just sit in the car." Maybe it's cold outside in January, and she just wanted to sit by the heater. Then it's her call to stay in there. But in this case, the law enforcement officer made the call requiring them to stay in. So anyway, go ahead, Mr. Sweeney, if you had some additional remark.
No, Your Honor, I appreciate the court's allowance, but Your Honor, I think every situation is fact dependent. As Deputy Nitcher testified, certainly there's been instances where, and I think this is also for safety purposes too, sometimes where they're ordered out of the car. So, you know, potentially a suspect can't, and another officer stays with them, so a suspect can't approach them from their back. In this situation, there's a lot of individuals in the car, and maybe more than what you might normally see. So 4 or 5 individuals in a car, they're ordered to stay in. I don't know the ratio of how often that happens, but I mean, I would say it's fact specific. And I don't know that it certainly didn't sound like from the deputy's testimony that subjectively he had any intent to lessen the suspect's privacy interests in any way by doing this. It didn't sound like he had gone through that calculation in his mind. I think if the passenger would have said something to the effect of, "Hey, I have a privacy interest in my purse," and I now understand that's an odd thing to say, but that may have changed the calculus. But that wasn't said, and that didn't happen, and probable cause was established. And then the conversation happens. And I think the case law that we do have tends to say that that's kind of where the conversation ends. And that'd be my argument, Your Honor.
Mr. Watts, do you agree with Mr. Sweeney's analysis?
I do not, Your Honor, and it will surprise no one to say that I view this with much more cynicism than Mr. Sweeney does. It is my suspicion that the officer does it with the dog, with the people in the car precisely so that he can search everything in the car, including what they have on them. These searches and the way these searches are conducted do not happen in a vacuum. And despite what Deputy Nitcher says, this wasn't about officer safety. This is about making sure we can search everything. And I say that because I just found it at 11:04 on Officer White's video. The first video is the officer walking down the driver's side of the car. There are at least 4 officers present there, counting the 3 I can see on camera, plus the one who has the camera on his chest, the one carrying the camera. Obviously, I can't see him. So despite the officer's assertion, there are plenty of officers there to keep track of everyone. But for whatever reason, they decide to keep people in the car. My suspicion, and again, I'm a cynic, is that law enforcement has figured out that if they leave people in the car, they get a broader search. In fact, the Boyd court itself foresaw that coming. And I'll note in my brief on page, where is it? On page 5 of my brief, page 283, the Boyd court notes that in order to get around the rule, the Boyd court could simply order passengers to remain in the car and thus make their persons subject to search. It's rather prescient that the Boyd court foresaw this very thing happening. Interestingly enough, and the very next sentence of the motion as I look at it, if this was a man's wallet, we wouldn't be having this conversation. And that serves essentially the same purpose as a woman's purse. My wallet, as I'm sure your honors, my life is in here. Your driver's licenses, your credit cards, everything that you have, your personal stuff. This is how, for most males, we carry it around. These days, we add to that our cell phone. For most men, though, our lives are in those 2 items we can stick in our pocket. For most women, for whatever reasons, and I was discussing this with Stephanie, in large part, I suspect because women's clothing simply doesn't have a lot of pockets. Women carries in a purse. The purse is this for a woman. And the Boyd court recognizes that. This court does not decide this case on the basis of whether probable cause has existed or where some fine line probable cause had existed. It decided this case on the basis of the inherent privacy of our personal items, whether it be our wallet or our purse, or I suspect these days, our cell phone. This is different from just the vehicle. And as I said, I'm a cynic. I suspect this dog sniff is done exactly for that purpose, and so you can make sure you can search everything in the car. The state cites Groshong. The problem with Groshong, of course, and why Groshong is, I think, well, you've got my motion. Groshong, I think, is easily distinguished from this one on its facts. This is a very different case than Groshong. In Groshong, the woman had gotten out of the car, left the purse, probable cause was later established. And then after everybody knew we're going to search the car, she says, oh, wait, I want to go back and get my purse. That's not what happened here at all. At the very first indication, my client attempts to take her purse out of the car. And there's really no dispute that that's the case. She doesn't leave it behind. She doesn't know. I don't know whether she knows probable cause exists at that point or not. She's told that everybody has to get out of the car, and she's told to leave her purse there. The one thing that struck me as I listened to Mr. Sweeney is, again, and I won't get the quote right, the line from Justice Beyer years ago. The courts and the public and the police expect way too much chutzpah from the citizens to try to understand these fine lines and assert their rights. The courts have a habit of drawing these fine lines and asserting that if something happens on this side of a line, it's one way, and it happens on this side of a line, it's another way. And we draw our cases based on those fine lines. Public doesn't understand those fine lines. They don't understand, nor should they be expected to understand the intricacies of probable cause, when and where probable cause might exist, and what the limits of that probable cause are. We don't even agree on them after research and briefing. How do we expect the public to understand those rules? They can't. And to be perfectly blunt, law enforcement relies on the public not understanding those rules, and they take advantage of it, which is why we walk the dog down the car with the people still in it. So, Judge, I think that the distinction whether the probable cause had existed or not is a false distinction. The distinction here is very simple. That purse is her very private personal property, much like your wallet, Your Honor. And the case law, Boyd, says that she asked to take it out, and she asked to take it out at the first instance. You don't get to search it. And that's what she did here. And setting that line on where, to be perfectly blunt, law enforcement decides to place the probable cause distinction is asking way too much of the citizen in dealing with law enforcement. I think this should be suppressed.
Very well. Thank you, Mr. Watts. Court is going to refer some specific excerpts from State versus Boyd and State versus Groshong in making its decision here this morning. I appreciate the conciseness and clarity of both arguments in the case. I understand each of your two positions quite well. First of all, from State versus Boyd, page 282. There is no question the purse was Boyd's personal property, in her possession and under her control. She attempted to take it with her, but was directed to leave it in the van. Under these circumstances, her purse was entitled to the same increased protection from search and seizure as afforded to her person. The search of Boyd's purse violated her Fourth Amendment right to be secure in her person and effects from unreasonable search and seizure. Further, as Mr. Watts referred to earlier, the specific quote from page 283. If we hold an officer can lawfully order a passenger to leave her purse in the car and thereby making it subject to search, then what prevents the officer from ordering the passenger to remain in the car, thus subjecting her to be subsequently searched along with the car? The protection of the Fourth Amendment cannot be defined at the discretion of the law enforcement officer. The heightened privacy interest and expectation in the present case is sufficient to tip the balance from governmental interest in effective law enforcement, which outweighed the privacy interest in Houghton when the purse was voluntarily left in the back seat unclaimed. We hold that where a passenger is told by a police officer to get out of a lawfully stopped vehicle, and in response to the officer's order to leave her purse in the vehicle, puts the purse down and exits the vehicle, a subsequent search of the purse as part of a search of the vehicle violates the passenger's Fourth Amendment right against unreasonable search and seizure. The motion to suppress should have been granted. In considering the probable cause argument made by the state, the court understands it. The court would refer to State versus Groshong and a specific quote made by the Kansas Supreme Court in that case. It analyzed case law from the Florida and Idaho court systems. And they state, the Florida and Idaho courts have heeded Justice Breyer's warning to avoid subjecting a passenger's purse to a search during the lawful search of a vehicle. A passenger in Florida and Idaho must immediately assert a privacy interest in the purse by taking it upon exiting the vehicle. Quoting Hawley from Florida and Holland from Idaho. The next line from our court is, we agree with the Florida and Idaho courts. In other words, they agree that even during a lawful search of the vehicle, if the passenger takes their purse with them and therefore immediately asserts a privacy interest in that purse by immediately taking it upon exiting, then they have a right that cannot be violated by requiring them to leave that behind. That's what happened in this case. This court holds that when the passenger, Ms. Sizemore, was told by the officer to get out of a lawfully stopped vehicle, and in response to the officer's order, to leave her purse in the vehicle. She puts the purse down and exits the vehicle. The subsequent search of the purse as part of the search of the vehicle violated Ms. Sizemore's Fourth Amendment right against unreasonable search and seizure. The motion to suppress, therefore, is granted by this court. Now, Mr. Watts, Mr. Sweeney, it's the court's understanding that the pending charges in this case are possession of methamphetamine ostensibly found in the purse and possession of paraphernalia for use ostensibly also found in the purse, or stemmed from what was found in the purse. Correct?
I think in both cases, Your Honor, those items are found in that purse.
Do you agree, Mr. Sweeney?
I do, Your Honor.
That evidence has been suppressed. It would appear appropriate for this court to dismiss the criminal case against this defendant. And the court makes that order. Ms. Sizemore, do you understand what happened here today?
Yes, I do, sir.
All right. Due to what the court ruled in your favor, the evidence against you has been suppressed. In other words, it can't be used by the state. That's what we call the
They can't bring it
exclusionary
back
rule.
up, right?
Excuse me?
It's not like a walk charge where they can bring it back up, correct?
Oh, they can't refile the same case on the
Okay.
same facts. No.
I've never been in trouble, so that's why I was wondering.
Okay. So my next statement is this essentially concludes the prosecution against you in this case. The state does have a right to appeal, which may lengthen the pendency of this case. But nevertheless, at this point, there is no more active prosecution against you pending in the court at this time. Therefore, you have no further court appearance requirements in this action at this time.
Okay,
Okay? With that said, I hope, Ms. Sizemore, that this has been a horrible experience for you, that you've really come to grips with the fact that methamphetamine was found near your person. Methamphetamine is an incredibly dangerous drug, and there's nothing positive about it. There's nothing positive about methamphetamine culture. While you're no longer subject to the orders of this court, at least at this pending time, I hope that you have completely separated yourself from methamphetamine and anybody who would expose you to it. Your life will be a lot better without it. Good luck to you, Ms. Sizemore.
thank you.
All right, make sure you thank your attorney for a job well done as well. All right. Gentlemen, attorneys, is there anything else the court needs to address on the record here?
No, Your Honor, not that I'm
No,
aware of.
sir.
Now, Mr. Vedder, you are ordered to pay $30 a month in child support. And as of today's date, you have an arrearage in excess of $10,970. I'm sorry, Mr. Anderson, is he really only ordered to pay $30 a month?
Yes, ma'am.
All right, good morning. This is in the matter of Penny Jane Riem versus John Edward Vedder Jr., file number 2007-31231 DP. This is Mr. Vedder. Looks like there was a bench warrant for failure to pay child support and for failure to appear. So it looks like you were ordered to appear in this court on April 3rd of 2023, and you failed to appear. So a bench warrant was issued for failure to appear. Now, Mr. Vedder, you are ordered to pay $30 a month in child support. And as of today's date, you have an arrearage in excess of $10,970. I'm sorry, Mr. Anderson, is he really only ordered to pay $30 a month?
Some of that, Your Honor, there's there were at one point in time 3 children on the file. One of them was dropped when my mom and dad adopting, and the amount actually reflects over $100 a week I was ordered to pay in Oakland County before my other case.
So
was transferred
hold on
to-
a second, Mr. Vetter. I asked Mr. Anderson if the monthly charge was $30. Is that correct, Mr. Anderson?
Yes, that's correct.
Okay, so Mr. Vetter, there is a $30 a month charge and there is an arrearage. And we've not had a payment since 2021. So, Mr. Vetter, do you understand that's why you're here today?
Yeah, what I don't understand, Your Honor, is I have not received any correspondence from friend of the court at either my brother's house or my house, nor has my boss, who I've worked for 8 years and I pay taxes. He does, I've had, my child support was being taken from him in prior years. And he's heard nothing from them in 2 years, nor have I.
So, Mr. Vetter, before we get into a debate on whose responsibility it is to collect child support, my next question will be, do you understand that you have 2 prior contempts? So if you were to be found guilty of contempt of court for failure to pay child support and failure to appear, your maximum penalty, it could be up to 90 days in jail. Do you understand that?
Yes, Your Honor.
Now, Mr. Vetter, you do have a right to have an attorney represent you here today and all subsequent hearings. If you can't afford to hire one, we can appoint you one at public expense. Would you like an attorney appointed to represent you? Yes or no?
It's kind of a catch-22, Your Honor. I mean, I would, because I don't know the legal jargon, but I don't want to waste the court's time and I don't want to waste.
Mr. Vetter, this is my job and I'm here all day long. So you are not wasting my time because I signed up for this. So if you would like an attorney, just let me know and I will give you an attorney who can give you legal advice and guidance. Would you like an attorney?
No, Your Honor, I just want to go to work.
All right, well, Mr. Vetter, do you understand that it's a crime to fail to pay child support to the very best of your ability up to the amount ordered?
Yes, Your Honor, like I said.
Do you understand that it's a crime to fail to appear here in court when you're ordered to appear?
Yes, Your Honor, I never received a notice though.
Well, we're gonna get to that in a minute, Mr. Vetter. So, want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Now, Mr. Vetter, do you understand that you're entitled to have a trial and you cannot be convicted unless the evidence at your trial proves that you're guilty beyond a reasonable doubt? Do you understand that?
Yes.
Do you understand that you are entitled to have an attorney represent you here today in all subsequent proceedings? Do you understand that?
Yes.
If you want an attorney and you do not have the money to pay for one, you should tell me right now, and I will appoint you one at public expense. Do you understand that?
Yes, Your Honor, I just want.
Do you want an attorney?
No.
All right, so Mr. Vetter, do you understand if you were to have a trial, you would be entitled to have all the witnesses against you appear at your trial, and you would have the right to question those witnesses while they're under oath. Do you understand that?
Yes, Your Honor.
You're also entitled to have me order any witnesses you might have to appear at your trial on your behalf. Do you understand that?
Yes, Your Honor.
You do not have to say anything at your trial, and if you do not testify or say anything, nothing will be held against you, and in fact, no one will even mention your silence. Do you understand that?
Yes, Your Honor.
On the other hand, do you understand that you are entitled to testify at your trial if you want to testify?
Yes, ma'am.
So, Mr. Vetter, how do you plead to the charge that you have failed to pay child support to the very best of your ability up to the amount ordered each and every month? Your answer would be guilty or not guilty.
I mean, I haven't been paying it.
Okay, so would that be a guilty or not guilty?
Yes, Your Honor.
No, you gotta say guilty or not guilty.
I'm sorry, Your Honor. I'm really frustrated. Yeah, I'm guilty.
Did you? What did he say, Cindy?
She said, I'm frustrated, I'm guilty.
Okay, guilty. All right, and how do you plead to the charge that you failed to appear in court as ordered on April, well, let me see here, I'm gonna go back. April 3rd of 2023. Guilty or not guilty?
Guilty, but I didn't.
Okay, so hold on, Mr. Vetter, we'll get there. All right, so Mr. Vetter, you are ordered to pay $30 a month in child support, is that correct?
Yes, sir. Yes, ma'am.
Okay, so Mr. Vetter, when's the last time you got a paycheck?
Today?
Okay, and Mr. Vetter, was the child support taken out of your check?
No, ma'am.
So did you make the payment online or come in and make the payment?
No, I can come in and make a payment as soon as I'm done, as soon as I get out of here.
Mr. Vetter, you've owed
put my whole
$30 a month
paycheck
in
on it.
child support and you haven't paid child support since 2021. If it doesn't come out of your check, it doesn't mean you don't owe it. So during the
It's
last
always-
2 years, have you come in and made the $30 a month payment because it wasn't coming out of your check?
No, but I haven't received any correspondence from friend of the court either. Nothing.
So did you
No,
know
no,
you were supposed to pay $30 a month?
I thought that maybe Penny had fucking, pardon my language, I'm sorry.
It's
I
okay.
honestly thought that Penny might have signed off on it. Because I thought she might have signed off on it because I know she got married. And then I don't know if they got divorced or not or what happened.
Mr. Vetter, hold on a second. So, Mr. Anderson, is some of this money owed to the state of Michigan?
Some of it, yes.
So, Mr. Vetter, so she can't sign off on the money that's owed to the state of Michigan. And she can't sign off you as a parent, even though she got married. Do you understand that?
Yes, ma'am.
Because you do have rights. People can't just terminate your parental rights without a hearing.
My daughter,
Hold on, Mr. Vetter, hold on. So where are you working?
JAK Concrete in Toledo. I've been there for 8 years.
All right,
Yeah,
at
in
one
the
time,
private
we had, okay. At one time, there was an income withholding coming out of there, correct?
For 6 years there was.
Okay, Mr. Anderson, the last payment we have was October 18th of 21. Was that an income withholding?
It appears it was, yes. I'm not sure what
So-
happened there.
Do we still have that employer listed?
We have the employer listed, it's just not active right now.
Why not?
I don't know. It was something that happened a couple years ago.
Okay, all right, so can we now activate that?
Yes, absolutely.
All right, so Mr. Vetter, what I'm gonna do is because you have a big rearage, I'm gonna need you to pay $80 a month. Can you do that?
I'll pay whatever it takes.
Okay, so Mr. Vetter, we're gonna do an income withholding and send it again for $80 a month. That's $20 a week. So Mr. Vetter, when you get your paycheck, if they didn't take it out, I need you to make that payment online or come in and pay it, okay?
Mhm.
Now,
Yes,
Mr.
ma'am.
Vetter, you do have a suppressed address. And what that means, at some time it was indicated that for your protection, your address needed to be suppressed. So I don't want you to put on the record what your address is, but I'm gonna put you in a breakout room with Mr. Anderson. And Mr. Anderson is going to get your correct address from you, okay?
Yes, ma'am.
Okay, and so then what I'm going to do is accept the guilty plea to failure to pay. And then I'm going to set this out for sentencing, I don't know, July, August, September. I'm gonna set this out for sentencing on September 11 at 8 AM, okay? And I'm gonna release you from the jail today.
Thank you.
All right, so can you remember 9/11? It's a pretty important day, right? Your paperwork from the jail, when you get released, will say the date that you need to do this. You can appear via Zoom. If you're making the $80 payment by the 1st of July, the 1st of August, and the 1st of September, Mr. Anderson will dismiss this.
I will be over, I'll be over, and as soon as I'm out of here, I will walk over and make a payment today. Like I said, Your Honor.
Okay,
Everything's always just been automated, so I just,
all right,
I
but
screwed the
Mr.
pooch.
Mr. Better, you knew the payments weren't coming out. So that was your responsibility to contact us and find out what was going on, okay?
Yes,
So you're gonna get released on a PR bond. I need you to pay $80 a month in July, August, and September by the first Friday of the month. If you do that, Mr. Anderson will dismiss that. If you don't, you're gonna have to appear either in person or via Zoom. Do you understand?
yes, ma'am.
Do you have any questions, Mr. Vetter?
No, ma'am.
All right, so set sentencing for 9/11 at 8. And then I'm gonna put you in a breakout room with Mr. Anderson so you can give him your valid address, okay?
Yep.
All right, do you have any
Yes, ma'am.
questions, Mr. Vetter?
No, ma'am.
And by the way, I think you pay attention to my car because it's a BMW. Period. You saw a BMW and you said, oh my
Yeah.
God.
If you're in Saugatuck, Douglas, a BMW would be par for the course, ma'am. All right, gentlemen. This is a citation that was issued on May 12th of this year, 115th there, Valley Township. It's for riding an ORV without a helmet. You are here, Mr. Chrisman, on this citation to do one of three things. First is you could admit responsibility to the citation. 2, admit responsibility, but you'd like to provide some sort of explanation to the court as to how or why this happened. Or 3, you wish to contest this citation. In other words, fight the ticket at what we call informal hearing. What were you looking to do?
Number 3.
All right, then what I'm going to do is have you both swear in. You can raise your right hands. Swear or affirm any testimony you give here today would be the truth, the whole truth, and nothing but the truth.
Yes. Yes.
All right. Mr. Chrisman, it makes a lot more sense for me to start with the officer. He has the burden to establish to me why he issued a citation in the first place. But after that, you'll have an opportunity to either ask questions or testify on your own behalf. All right?
Okay, thank you.
And officer, then if you want to pick up the narrative somewhere where it makes sense, explain the issuing of this citation.
Yes, I was patrolling on my marked ORV down 115th Avenue for ORV stuff.
I had to actually look up the definition of an ORV because we don't use that terminology in Florida. We just say ATV, sometimes UTV. But in Michigan, they call them ORV, off-road recreational vehicle. And the legislature actually defines it as a vehicle that is motor driven and off-road used for recreational purposes. You can use it over land, ice, snow, marsh, swampland, or any other natural terrain. A multi-track vehicle or multi-wheel vehicle or motorcycle or related two-wheel vehicle or a vehicle with 3 or more wheels. It can be an amphibious vehicle, a ground effect air cushion vehicle, or other means of transportation. It can be an ORV. The vehicle does not include registered snowmobiles, farm vehicles being used for farming, but if you use them for recreation, then it could be an ORV. A vehicle used for military, fire, emergency, or other law enforcement purposes, or a vehicle owned and operated by a utility, gas, or oil company when performing official duties. So now you know.
And I saw an ORV coming at me. I could see there was occupants on it without helmets. So I conducted a stop with my ORV. It's got red and blue lights on it. Upon conducting that stop, the ORV is meant for one occupant. It's only manufactured for one occupant. And I noticed there were 2 occupants on it. Neither of them were wearing helmets. And then I also discovered the ORV was not licensed per the requirements to operate on the Allegan County roads. Further, I found the VIN number on the ORV, ran that. It returned stolen out of Kalamazoo County. And in talking with Mr. Chrisman, my personal belief, I don't think he knew that it was stolen. He purchased it a while back, so I wasn't going to pursue any of those charges or anything. So I just had the ORV turned over to the rightful owners that it was originally stolen from back in, I believe it was 2019, and released Mr. Chrisman with a single citation for operating an ORV without a helmet.
All right, Mr. Chrisman, what is it you'd like to say?
I thought it was a no helmet state, and I was on a seasonal road, and we were mushroom hunting. We weren't even going that fast.
The no helmet state is for motorcycles, and you have to pay for that privilege. It goes into a fund for when people on motorcycles without helmets wreck, but it doesn't apply to ORVs. Gotta wear a helmet.
I understand that, but I don't see who I was hurting but myself, you know.
Well, that's not really the point, though. If you got hurt and went into a coma, it's all of us that has to foot that bill, right?
No, I would have to flip it.
No, you wouldn't, sir. Your insurance would run out. That's the whole point of the helmet law that went back and forth with motorcycles. One catastrophic accident and you're on the hook for millions and millions of dollars in care. Your insurance stops covering that. You become a taxpayer ward. So that's why they made the law saying if you really want the freedom to not wear a helmet, that's fine. Pay the state the money to have the permit to not use a helmet.
All right. I was already out $1,000. Just paid $1,000 for the quad. He takes the quad and then issues me a ticket for $200. No, I'm
the quad was stolen.
Go for it.
And he didn't issue you a ticket for having too many people on it or for you not bothering to license it. He gave you breaks on both of those. So I would find you responsible on this citation. He would have a right within 7 days of today's date in writing to ask for a formal hearing in front of the district court with the prosecutor's office. But short of that, you would need to make arrangements to pay those fines and costs. Do you understand your rights on appeal?
All right. Who do I write the letter to?
District court.
District court. All right. All right. Thank you.
All right, so we're here for a citation that was written on May 26th of this year on Center Street there in the city of Douglas, Allen County, state of Michigan. This is a speeding violation on an actual, looks like 40 and a 25. You are here, Ms. Rivero, on this speeding citation for 11 to 15 over to do one of three things. First is you could admit responsibility to the citation, or two, admit responsibility, but you'd like to provide some sort of explanation as to how or why this happened, or three, you wish to contest this citation. In other words, fight the ticket at what we call informal hearing. What were you looking to do?
Fight the speed limit that it was cited, meaning.
All right. Then I would ask that you would go ahead and raise your right hand, same way the officer is going to raise his right hand. You swear or affirm any testimony you give here today would be the truth, the whole truth, and nothing but the truth.
Yeah.
I do.
All right. Ms. Rivero Vasquez, it makes a lot more sense for me to start with the officer. He has the burden to establish to me why he issued you the citation in the first place. After that, you'll have an opportunity to either ask questions or testify in your own behalf, all right? And with that, officer, you want to pick up the narrative somewhere where it makes sense, explain the issuing of this citation?
Yes, sir. I, Officer Brown, was on duty for the city of Douglas on 5/26/23 and around 8 p.m. I'm a Michigan radar certified operator. While I was sitting on Center Street near the intersection of Center and Ferry, I was operating my forward and rear radar. I had a target coming towards me, a suspect vehicle, heading westbound on Center Street, coming towards Ferry as I sat in the intersection. I activated my radar. The vehicle was approaching me, driving 40 miles an hour. I checked that speed of the target 2 more times. It continued at me at 40 miles an hour. And it continued on past me, turning north onto Ferry Street At that intersection, disregarding the stop sign, I initiated the traffic stop for that. I made contact with the driver near the north driveway to the Woosah Coffee Shop at that time for those 2 violations. Made contact with the driver. There were 2 occupants of the vehicle, the female driver and a female passenger. She advised she didn't know what the speed was and that she did stop at the stop sign. I went back to my vehicle and cited her for the 40 and a 25 and the disregard of stop sign. Returned to the vehicle and issued the citations, giving her the citation and an envelope explaining how to contact the court. And the envelope also had the schedule of the fees on the envelope. And I went back to patrol after that.
Okay. And then, ma'am, what is it you wish to tell me?
Precisely because there was a stop sign. I know for a fact that I was not going at 40. Because even though I accepted the fact that I didn't stop, I slowed down. I didn't see any cars. I paid the fine for the stop sign because did I stop? No, I slowed down, I rolled over to the right. But it was impossible for me to go at 40 because there was a stop sign. And yes.
You do not have a speeding ticket at the stop sign. The speeding happened considerably before the stop sign.
Correct. And I wasn't precisely. I did not go at 40. Maybe I know that I didn't. I'm not saying that I was going at 25. I admit that. But I was not going at 40. And I'm very
How fast were you going?
30, 35. Max. Max. Precisely because there was a stop sign. Because I knew, and it's not a fast, this is not a highway. This is not a highway. It's impossible to go that fast.
Officer, was this toned out as well?
I'm sorry, there was a little bit of a break in the audio.
Did your radar tone out as well?
It did. It had high audible tones, and she was the only target in the operational radar beam at the time.
And visually, did you think that that car was going faster than 25?
I did. It was coming at me rear radar, and I could see it in both my side rearview mirror and my center rearview mirror.
See, here's the problem, ma'am, just so you may not understand all the things he's saying. The first thing he's saying is that visually he's observed your vehicle and thinks you're speeding. We don't let him tell us how fast you were going because human brain can be wrong, but traffic officers are usually pretty good at assessing speed. What he's really saying is that his radar did 2 things. One is gave him a steady 40, in other words, more than one reading at 40 miles an hour, that you were the only vehicle in the target. And then that radar also tones out a pitch, and that pitch, they're trained to recognize whether or not that's consistent with the number. If the pitch is different than the number, they know something's wrong. Officer Brown, I'm assuming you checked this radar before and after shift?
My radar was verified before and after my shift, yes, sir.
How do you verify your radar?
With the auto test and then against my speedometer.
Your speedometer is calibrated separately?
The speedometer is calibrated, yes.
And if you had had an issue or your radar did not self-test properly at the beginning of your shift, what would you have done with speeding citations?
I would have to void them all, and I would have to take my radar out of service.
And what if you wrote tickets all day and then it didn't pass muster at the end of your shift?
All of those tickets would have had to have been voided.
So, ma'am, based upon the evidence that I have in front of me, I would find you responsible for this speeding citation as it's written. Because you had a contested hearing, you do have a right to say, I don't agree with what just happened in there. You would have a right to take this to what we call formal hearing in front of the district court judges with the prosecutor's office. But to do that, you must ask for that within 7 days of today's date, and you must ask for that formal hearing in writing. Otherwise, the window of opportunity closes and you would accept my finding of responsibility. If you accept that finding of responsibility, you would just need to contact the court to make arrangements to pay the fines and costs. You understand?
Mm-hmm.
All right. And we are all set. I'm going to go ahead and release parties. Thank you.
So I don't even know how much I'm supposed to pay. And by the way, I think you pay attention to my car because it's a BMW. Period. You saw a BMW And you said, oh my
Yeah.
God.
If you're in Saugatuck, Douglas, a BMW would be par for the course, ma'am. It's an expensive tourist town with lots of nice cars. $120, ma'am, is your
Thank
fines
you.
and costs.
Have a nice day.
Mhm.
It's all.
Yep, you're all set.
Bye.
Gonna release you, officer. Thank you.
This is for the sentencing hearing and Mr. Lockhart's motion. So let's bring out the defendant, please. I would also remind everyone that the district attorney has talked with the victim and the victim's family, and that they have requested that this matter be live streamed on the YouTube channel that we maintain. And we're doing that with the agreement that there will be no mention of the child's full name, and that the victims will be identified by the initials LU. Anyone who refers to the child needs to refer to the child in that fashion. The child will not be shown on camera if she chooses to give any sort of statement. So, all right, this is the sentencing hearing, so let's proceed, Mr. Brooks.
Your Honor, by agreement of both counsel, we will agree to waive any authentication of the pre-sentence report and have that entered as Exhibit 1.
Right. I have a copy here in the file that was filed. Do you want to use that as your exhibit?
That's fine, Your Honor.
All right, we will mark this as exhibit 1 to this hearing. And you may call your next witness.
Your Honor, I'll first be calling our victim, LU. She will read a statement, and then I will have a couple of follow-up questions for her.
All right, we need to stop the camera on this one.
And if all other witnesses are going to testify, if y'all could please step out of the courtroom.
The rule has been called for, so all witnesses who are going to testify must go outside of the courtroom and remain outside of the courtroom until you're called to testify yourself. You're not to discuss the testimony of any other person until you yourself have testified. Counsel are under a continuing duty to ensure that the rule is complied with. This, if you will raise your right hand and be placed under oath. Is this a victim statement or actual testimony?
There will be a couple of questions.
Thank you. Raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Thank you, ma'am. Just have a seat right there. I ask you to speak directly, pull that microphone base towards you so that you're close enough to be able to, we can hear you clearly, okay? Mr. Brooks?
Can you please state your initials?
LU.
Okay. And are you the same LU that testified previously at trial in this matter?
Yes, sir.
Okay. Miss Yu. Do you have an uncle?
Yes, sir.
Who is your uncle?
Ricky Yule.
Okay. And you stay in contact with Mr. Yule?
No, sir.
Okay. Are you Facebook friends with Mr. Yule?
No, sir.
Okay. Have you ever sent any messages via Facebook Messenger to Ricky Yule?
No, sir.
Okay. Have you ever sent any messages to Ricky Yule admitting to lying on the stand?
No, sir.
Your Honor, I thought I'd move to strike that motion.
You haven't, you just asked for it to be continued in order to allow you to investigate the basis of that motion, and we did that.
I'd move to strike the motion. I do not intend
motion. Is there another relevance to this proceeding?
It is to the new crime that's alleged, Your Honor.
Well, I'm going to object to evidence of a new crime. Sentencing factors refer to prior or previous criminal history, not to subsequent criminal history.
Your Honor, it does not specify whether it's prior to the act or prior to sentencing, so I would argue that it is extremely relevant for a consideration for the court to make in its sentencing. It's very common for the prosecution to admit evidence of jail assaults or anything, any criminal offense that happens in jail. It's a common occurrence to admit proof of that in sentencing when asking for an enhanced sentence.
Let me have a moment to look at the statute. Are you proceeding under the enhancement factors, Mr. Brooks? Is that what you're introducing this evidence as?
Yes, Your Honor.
And are you proposing that this is under which of those enhancement factors are you proposing to introduce this?
I'm proposing to introduce this, but the sentencing factor that I originally filed with the court was factor 1, the defendant has previous history of criminal behavior in addition to those necessary to establish the appropriate range. And the state would argue that this is behavior, so it's not necessary that we have a conviction and that this is prior to sentencing, which would be appropriate under that factor.
Well, this is a fairly significant issue. It is brought about because of the defense filing a motion for extraordinary relief from bond, alleging that there was a communication on Facebook between this victim and an uncle or a brother to the defendant that purported to allege that she had lied under oath in the trial. And we had a hearing. The prior date for the sentencing hearing was some time ago, and it was reset for today because Mr. Lockhart, who had filed the motion, was later advised perhaps that was not accurate, and to his credit, wanted to investigate it, and today has moved to strike it. So what I want to do is to ensure that whether or not this is admissible under that rule, I'm going to take a short recess and try to do a little bit of research. If anybody has a case law that you want to propose, then we'll be in recess for a few minutes. So let me look at the relevant statute and the relevant case law, and then we'll come back to it. So we'll stand in recess.
All rise.
All right. I have done some research on my own, trying to determine exactly what the law is on this point. And I've found information that I'm going to share with you that, in my opinion, is relevant to these questions. Number one, the court has granted, or this court will be granted, significant discretion in setting a punishment or sentence in this case. Our Supreme Court has made it very clear, along with our other Court of Appeals, Court of Criminal Appeals decisions, that trial court can consider a lot of different factors. One of the cases that I'm referring to and relying upon is the State versus Winfield, which is a 23 Southwest 3rd 279, a 2000 decision of our Tennessee Supreme Court. In that case, the objection was to the court considering facts of a charge for which a person had been tried and acquitted. And the Supreme Court said that they did not find that the 6th and 14th Amendments prohibited the sentencing court from considering prior criminal behavior for which there's been no conviction. And it goes on to state that we believe by allowing the sentencing court to consider facts underlying a charge for which there has been an acquittal is also consistent with the overall statutory scheme under the Criminal Sentencing Reform Act of 1989. Goes on to state that with regard to enhancement factors, we've observed the statute requires only that they be appropriate for the offense and not themselves essential elements of the offense. The act does not preclude consideration of facts proven by a preponderance of the evidence, even when the facts are the basis for a charge for which there's been an acquittal. Accordingly, we hold a sentencing court may apply an enhancement factor based upon facts underlying offense for which the defendant has been acquitted so long as the facts have been established in the record by a preponderance of the evidence. That's State versus Winfield. That's been upheld or followed in a recent case, State versus Howard. It's an unreported case from the Court of Criminal Appeals in 2017, which basically goes on to say that Winfield decision does not prohibit, the act does not prohibit or preclude consideration of facts proven by preponderance of the evidence, even when the facts are the basis for a charge for which there's been an acquittal. Clearly, an uncharged, and then there's multiple cases where the court has upheld the sentencing consideration, or the court considering it sentencing, the acts proven that were uncharged criminal offenses. So the really only question becomes whether or not this bringing in this information because of the fact, does it constitute prior criminal behavior? Until I hear that evidence, I can't make that determination. So I'm going to overrule Mr. Lockhart's objection, allow the evidence to come in. I will then consider whether or not this evidence is or is not, or it does or does not fit the category of prior criminal behavior enhancement number 1 under the statute. But until I hear that evidence, I can't make that determination. So Mr. Lockhart, your objection is overruled. I will decide whether or not it fits that at the sentencing, according to the sentencing guidelines, and I'll either apply it or not apply it, depending on how I find. So,
And I assume we'll be able to be heard at that time.
I'm sorry?
I
Yes, you will
assume we'll be able to be heard at that time.
Yes, I'm not precluding you from arguing. I'm just simply saying, I know what the evidence is at this point, the state is trying to present. Number 1, I haven't heard anything that actually determines that it was criminal behavior by your client.
Yes,
so
Your Honor.
This is going to have to be proven by the state so that I may determine whether or not he is engaged in that conduct or some other person has. And if some other person engaged in it, then it would not be attributable to your client. So I've got to hear the evidence, make the determination then of whether it fits in, but I'm not precluding you from being able to hear. All right, Mr. Brooks, if you want to call Ms. LU back to the stand.
Ms. Yu, if you flip to the what appears to be messages on that behind that motion, if you look in the lower right-hand corner, they're labeled 2 out of 8 all the way to 5. Do you see those numbers? That's at the bottom right. Okay. Now, referring to page 2, do you see that?
Let me.
Yes. Do you recognize that message?
No, sir.
Did you ever send that message?
No, sir.
Okay. If you can turn to the next message. And what is the number in the lower right hand corner? 4. Is that a message or is that a post?
I think it's a post.
Okay. If you can
But no, it's a message.
it's a message. Okay. Did you send that message to anybody?
No, sir.
Okay. If you can flip to the last message. What is that message numbered?
5.
5. All right. And did you send that message?
No, sir.
Okay. Your Honor, I would ask that that be made an exhibit. It is a certified copy of Mr. Lockhart's motion that he has already filed with the court.
All right, mark it as exhibit 1 for this hearing. 2, I'm sorry, yes.
Your Honor, would it be appropriate, I'm through my questioning, the witness would like to read a statement, would it be appropriate to allow Mr. Lockhart to have an opportunity to
Allow Mr.
cross-examine?
Lockhart cross-examination if he chooses, and then we'll allow her to read her victim impact statement.
Of course.
No questions.
All right, then we're ready for her to go ahead and make her victim impact statement.
Ms. Hsu, did you write out a statement for the court?
For him?
Yes, correct.
Yes, sir.
All right, would you like to read it?
Yes, sir.
All right, you have the floor.
Do I have to stand up?
You don't have to stand.
Okay. Jimmy, the things you've done, they hurt me every time I remember something. You've really traumatized me. I don't trust other people. I'm scared, and that's because of you. You tried breaking in my window. You killed my cat. You stayed in my papa's back 40s. in the old car. You hurt Wyatt. How could you? You were supposed to love us and be there for us and not hurt us. You can't be a father or dad if you can beat and molest your kids. You can't tell us that you love us because you don't. If you did, you wouldn't have done the things you've done, and there's no going back. But just because you're going to prison, don't give up. There's still good out there for you. When you get out, you just need to get the help you need and be a better person. And if you do become a better person for yourself, I don't want you running and trying to talk to me just because you want to, or you feel sorry because you don't need to. I don't, and I never will need you in my life. I'm better off without you, and you're better off without me. I'll forgive you someday, but when I do, I still won't talk to you. You've never known anything about me other than I was obsessed with horses. You don't have the right to get to know me. I don't want you to know me. Ever, whatsoever. I wouldn't have or know what to say to you. You gotta do better. Please do better and find yourself while you've got the chance to and time to. I'm sorry it had to go like this. I did give you a really good plea though. You could have took that, but you chose to do it the harder way. I'm only sorry because you got to spend some time, but you do the crime, you do the time, and you did a crime. I hope that you take this time and think about everything you've done, and if you feel it's a mistake, learn something from it, stop doing it, please. You still have people waiting for you when you get out, like Nana and Ricky. I don't know if I'm happy or sad about this. You're going away. You're going far away, locked up. Good, you'll be far away, so I won't have to worry. I want to come one time and see you, so I fully know that you can't hurt me or anyone else anymore. It's time for me to say goodbye now because I think I've said everything I needed. Goodbye.
Is that all? Thank you so much, Miss Yu. Or Miss you return.
You may step down. Thank you. Mr. Brooks, you may call your next witness.
State would call Brittany Lovelace with Mental Health Cooperative. She should be out in the hall.
Please, ma'am. I'm going to ask you to raise your right hand and let's place you on the oath.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God? I do.
Just as a reminder, since it's been a long time, we are referring to the victim by her initials, LU.
Yes, sir.
All right. Can you please state your name for the record?
Brittany Lovelace,
And where are you employed?
Mental Health Cooperative.
And how long have you been with the Mental Health Cooperative?
This time 4.5 years.
Right.
I've worked there twice, sorry.
And what is your position there?
Case manager.
And have you occupied that position the entirety of that time?
Yes, sir.
Okay. And describe what a case manager does.
We collaborate with our med provider, therapist, to get, or any outside sources to get I'm a kids case manager, so we collaborate to get them the help they need to overcome any emotional, mental health, behavioral health, academic or physical health goals.
Okay. And are you don't have anything to do with actual therapy or diagnosis, correct?
No, sir.
Okay. But can you detail a patient's treatment through your company?
Yes, typically, once they come into services, they will meet with their med provider where they have a psych evaluation. That is when they get the diagnosis and will discuss any medicine that is needed. And if needed, they will also start therapy and come in and work with a therapist to overcome whatever the symptom or behavior is.
Okay. And are you familiar with the young lady that stepped off the stand, LU?
Yes, sir.
Okay. Is she a patient at the mental health cooperative currently?
Yes, sir.
Okay. And when did she begin treatment with your company?
With me, I started back in January of 2019, and that's when I started working with her. I do not have the exact date. I meant to get that before I come. I apologize. But she was already in services when I come to work there.
Okay. If I handed you up some notes, would that refresh your memory?
Yes, sir. Yes.
You're on my approach.
Yes. So our system, when I got this together for you, goes back to 2018 because I started in 2019. We were using a other program prior to that. And this goes back to when she started in 2018 with us, therapy.
Okay. And what kind of treatment has she done with the mental health cooperative since
Objection.
2018?
Unless he has the medical and psychological experts here to testify, I'll object to her as a case manager discussing her treatment, prognosis, diagnosis, anything of that nature.
She's not here to discuss any diagnoses, Your Honor. She's just here to detail treatment received through her.
I think there's a difference between her just relating what the records reflect as the treatment received versus the diagnosis or professional opinion. So she will be limited to giving only what the records reflect as to the type of treatment she's received. She will not be allowed to give any professional opinion or render any kind of diagnosis. So sustain the objection to that extent, but I'll allow her to testify as to the records.
And since 2018, what treatment has you received through the mental health cooperative?
Therapy, case management, and med management.
Okay. And can you describe those functions?
Therapy, going back to like what I had said before, working with a therapist to overcome any symptoms or behaviors, med management as well, kind of with the same, and then case management, collaborating care for the therapy, med management, and working to reach goals.
And is this treatment in regards to the sexual assault allegations that occurred prior to 2018?
I don't know that I can answer that. I don't know if that would be like an opinion base, but that has been a concern that has been worked on in all three of those areas, if that answers your question.
Can you describe the other phases?
Are you talking about what's on this list?
Yes, correct.
She also was in intensive services with us, and that is more of like a therapeutic case management where they meet 3 times weekly. And so like she also did that with us. And at 2 different times she was discharged from us when she had went inpatient at a different place from us.
Okay. And does she continue to seek treatment through the mental health cooperative?
Yes.
Right. That's all I have to sweat, Your Honor.
Block, do you have any questions?
No questions, Your Honor.
Thank you, ma'am. You may step down. We're releasing you from your subpoena, and you may go. You can stay or go as you choose. Brooks, you may call your next witness.
State would next call Lieutenant Heather Huppe. Huppe, Huppe.
you to step right up, please, and raise your right hand.
solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
Can you please state your name for the record?
Lieutenant Heather Hoope,
Ms. Hupe, where are you employed?
Dixon County Jail.
And what is your position?
I'm the lieutenant and the security officer.
Okay, and what are some of your functions as a security officer?
I deal with all of deboard process, any safety and security issues inside the facility, phone calls, text messages, videos.
So when you refer to phone calls, what do you mean?
All the phones that are recorded inside of the facility, I am the one that investigates any phone calls in there. Anytime that there's a recorded needed, I'm the one that has to handle all those.
So how does, if somebody is housed in your jail, are they able to make phone calls?
Yes.
Okay, how are they able to make phone calls?
Inside their pods, they have 3 phones that hang on the wall that they're able to access at all times of the day.
And are you referring to the inmates?
Correct.
Okay, does this require any funds?
It does. In booking, when they first come in, that those phones are free. But inside the pods, the family has to put money onto the phones for them to be able to use.
Right, and does each inmate have a particular ID that they have to use in order to use these phones?
They do. When they all come into the facility, there's a jacket number that is added to their ISOMs when they first come in, and that's the number that they use. And they also make up a PIN, which I believe is the last 4 of their social.
Is it common practice for inmates to use other inmates' IDs or accounts to initiate phone calls?
Yes.
Okay. So when a phone call is made, what is does it announce itself to the recipient in any certain way?
It does. It comes across as a recording stating that there's a phone call made from this specific inmate where they say their name. And then it tells them that this call has been recorded, and it goes through a whole little verbiage of what the phone system is. And then it tells you have to press a certain number for it to be accepted.
Right.
Your Honor, we have no objection to, of course, reserving my standing objection to the admissibility in this sentencing hearing. We have no objection to these calls being played. The district attorney has provided them to me. I've heard the calls, and the simple way would be just to allow them to play those for the court.
Right, we'll allow them to be played.
Just for identification purposes, do you recognize those CDs?
Yes, I do.
Okay. Have you been able to review those CDs?
Yes, I have.
Okay. And are they phone calls made from the Sheriff's Department jail services?
Yes, they are.
Okay. Your Honor, I'd ask that those be made an exhibit, and then I would ask to publish those.
Right. Welcome as the collective exhibit, which will be 3.
Your Honor, for the YouTube sake, these do mention, one of them at least mentions the victim's name, so I'd ask Ms. McKinney to not publish this to YouTube.
Are you going to let us know which one it is?
I know it's at least the first one.
The first one, so we're going to mute the live stream for this recording. Ask you to step around to where the officer is, please. I'm going to ask you to the best of your ability, raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Mr. Yule, in regards to referring to our victim, we're only using her initials, okay? So we will refer to her as L.U. Okay?
Yes, sir.
All right. Can you please state your name?
Ricky Yule.
Okay. Mr. Yule, you have appointed counsel on this matter?
Yes, he's.
And has he fully advised you of your Fifth Amendment rights?
Yes.
And are you willing to waive those today to speak?
Yes, sir.
All right. Isn't it true that you have a pending tampering case?
Yes.
All right, and you are currently in jail on that, correct? All right. Have we worked out any type of agreement as of yet?
I don't know yet.
Your testimony today, is it possibly to facilitate you getting out?
Oh, okay. I didn't know.
Do we have an agreement to that effect?
I wasn't for sure, but yeah.
Okay, so your testimony here today, you have motivations to get out, right?
Yeah, yeah.
Just to lay it out in front of the court, okay? Do you know the defendant, Jimmy Yule?
Sir.
And who is he to you?
Brother.
All right, can you point him out and describe where he's sitting? Where is he sitting? I mean, could you verbalize it?
Right there beside his, I guess his lawyer.
Okay, and what is he wearing?
Orange.
Okay. Your Honor, if the record could reflect the witness.
Witness has identified the defendant.
Okay. Does Jimmy make phone calls to you from the jail?
Yes, sir.
All right. Does he always call from his account? Okay.
So.
All right. Do you know why we're here today? Okay.
I'm sorry. Oh, yes, sir.
You know why we're here. Has he ever instructed you, you know the phone calls we're here in question?
Yes.
Okay. Did he call you on April 25th of this year?
Yes.
Okay. What was the contents of that discussion you had with Jimmy on the 25th?
He was wanting me to make a fake profile for LU, and like an idiot, I did.
Okay. What was the purpose of making that fake profile?
He said to kind of show that that she was lying or something, but trying to make it look like it or something.
You're referring to the victim, LU?
Yes, ma'am. I mean, sir. Yes, sir. Okay. I'm sorry, I'm nervous.
Your Honor, can the defendant be passed to Exhibit 2? Can you flip through those pages? Do you recognize what was handed to you?
Yes, sir.
Okay, what is it?
Fake profile, or whatever you call it. Yeah.
Okay, so you indicated that it was from a fake profile.
Yes.
Did you create said fake profile? Okay.
Sorry to say it, but yeah.
All right. And are these the messages that you handed to the defense attorney to file this motion?
Defense attorney.
Did you hand them to Mr. Walker?
No, I texted him.
Okay, but you handed these messages over to Mr. Walker?
Yes. Yes.
Okay.
Which I shouldn't have done, but.
And these are messages that you yourself fabricated to yourself? Did Jimmy call you on June 1st?
Around that time, yeah.
What about? Did he give you any further instruction?
Yes, but to get a Dollar General store phone, try to do some more of that stuff, and I didn't do it.
Okay, so when you say stuff, what are you referring to?
Like, get more damaging or what, something or other, the evidence or something, fake evidence, whatever, but I decided not to do it.
All right, so you didn't actually act on those instructions on June 1st?
No.
the April 25th instructions you did act on and follow through with. Okay, and you've since been charged with tampering with evidence.
Yes, sir.
Okay. That's all I have this witness, Your Honor.
Mr. Lockett, do you have any questions?
On the first phone call, you and your brother discussed LU sending messages that she had lied to get her dad in trouble. Ha ha ha. Are you saying that you manufactured all of that? You created it?
I was an idiot for doing it too.
That's all the questions I have.
I can't take it back. I wish I could.
All right, thank you. You may stand down and we'll return you to custody. Thank you.
What I do with these?
Take the last call, Detective Lovell.
You solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God. Yes, ma'am.
Can you please state your name for the record?
Jeff Lovell.
And where are you employed?
I'm a detective with the Dixon County Sheriff's Office.
And what is your position?
Detective, yes.
And how long have you been in that capacity?
In that capacity for almost 10 years.
And were you working in that capacity on or about April to June of this year?
Yes, sir.
All right. Were you made aware of some suspicious jail calls this
Yes,
year?
I
Okay.
was.
Did you have an opportunity to listen to those as they were played in court?
I did.
Are you familiar with the defendant, Jimmy Yule?
I am.
And are you familiar with Ricky Yule, who just was on the stand?
I am now, yes, sir.
Okay. Have you had an opportunity to hear their voices?
I have.
What opportunities have you had to hear their voices?
Over the probably last 6 years, anytime we've had court proceedings, when I interviewed Jimmy Yule back from the original case. And then once I got the phone calls, I listened to those between him and his brother, the calls we're here on today.
Okay. And while you were in court just now and you're listening to those calls, are you able to identify the speakers in those calls?
Yes, sir.
Who are they?
They're Jimmy Yule and Rick Yule.
Okay. And Jimmy Yule, what was his part in those phone calls? Can you just distinguish his voice from the other?
I just know it. You can sometimes hear stuff from like inside the pod or whatever, but just the stuff he was saying let you know which was which. Their voices are different.
Okay. And who was doing the instructing?
Jimmy Yule was doing the instructing.
Okay, when I refer to the instructing, I'm talking about the potential fabricating evidence.
Yes, sir. The fake profiles and the dollar store phone, that stuff. Yes, sir.
That's all I have, Your Honor.
Lockett, any questions?
No questions.
Thank you, Detective. You may stand down and have a seat. State may call your next witness.
State's approved, Your Honor.
State has rested their proof, Mr. Lockett. Do you wish to offer any proof?
I would request a 5-minute recess.
All right, we'll take a recess and we'll probably give you 10 minutes. How about that?
Yes, Your Honor. You may be seated.
All right, Mr. Lockett, do you wish to offer any proof? Oh, you got to bring the client. Go ahead of myself there. Mr. Lockett, do you have any proof you wish to offer?
No, Your Honor, I've discussed with my client whether or not he would take the stand or not, and based on my advice, he's choosing not to take the stand and testify, so I have no proof.
I'll hear an argument then. Mr. Brooks?
Your Honor, after a jury trial, the defendant was convicted of TCA Code 4035. Say no. Was convicted of 39-13-504, the offense of aggravated sexual battery. The legislator has taken a lot of the decisions out of the court's hands in this type of case. According to TCA 4035-112, this is a B felony. The defendant was convicted as a range 1 offender. There's been no proof to say he's a higher range, so he would be sentenced as a range 1 offender. That carries a range of punishment of 8 to 12 years with a maximum fine of $25,000. The defendant is not eligible for probation, subject to TCA Code 4035-303 for the conviction of such offense. This is also a 100% crime. It is to be served at 100% according to 4035-501. So there will be no opportunity of parole except for good time credits that can be achieved at maybe 15% off his sentence. This is a violent sex offense. It is required by TCA Code 39-13-524 that it be a community supervision for life. Also, as a violent sex offender, he's be placed on the sex offender registry for life once he's released from incarceration, 4039-202. Really, the only thing to discuss at this stage is we know he's going to serve. It's really a matter of where he falls within that range of 8 to 12 years, and that's where we go to the mitigating enhancement factors. And the state has already pre-filed a notice of enhancement factors we intended to approve today, and that's what I'll argue right now. Factor 1, the defendant has a previous history of criminal behavior in addition to those necessary to establish the appropriate range. The defendant, looking at his pre-sentence report, he did not have much of a criminal history, if at all, prior to these acts. However, during these, while sentencing has been pending, he has committed serious felonies. The state has provided proof today that the offense of C felony tampering with evidence has been committed, and also an attempt to fabricate more evidence on a second occasion. On April 25th, he called his brother from a separate account. He instructed his brother to create a fake Facebook account and to send messages from said Facebook account to essentially insinuate that the victim was lying at trial. And the court and the defense, we all know that would be a serious consideration for a new trial if in fact the victim had sent those messages. In the process, the defendant has made a mockery of this court, has made a mockery of his counsel's representation. He has made a mockery of this case to our victim. And the state would ask that the court would consider strongly those acts while the sentencing hearing has been pending. Factor 4, the victim's offense was particularly vulnerable because of age. The victim, LU, was 12 years old at the time of this sexual assault. That is when innocence is very important to our children, and that was severely infringed upon when this act was committed. Factor 5, the defendant treated or allowed the victim to be treated with exceptional cruelty during the commission of the offense. The state would submit that the fact that a biological father would subject his biological daughter to sexual assault in and of itself is exceptionally cruel. That would go into violating the position of trust, public or private. In Factor 14, I'm sure, I would assume that Miss U had great trust with her father before this. And that's how, and that led to how this act was committed. At trial, the victim testified that she was sleeping in her parents' room, in the floor. Imagine she had to have a great deal of trust to be able to go to sleep at night in her parents' room. I assume a lot of children do. And then she wakes up to being fondled by her father. Her father's excuse was, it was a mistake. I must have mistaken her for my wife. Regardless that his daughter was sleeping on the floor, not in the bed. Factor 6, the personal injuries inflicted upon the victim were particularly great. Ms. Lovis from the Mental Health Cooperative, she was not able to testify to the actual diagnoses per se, but she's able to detail the extensive treatment that LU has received since these events, and she continues to receive them. The defendant may be serving an indefinite sentence, but the victim will likely have to live with this the rest of her life. And to her credit, she takes the stand and reads her statement and irregardless of what atrocious offenses have occurred to her, she shows empathy. She states, there's still good out there for you. And I hope when you get released, you go back to the people that are waiting on you. It speaks volumes of her. And on the flip side, while this sentencing hearing is pending, he's trying to fabricate evidence. Two different sides of the coin. Speaks volumes to Miss You and the person she is. The offense involved a victim. It was committed to gratify the defendant's desire for pleasure or excitement. I think there's no question that when dealing with sexual battery, it's to involve to gratify the defendant's desire for pleasure or excitement. The state would submit that the only appropriate sentence is to sentence him to the maximum range of 12 years in that 8 to 12 to TDOC. Thank you.
Walker?
First, I'll address, Your Honor, whether the court is to consider the evidence in this case of the attempt to solicit or manufacture false evidence or tamper with false evidence. The court cited some cases. The state has provided a case. I would submit those cases all involve prior convictions where a defendant was afforded the due process of a trial, an attorney, an opportunity to defend against those cases. And even in cases where he was acquitted, he still was afforded that due process previously. In this case, there is no prior conviction. By virtue of the fact that it's an ongoing investigation, it puts the defendant in a position where he's not afforded the due process of defending against those charges. To my knowledge, he's not even charged with those charges yet. I'm sure he will be. One of the considerations in not putting my client on the stand would be the fact that it would be difficult to contest those charges without subjecting him to cross-examination by the state that, depending on his answers, might further incriminate him. So I would submit that evidence should not be considered because all the cases we've looked at, the defendant in those cases, whether he went to trial and was convicted or went to trial and was acquitted, had the opportunity, the due process protections of going to trial, putting on proof, cross-examining witnesses. In this case, he's not even charged yet. Certainly no discovery has been provided in regard to The case, other than the phone calls themselves, to my knowledge, no records have been subpoenaed from Facebook or any real detailed investigation. So my client is not afforded the due process he would have been afforded if he had been charged and had to go to trial on tampering with evidence or conspiracy to tamper with evidence or whatever the charges will end up being. So I submit that kind of hogtied the defendant in a position in this case where he couldn't even take the stand and try to address those because it's a pending investigation. And it would make it difficult for him to take the stand and testify in this case. So I submit that that evidence should not be considered where the defendant is not afforded at least a chance for a jury to either convict or acquit, and where he's afforded some due process in regard to defending against those charges. So I would ask that not be considered in regard to enhancement factor. Number one, I would submit that if you set that aside, he has no criminal history that would cause him to be enhanced at all. The fourth factor, the victim's age, I submit, is an element of and inherent in the offense itself, so should not be considered by the court. The fifth factor, I'd submit there's been no showing of exceptional cruelty other than that would be inherent in the offense itself of aggravated sexual battery. The case manager testified that LU was being treated, but couldn't even say it was solely for this. She said that would only be an opinion. So we don't even know what all she's being treated for. But I submit there is no showing of exceptional cruelty other than that which is inherent in the offense itself. Also, number 6, I submit there's been no showing of great personal injuries. Perhaps the state could have put on proof of a medical expert or psychologist, but there's been no showing of great personal injuries to LU. Number 7 enhancement factor I submit is inherent and an element of the offense and therefore should not be considered. Number 14, there's been no showing that the defendant requested LU to come sleep in the bedroom. No showing that he used a position of public trust to facilitate the commission of that crime, which has to be shown. So I submit that should not be considered either. In regard to mitigating factors, I would submit, number 1, that the criminal conduct neither caused nor threatened serious bodily injury. Number 3, that substantial grounds exist tending to excuse the criminal conduct based on the defendant's statement to law enforcement that it was an accident, and as soon as he realized his hand was over her breast, he removed it. Number 11, that under those circumstances that it was unlikely that a sustained intent to violate the law motivated his conduct. And number 13, any other factor which I would request the court to consider the lack of previous criminal history and also the defendant's work history as reflected in the pre-sentence report. So I would request that his sentence be 8 years.
Anything further, Mr. Brooks?
No, Your Honor.
Court is required to follow the state statutes regarding sentencing that's to be imposed, and those are set forth in the Tennessee Code in Section 4035-103, which are the sentencing considerations. And for the record, so that there's no question about my considering and following all of those considerations, I want to go through them. Number 1, sentencing involving confinement should be based on the following considerations. Confinement is necessary to protect society by restraining a defendant who has a long history of criminal conduct. I'm not going to go through the rest because this is a mandatory sentence to be served based upon a conviction. Second, paragraph 2 of that section says the sentence imposed should be no greater than that deserved for the offense committed. Inequalities in sentences that are unrelated to the purpose of this chapter should be avoided. Sentence imposed should be the least severe measure necessary to achieve the purposes for which the sentence is imposed. And number 5, the potential or lack of potential for rehabilitation or treatment. And it goes on to say that judges are encouraged to use alternatives to incarceration. That's not available in this case because of the nature of the crime and the mandatory sentencing. So, first thing I'm required to do is to set the range that the defendant is, and the court finds that based upon proof, the defendant is a range 1 offender, a standard offender, in other words, as a range 1 offender because according to the pre-sentence report, he has 1 prior conviction, that conviction being for violation of the order of protection, the misdemeanor. So he does have 1 prior conviction, but it's not enough to bump him into a range 2. Based then upon those factors, I'm required to consider the following factors in setting the proper sentence, and those are the evidence, if any, that's received at the trial and the sentencing hearing. Both at the trial and the sentencing hearing, I can consider the evidence, and I must consider that evidence. A pre-sentence report, principles of sentencing and arguments as to the sentencing alternatives, the nature, characteristics of the criminal conduct involved, evidence and information offered by the parties on the mitigating and enhancement factors set out in the Tennessee Code, any statistical information provided by the administrative office of the courts as to sentencing practices for similar offenses. None was presented at this hearing. Any statement of the defendant made on the defendant's own behalf about sentencing, and of course, Mr. Lockett spoke on his behalf. That is not something that the defendant did not make a statement. And lastly, the trial court must also consider the potential or lack of potential for rehabilitation treatment of the defendant in determining sentence alternative of the length of term to be imposed. The length of sentence, the court is required to consider the following under the Tennessee Code. The minimum sentence within the range of punishment is the sentence that should be imposed because the General Assembly set the minimum length of sentence for each felony class to reflect the relative seriousness of the criminal offense in the felony classifications, and the sentence length within the range should be adjusted as appropriate by the presence or absence of mitigating and enhancing factors set out in 4035, 113, and 114. Although the trial court should also consider enhancement and mitigating factors, such factors are advisory only. The trial court's weighing of various mitigating and enhancement factors is left to this court's sound discretion. So going then to having found that the defendant is a range 1 offender for a Class B felony that he's been convicted, Mr. Brooke correctly states that the range of punishment that I'm considering is a minimum of 8 years and a maximum of 12. And obviously these two parties both sides have advocated their position. The defense is asking for the minimum, the state is asking for the maximum. In order to then determine that, I will look to what I believe to be the findings regarding mitigating and enhancing factors. I'll start with the enhancement factors. State refers to factor number 1 set out in the code, which is the defendant has a previous history of criminal behavior in addition to those necessary to establish the appropriate range. As I stated, the defendant has a prior criminal record, prior criminal conviction of violation of an order of protection. It is a misdemeanor, but it is also significant because of the fact that it reflects that the defendant was placed under a court order and failed to adhere to that court order. And albeit a misdemeanor, it also reflects his likely not complying with orders of the court. Then Mr. Lockhart argues that the evidence that the state has presented regarding his behavior should not be considered. Well, this is the sentencing hearing that we're conducting today on June the 30th, 2023. The statutory factor, and I've looked at it at length, does not specifically state that previous criminal history or behavior upon which the court may find a mitigating or rather an enhancing factor must have occurred prior to the commission of the crime upon which he is convicted. In other words, there's nothing in the code or in the case law that I have found that says the only evidence of prior criminal behavior can be anything prior to his being convicted of this crime. And in fact, most of the time in the case law, it's pretty clear. The appellate courts have upheld the fact that if a person charged with multiple counts of rape and is found guilty of one offense of rape, that the trial court sentencing can consider nonetheless the other offenses upon which he was not convicted, which would have occurred prior to his conviction as well. So there's nothing that says that that has to be done in that fashion. The purpose of considering criminal behavior in addition to the necessary appropriate range is to show what type of an individual a person is for purposes of sentencing, whether or not they are willing to engage in other criminal behavior. Our case law that I've cited is pretty clear that it doesn't preclude the court from considering other factors, other cases. And I would simply point out that, and I'm going to refer to one case in particular, which is State of Tennessee versus Melanie C. Moore. It's a 2017 criminal appeal, Court of Criminal Appeals case cited at Lexus 982, decided October the 11th, 2017. In that case, the trial court considered the factor that this lady who was on trial could have been charged with kidnapping of two children. And there was an objection for him having weighed that and having considered that and stated that during sentencing. I would simply refer to you what the trial court there, the Court of Criminal Appeals says. Here the defendant specifically argues the trial court erred in deciding the length of the sentence for count one because the trial court improperly considered the defendant's uncharged conduct over Tennessee Code annotated section 4035-114-3, which states that the offense involved more than one victim. The defendant knows that the trial court frequently referred to the defendant's kidnapping of the minor victims throughout the sentencing hearing. And then we go on to state the trial court, it goes on to state that in other cases, the trial court may look behind the plea bargain and consider the true nature of the offenses committed, citing State versus Hollingsworth. In other words, a trial court is not restricted to considering only the crime to which the defendant pled guilty, but may consider what evidence shows actually happened. Going on to say, in other citations, I'm omitting the citations, that was State versus Jennifer Hargrove. Our court has previously affirmed the trial court's decision to look behind the plea bargain at the facts of the case, including a defendant's uncharged criminal conduct. See State versus Lane, 3 Southwest 3rd, 456, Tennessee Supreme Court decision in 1999. That case affirmed a denial of an alternative sentence in part because the defendant's criminal record included 2 uncharged incidents of statutory rape and 4 uncharged incidents of official misconduct emanating from the relationship with the victim. And it just goes on and on and on in that case, talking about uncharged conduct revealed during affirming a sentence where the trial court considered uncharged conduct that was revealed during the trial. Case after case. So that court concluded that the trial court did not err by considering or referring to the defendant's criminal conduct as kidnapping through the sentencing hearing. Based upon all of that and the prior cases I've cited on that, it's this court's opinion that the evidence of the fact that this defendant clearly intended to present false evidence to this court in obstruction of justice in this proceeding, that he is guilty of, by a preponderance of the evidence at least, the court finds that the state has proven by a preponderance of the evidence that the conduct of the defendant, that he solicited his brother to present false evidence, to manufacture and present false evidence, and that there are a number of criminal statutes that would have applied, but it clearly would also be tampering with evidence in a criminal case that upon all of this. It occurred after conviction, but before the sentencing. So I find it to be prior criminal history or history of criminal behavior, previous criminal behavior that would apply under Rule 1 or Factor 1. I would also state that that is not the only factor that I'm relying upon. It is simply a consideration and observation. I place greater weight upon the following factors. Number 4, the victim of the offense was particularly vulnerable because of age. Yes, it is a factor that the court finds that it was a statutory offense that basically said that he was convicted of sexual battery of a child under 13 years of age. That's the nature of the child. So that is a part of the consideration. So number 4 cannot be considered as a factor for enhancement in this court's opinion because it is part of the crime itself. Number 5, the defendant treated or allowed the victim to be treated with exceptional cruelty during the commission of the offense. I don't find that to be the case. Yes, I know Mr. Brooks argues that this was exceptional cruelty to do this to a person's own biological child. However, the fact of the matter is that I don't think that factor deals with that type of psychological injury. I think Factor 6 does apply. The personal injuries inflicted upon the victim were particularly great. This court has presided over this case for a couple of years during this time. I have observed LU, the victim in this case, come into court on numerous occasions. I have observed the emotional trauma that this case has imposed upon her, having to come into court and testify on multiple occasions, on motion hearings and at trial. And it is clear from my observations of her that she has suffered an irreversible, I hope not irreversible, but an undisputable psychological and emotional injury as a result of this. I think it is not necessarily a physical injury that she suffered, but it certainly is an emotional injury. The proof before me is that she's undergoing therapy and has been for years. And that's consistent with the testimony at trial. He was not convicted of multiple accounts because he was only charged with these others, but there was testimony that this had been ongoing for some time. As a result of that, this court is of the opinion that that is a major factor. The personal injuries inflicted upon this victim being molested by her own father over a period of time, including the evidence that she testified at trial about that the jury found him not guilty of. He was acquitted by it, but I still consider that evidence in determining that that is a major factor upon which I place great emphasis. Factor 7, the offense involved a victim was committed to gratify the defendant's desire for pleasure or excitement, clearly applies to this case. I do not believe that the defendant who did, his story about that he just accidentally woke up and had his hand on his daughter's breast instead thought it was his wife is not, in my opinion, not a credible explanation, period. I think it was clearly these things, according to her testimony, the victim, that it was done to gratify his desire for sexual pleasure or excitement. And Factor 14, the defendant abused a position of public or private trust in a manner that significantly facilitated the commission or fulfillment of the offense. I don't think that factor requires that there be proof that because he was a parent, he called her to the bed or anything else. He was her father. There's no greater obligation that a person can have than as a parent to protect your child from these types of things happening. To have a father who willingly and intentionally abused that position of trust and used that position to obtain his own sexual gratification, one of the worst things that a person can do. And I find that that is a major factor that deserves great weight. So I have found factor number 1 to be applicable. Factor 4 cited by the state to not apply because of the fact that the offense he was committed or he was convicted of included the age requirement of the defendant. Factor 5, I do not find because there was no evidence of any cruelty during the offense other than the nature of the offense, but I do find Factor 6, 7, and 14, so 4 of the 4 aggravating factors that, in my opinion, apply. Then moving to the argument made by the defense for the mitigating factors. The defendant's criminal conduct neither caused nor threatened serious bodily injury. Serious bodily injury depends on different things, but the case law clearly indicates that psychological or emotional damage can be serious bodily injury. I do not find that to be applicable. I find that she has suffered serious bodily injury, and that my observations of her in person while she testified and the trauma that she experienced, the emotional upheaval that took place. One particular hearing, she stood and walked out of the room because she was so emotionally distraught. The defendant acted under strong provocation does not apply. I believe the defense actually cited number 1 and number 3. Number 3, substantial grounds exist tending to excuse or justify the defendant's criminal conduct. I find that does not apply. His statement to law enforcement that it was an accident that he is completely contrary to the testimony of the victim, in this case, LU, who testified this was not an isolated event, but rather a repeated course of conduct. And number 11, the defendant, although guilty of the crime committed under such unusual circumstances, unlikely that a sustained intent to violate the law motivated the criminal conduct. If nothing else, the evidence presented by the state today about his soliciting a false report to be, or a false evidence to be introduced to this court, clearly shows that he has a sustained intent to engage in criminal conduct, and it does not hesitate from doing so. But nonetheless, I don't find that this was unusual circumstances that I don't find this factor to apply, because I think the young lady testified that it occurred over a course of time, that it was not an isolated event, and it repeatedly occurred. So I do not find that to be. And number 13, any other factor that the court may consider for purposes of the chapter, and he cites the lack of previous criminal history. I have found the criminal history does apply in number 1, and his work history. I do find that there is, that he was gainfully employed, but that is only a very minor consideration. Based upon that, it is this court's opinion, based upon the 4 enhancing factors, that his sentence should be 12 years in the Tennessee Department of Corrections be served. As a judgment, he ordered to pay a $25,000 fine, and he'll be on the sex offender registry for a lifetime, and he will also be under community supervision for life. That's the judgment of the court in this case. Having rendered that verdict, he is remanded to the custody of the Department of Corrections to begin serving his sentence. We will, with that, adjourn court.
Your Honor, had we already set a motion for new trial date?
I don't know that we have. We can do that now if you like. I know you have not yet filed it, so we hadn't had the sentencing hearing, but you're able to do it by that August 28th date.
Yes, Your Honor.
Let's just set it for August 28th at 1:30. Brooks, is that any problem for you?
Should be, Your Honor.
A motion for new trial will be August 28th at 1:30.
All rise. Court's adjourned. What did he say? Breakdown. Yeah, man.
Say you did do all you could do. Run. Yeah, I was looking at September 28th.
Little one-arm paper hanging.
They all,
man, a lot of them do that. Joe's dangerous work that he does. I mean, he made it impossible. I know for a fact, they won. Oh, yeah. You know what? He's the person, what we the last time. They listen to their inmates more than they do the lawyers. Yeah. I'll be thinking like that. He's gonna be a good lawyer, that's where he's sitting. Same pod you're at. You can't turn around like, who's next? Who's next? Yeah, I call you.
Yeah, I know yours goes a lot like mine.
This is case number 23-240-077. Stephen Johnson versus Bozzi Auto Sales LLC. This is a small claims bench trial. This is an appeal. The appeal is de novo. That means it's brand new. There is no appeal from my decision. Because this is a small claims matter, there is no record in this case. So I shut down the JAF system. Could you raise your right hand, sir? You swear affirm testimony you're about to give be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
Could you raise your right hand, ma'am? You swear affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
Mr. Johnson, please proceed.
So yeah, we're here because I purchased a used vehicle from the defendant, which they misrepresented the condition of, and this cost me $6,000 in damages. I was made aware of this listing on Auto Trader. The advertisement for this car clearly stated that it was in good condition and pre-inspected, which I've included on the top of page 4 of my evidence document I've submitted, if you have that.
I have it, and I have reviewed.
Okay. I talked to the defendant multiple times over the phone asking about this car. They agreed to inspect it again for me and told me it passed. When I was on site, I also specifically asked about leaks and rust damage, and they told me it had nothing in need of repair. And so this led to me purchasing the vehicle for $6,100. However, that very same week, I took the car to the mechanic and who identified numerous severe. I'm sorry?
The mechanic you're referring to is Convenience Auto?
Yes, the first mechanic. That same week, and they identified numerous severe issues with the car, including leaks in power steering fluid, engine oil, transmission coolant, and brake fluid. I've included the entire report on pages 6 through 11. I also want to point out a note from the owner saying that these types of damages cannot happen in just a couple of days and must have been present at the time of sale. I've blown up some of the pictures from this report on pages 13 and 14. We can clearly see a lot of leaks happening here. On the bottom of page 4, the power steering fluid was leaking so bad that it was puddling during the time of their short inspection. On the top of page 14, we see corroded brake lines. And on the bottom of page 14, on the bottom left, is the area underneath where I parked the car, versus on the bottom right, the area just behind my car, showing clean pavement as this street was resurfaced recently before I bought the car. So at this time, I took the car back to the defendant. I told them this is not what you told me it was. I tried to sell it back to them. They would not. They did perform some attempted repairs on the vehicle. One of the brake lines and part of a power steering line. But they insisted nothing else was wrong. So at this time, I got the car back and took it to another mechanic. This is the Hoover Street Auto Inspection that I've included on pages 16 through 20. This identified essentially all of the same issues as the first report, including, I'll point out on page 18, they list all of the leaks they found, which again were leaks in engine oil, transmission coolant, power steering fluid, and brake fluid. So even aspects the defendant had attempted to repair or in some cases partially repaired. The cost estimate to fix these leaks, as well as the suspension that was rotted and in need of replacement, is over $5,000. Of course, the car is worth nothing close to that. I bought this car to use for work. I need to be able to drive at distances on the highway. in its condition, it can't reliably do that. So I intend to get rid of this car as soon as this case is over. I've been exploring options to sell the car. The highest offer I've gotten is 900. I was also able to find record of what I believe is the purchase of the car by the defendant at auction for 800. And so I think that is the value of this car, $900. When we add up what I spent to buy the car, what I've had to pay for inspections, and what I have to pay for insurance, because the car is financed, I can't drop insurance until I pay off the loan. The damages are 6,900. The car's worth 900. That's why I'm asking for 6,000, which I believe I'm legally entitled to, as the sale of this car violated the Michigan Consumer Protection Act. I've included a legal memo referencing the specific subsection I found that I believe this falls under. Subsection 9031E, which states that, quote, representing that goods or services are of a particular standard, quality, or grade, if they are of another, end quote, is an example of unlawful commerce. I think that's clearly what happened here, and resulted in, like I said, $6,000 in damages that I'm asking for. And I think that is all I have to say, so I'm happy to answer any follow-up questions.
What is your education level?
I got I just got my PhD last year.
Did you read the contract that you signed when you bought the car?
I did. I'm aware the car did not come with warranty. However, I don't think that I'm arguing, I think, for misrepresentation of the vehicle prior, resulting in the contract. I'm not arguing under warranty.
Do you have any legal support for your proposition that you may maintain a private action under the Michigan Consumer Protection Act, as distinguished from those actions being reserved for the Attorney General of the state of Michigan?
I'm sorry, could you repeat that, Your Honor?
Yes, sir. I'm asking you, do you have any legal authority for your proposition that you can maintain a private action under the Michigan Consumer Protection Act?
I'm not sure what exactly you're asking.
Okay, thank you. Let me hear from Ms. Bozzi.
Okay, so yeah, he did purchase the vehicle. When he came in, before purchasing the vehicle, he was here for at least 4 to 5 hours, checking out the car. His complaint or question, I guess, was the blinker works, but it didn't make a noise inside the car. And if we'd be able to fix that, which we said no, and the radio was the main concern for him. We offered for him to take the vehicle to go have it inspected by his mechanic or another mechanic. We also offered for him to lift up the car here to take a look at it, and he declined. Then he purchased the car. When we were doing the paperwork, he specifically asked about the as-is form. I explained it thoroughly. He read it, he signed it.
What did you tell him about the as-is form?
That there's no warranty, and that basically what the as-is form says, like right above where he signed, it says everything that could be wrong with a used car. And I just told him that there's no warranty and we're not selling. It basically states that we're not selling him a warranty or promising him a warranty. So he continued to go ahead with the purchase. So then I did include in our appeal, our email conversation, where he did bring the car back. We did agree to fix a couple of the main concerns. A lot of the other things on that report were just like, tires and stuff that is kind of common with used cars. We still agreed to try to make him happy and fix a couple of those repairs. And according to him, it still wasn't fixed. Like, I don't know exactly how much longer. It's in the paperwork here that you have, but we agreed to have a different mechanic look at it because maybe they just didn't do their job the first time when they tried to repair those two things for him, but he declined. And then I ended up getting the paperwork for the lawsuit.
All right, Mr. Johnson, were you given at the time of the sale the opportunity to inspect the vehicle?
I was able to inspect the vehicle,
How
yes.
much time did you spend doing that, sir?
Well, I looked at multiple vehicles when I was
Also, I'm
there.
asking you, how much time did you spend inspecting the vehicle?
On this particular vehicle,
Yes, the one you bought. Yes, sir.
I would say about maybe an hour, but I never looked underneath it.
Were you offered the opportunity to have the vehicle put on a hoist to look at it?
I don't recall being offered so.
So does that mean it was not, or you don't recall one way or the other?
I was not.
All right. Do you have any background in automotive technology or in automobiles?
No, I don't.
Had you owned an automobile before this vehicle?
Yes, in fact, I actually owned this exact same make and model just 4 years earlier. And so I thought I knew what I was getting into with this.
All right. Is there anything else you want to tell me, Mr. Johnson, about your claim?
Yeah, I would like to state that, I'm sorry, sorry, can I have 1 second? I would like to clarify, I think some points made by the defendant that I disagree with. They did not allow me to have the car inspected by my mechanic. They did say I could get it inspected, but the mechanics that I asked to get it inspected with were too far away. And they also, I don't know what was mentioned about getting the car inspected after they worked on it. I don't think that ever happened. After they attempted to fix the car, I told them that I was going to get another opinion, and that was how that conversation went. They did not offer to do anything related to that in the area.
Is there anything else you want to say?
No.
Ms. Bozzi, is there anything else you want to tell the court?
No, Your Honor.
Mr. Johnson, you have the last word because you have the plaintiff. You are the plaintiff. You have the burden of proof. Is there anything else you want to tell the court?
I think all of the photos and testimony from multiple mechanics that I took this car to speak volumes in terms of evidence for misrepresentation. So I don't have anything else to add.
Thank you. I'm prepared to rule on this matter. This is a claim ultimately for breach of contract. Claim is that the vehicle was sold by the defendants, and it was not as the parties agreed it should be. The problem with the argument here on behalf of plaintiff, who has the burden of proof, is that on the face of the sale document, the document that was provided for me as part of the information provided by Mr. Johnson, car sold as is, no warranty. You're an educated man. You elected to buy a car without an inspection. You elected to buy a car without a warranty as is. The parties agreed onto a sale price on the basis of an as-is situation. The Michigan Consumer Protection Act does not provide for a private cause of action. It instead provides for opportunity for the Michigan Attorney General or some agent of the state to bring action saying there has been a violation of the Consumer Protection Act. It is therefore the ruling of the court that the defendant will win. Plaintiff gets no cause for action. Plaintiff has failed to prove its case. Plaintiff bought a vehicle that clearly needed help, but bought it as is. As is exactly that. What you buy is what you get. I'll send out an order today, and good luck to you both.
Thank you.
In that week, I think it's 14 hours one way. So he's basically in a vehicle for approximately 30 hours within a week.
So when you tried the driving, was it you doing the driving or was it Miss McKnight?
Well, it was actually myself, Mr. William Booth, and Miss McKnight, and my partner Cassie Criado. That way we could switch who was driving for safety reasons, because it was a fairly long drive.
Thank you. Judge, pass the witness.
Vickers?
I have no further questions, Your Honor.
Mr. Conley?
I don't have anything else for Mr. Huddleston, Judge.
Ms. Vickers, your next witness?
That's all the witnesses I'm calling for this particular motion. I assume we're going to do something different and separate with the mediation motion.
Okay. All right, Mr. Conley, would you like to call a witness?
Just briefly, Judge, I'll call my client.
All right, Ms. Saul, can you please unmute yourself? Please raise your right hand. Do you solemnly swear the testimony that you give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
You may put your hand down. And what is your name?
Aaron Sewell.
All right, you may proceed, Mr. Conley.
Good morning, Ms. Sewell. Are you in Georgia today?
Yes, sir.
All right. And I'm just going to kind of go straight to the point that we're here discussing today, the extended summer possession. Have you tried to make your son available to his father for a lengthy period of time this summer?
Yes, sir.
All right. And have you basically proposed a period over 30 days up to 42 days?
Yes, sir.
All right. Do you have some concerns about your son being gone from you so quickly for that long of a period of time?
Yes, sir.
Tell me just a little bit about those concerns.
I'm concerned the medication that he is on is only a 30-day dose. And due to the fact that it cannot be mailed or anything like that, and also he has doctor's appointments that he needs to, go to help him. I'm concerned that him not being around his brother and sister, that both his brother and sister miss him very dearly, and that he's always been around, them for the last 3 years. And during the time he has been at his father's, I have talked to my son on Zoom calls. 3 days I wasn't able to call him. He wasn't wanting to talk to me. I could understand he was at a church thing, apparently doing a water thing, and I completely understand that. I want him to have as much as fun as possible. I want him to enjoy his time.
Okay. And so you're aware that we have a final trial on the merits set for July 17th?
Yes, sir.
And are you requesting of the court today that essentially your son be returned to you the week before the trial?
Yes, sir.
So that would be about July 9th would be that Sunday before. That'd be about 8 days, I guess, if it was a Sunday transfer before the final trial. Is that correct?
Yes, sir.
And then would it be your intention to travel back to Texas for the final trial on the 17th with your son?
Yes, sir.
All right. Now I don't want to take too much of the court's time, but you you had started the process of having your son evaluated by an autism expert, is that correct?
Yes, sir.
But the individual that was you were initially referred to, was she able to complete the full evaluation?
No, sir.
All right. Are you committed to try to find someone else to finish that evaluation?
Yes, sir. He is on the list for Hope Bridge here in Georgia. It's a very good autism place to be diagnosed. They have very good therapy here. I am just waiting on a call from them to get him scheduled in.
All right. And, you've spent a lot of time with Peter. What sort of things, behaviors have you observed that give you concern that he might fall within the autism spectrum?
He has a problem with colors and separating his foods. I can give him the same thing, the same type of food, but it could be mixed together, and he will not eat it. He won't touch it. Even though he might like it, he has a problem with it. His colors have to be a certain color. Also, he's going to be 6 next month, but he acts like he is behind. He's an intelligent kid, but he writes his numbers backwards, his ABCs backwards sometimes. And I have talked to his teacher before about it to find out what was going on. I've talked to many counselors at the school to find out what was going on, due to the fact that I was trying to figure out, well, he's a very smart child, why is this happening? And he's kind of behind on certain things. I've been told by a psychiatrist.
Your Honor, I'm gonna object to any testimony about what she's been told. That's hearsay.
Sustained.
Yeah. So we'll just stick to things that you've personally observed. But let me just ask you this, Aaron, are you committed to making sure that your son he sees doctors who can appropriately diagnose whatever is going on in his world?
Yes, sir.
Okay. I'll pass the witness, Judge.
Ms. Vickers?
Ms. Sewell, what does the possibility that Peter might have autism, we don't know, but what does that have to do with him visiting with his father?
It has nothing to do with visiting his father. We have offered him to come up here and pay for all of his expenses to come see his son many of times. We have no problem with Bryce.
Excuse me, let me stop you for a second. When did that happen?
Every time Peter had asked for his father to come up here, we said we have no problems of him coming up here. And also
excuse me, Ms. Soul, let me finish my question. So answer my question. When did that happen? Can you give me a month and a year when you extended to Mr. Huddleston an invitation where you would pay for his travel and have him come to Georgia to see Peter? When did that happen?
Christmas of 2022, spring break of 2023.
Okay, well, so you're talking about the visits that have already occurred that we agreed to once the court proceedings were going on, the ones that Mr. Huddleston has testified to. That's what you're talking about?
Yes, ma'am.
Okay, now you talked about his medications. Is there some issue with calling in medications if they're needed to a pharmacy here in Pleasanton or San Antonio?
They are a controlled substance, and going from state to state is very difficult.
Well, have you ever attempted to call and figure out a way to call in a prescription to a pharmacy that is local to Mr. Huddleston? Have you tried?
Yes, ma'am. They have to have an ID. And he's also on Medicaid here in Georgia. And so the insurance doesn't travel to Texas, unfortunately.
Okay, have you given a prescription to Mr. Huddleston to see if he can arrange medications?
I have given him the bottles that
But that's not my question. Have you given him the actual prescription?
I'm kind of confused, ma'am. Meaning the paper?
The piece of paper that the doctor signs that says, this is my prescription, he's getting such and such medication. Have you given that to Mr. Huddleston and worked with him to see about the possibility of medications being available in Texas?
They do not write a piece of paper out.
That's not my question. That's not my question, Ms. Sewell. Have you attempted to give Mr. Huddleston the actual prescription and to see if there's any way to obtain whatever medication's been prescribed here in Texas?
Objection.
It's a yes or no. It's a yes or no
She
question.
just responded she didn't have a piece of paper.
So the answer is no.
Just to clarify, Ms. Stoll, I mean, why can't he get the prescription drugs here in Texas? Can't you just get the medical providers to provide him with a prescription? He goes to a pharmacy here in Texas. He may have to pay out of his pocket since it might be not covered by your insurance, but he should be able to get the same prescription here in Texas, right?
They already have them ahead of time, and they don't write any of the prescriptions out on paper. They all call it in.
Right. I know that things have changed where we don't really have paper prescriptions anymore, but still, it still begs the question, why can't he just get the pills here in Texas?
They have to have an ID, and it has to be on the list, and he is on the list. But here in Georgia, they have to have an actual ID in person to see it.
All right. Who are you looking at right now?
No one, sir.
Okay. There's no one in the room with you right now?
No, sir.
Okay. All right. Next question, Ms. Vickers.
All right. So you said something about medical appointments. When are these medical appointments scheduled?
He has a wellness check and a med checkup in July. I had to cancel.
When in July? What day?
It's on the 20th of July. I had to cancel it due to the court case coming up.
Okay, so it's actually after our court date.
Yes, ma'am.
All right. I have no further questions, Your Honor.
Ms. Harkins, do you have any questions?
I do, Your Honor. Okay, Ms. Sewell, let me get my bearings here. Okay. So the wellness checkup and you said a med checkup?
Yes, ma'am.
Is that, his birthday's in July, right?
Yes, ma'am.
So are those, like age 6 appointments?
Yes, ma'am. That's a 6-year appointment.
Okay. Any appointments in July related to his, the autism diagnosis?
Unfortunately, since the autism doctor, Dr. Courtney, couldn't finish the evaluation, we are on, as I said, we were on a wait list for Hope Ridge to get in. Now that can happen at any time during the month, or it could be next week. It could be as soon as I get a call from them.
Okay.
The reason why she had canceled out due to the fact that apparently from what she had told me was that she does not do custody battles. I explained to her that I'm not here for any, evidence. I'm just seeing what I could do to help my son. And she said, because it's a custody battle and a lot of people have been calling her, apparently harassing her is what the words were told to me over the phone. Apparently playing phone tag. And and I knew that you had called her. And then 2 other people apparently had called her, a lawyer and someone else that was a family member, is what I was told.
Okay. Well, it's true that everybody's been trying to get medical records for
Yes,
see what's going on with Peter, right?
Yes, ma'am.
Repeat that, please, Ms. Harkins.
Everyone has been trying to get medical records to find out what's going on with Peter.
Yes, ma'am.
And, I was under the impression that Peter does have autism, that he has been diagnosed on the high spectrum of autism. Is that correct or not?
Yes, ma'am. So he's been to a therapist here that was court ordered by the Georgia courts. Her name is Debbie Chambers. She referred me to River Edge Behavioral, and I had talked to them. I've talked to his pediatric primary doctor here, and they told me his primary pediatric
Your Honor,
doctor.
I'm going to object to any testimony about what a medical professional told her. That's all hearsay. We don't have any expert witnesses to talk about that. We don't have any medical records with the business records affidavit. We don't have any of that.
Sustained.
Okay, Ms. Soul, let me ask you this. Is it correct that Peter is on some pretty significant medication tailored for autism?
Yes, ma'am. He's on a low dose of risperidone.
Okay. Any other medication?
He's also on clonidine or clonidine.
Is that for sleep?
Yes, ma'am.
Okay, let me talk to you about the Christmas visit and the spring break visit, because I know that you and I spoke after each visit after Peter had returned home. And from what you told me, that transition was kind of difficult, right, when Peter would get home?
Yes, ma'am.
And so tell the judge that what Peter's behavior was when he would come back.
Peter came home just going crazy pretty much. And I guess the best way I can explain it is that misbehaving, jumping around, wanting to watch TV. He was wanting to take drinks out of our fridge, and he drinks water with us. We very rare give him any kind of sugary stuff due to the fact that the medication that he's on, he has to drink a lot of water or he gets really bad headaches. He was having nightmares. When his dad would call him, he did not want me leaving the room anymore. He wanted me to stay there. I told him you needed to talk to your dad. He did not want me leaving whatsoever. I've tried many times to give him and his dad his own personal spot where they can go into Peter's room and talk with the door closed while my other kids were outside playing or sitting down eating. But it started to get to the point where he did not want to leave my side. So I told Peter, you can sit at the kitchen table. I'm right here. If you need me, I'm right here. I'm cleaning the kitchen up. If you need me, mommy's right here pretty much. He was having nightmares really badly for a couple of days and just screaming for me.
Okay, and now on the flip side, you testified to this, and you also told me that when Peter was with Mr. Huddleston, there were times that he didn't want to talk to you at all, right?
No, he didn't want to talk to me, and it really concerned me a lot due to the fact that, he would run away and he's like, I don't want to talk to you. I don't want to talk to you. And I'm like, he's always wanted to talk with me.
Okay. And this is on Zoom, right? Not it's Zoom or FaceTime?
Zoom.
Okay. No further questions.
Mr. Connolly?
Just briefly, Judge, and if I may do a screen share, I've actually got some medical records with a BRA that I think might help us get to the bottom of something pretty quickly.
Have you provided, I don't recall receiving a business records affidavit, which just has to be on file for a certain number of days prior to the admission into court. What records are we talking about?
This is the notice that we subpoenaed from Dr. Courtney, which I believe you signed off on.
Okay.
And we received, I think, on 5/23, so just recently. But I was under the impression we've already provided it to you. You can inspect it, you can review it.
Well, normally business records affidavits, if you're using the affidavit, you have to file a notice and then it has to be on file. I believe it's.
I was under the impression it was on file.
I thought so. I got it.
Okay, well, it might be. I just don't know what records we're talking about. So let's see, and I'll reserve my objection.
I think I gave you the ability to share your screen.
And Judge, it looks, I'm sorry, I got a new computer 2 days ago, and it looks like I need to reauthorize my computer and quit to share. So I think I just need to restart Zoom for it to authorize it. Do you mind if I just do that really quickly? And then I think it'll just take 5 seconds for me to log back in.
Sure.
Okay, thank you, Your Honor. I apologize for that.
All right, I'm going to turn off my video while he's doing that. No worries, that was really quick.
All right, so I'm going to share what I will tentatively call ES1, just for Aaron Sewell 1. This is the response to a subpoena that we sent to Audrey Courtney in Georgia. We have attached to it a deposition notice, as well as an authorization to release records. There is a letter that she has provided that certifies that these are her complete records, and on the back of it, there is an affidavit of no records, and it references the letter that she sent. I would just ask that, or I'd move to tender into evidence ES1 as medical records from Audrey Courtney supported by a business records affidavit.
Ms. Vickers, you're on mute.
Yes, Your Honor, I did receive this, and I did waive the notice period for the deposition by written questions. So at this point, I don't have any objection.
All right, so just briefly.
Well, hold on, let me admit it. So ES number 1 is admitted, and Mr. Connell, I'll need for you to drag this thing into the chat, so that way the this, you know, for me to admit it into the record, I need to have it. So please, if you could please drag that into the chat. Do you know what I'm talking about?
I most certainly can. Can I just finish with it, and then when I close my screen share, I can drop it right in, I believe.
Yes, and of course, Miss May, if I forget to tell them to do it, you're going to remind us, right?
Yes, sir.
All right. Ms. Sewell, so it's my understanding that Peter was seen at Rivers Edge Behavioral Health Center in Macon, Georgia. Is that correct?
Yes, sir.
All right. And approximately when was that?
That was, I want to believe, last year, between right at the end of the year.
All right. And it was the therapist there that referred Peter to Audrey Courtney. Is that correct?
Yes, sir.
Is Audrey Courtney a specialist in diagnosis of autism and other psychological conditions?
Yes, sir.
All right. And did Audrey Courtney see Peter on or about March 29th, 2023?
Yes, sir.
All right. And did you arrange this because you were concerned about making sure that your son got the appropriate treatment?
Yes, sir.
Is part of why you did this also that Peter's primary care physician diagnosed him with autism?
Yes, sir.
I'm going to object to any testimony about what another doctor diagnosed him with, Your Honor. That's all hearsay.
Judge, we're just offering it for a non-hearsay purpose to explain her conduct of why she did this. We're not offering it for the truth of the matter asserted.
Yeah, overruled, Ms. Vickers.
All right.
All right, Ms. Sewell. So did Peter ultimately meet with Dr. Courtney?
Yes, he did.
All right. But then she explained that after a consultation, she wouldn't get involved because she understood there was a contentious custody matter here.
So I had an appointment set for him to go in and start his therapy and everything and all his diagnosis. And the day before he was supposed to go, she gave me a call on the phone telling me she will no longer see Peter due to the fact that this is a custody matter and that she will not do custody matters, that people had been calling her and, like I said, harassed her in a way.
All right. So Ms. Vickers asked a question, why about all this talk about autism? Why does it matter? Is it your position that it matters because you're trying to get your son to an expert who can properly diagnose him?
Yes, sir.
And you're committed to that?
Yes, sir.
And you've been trying for the past months to get him in to see a specialist, and that can be difficult, correct?
Yes, sir.
There are typically waiting lists, and you know, you have to just be available whenever they have you come in. Is that correct?
Yes, sir.
All right. So again, Ms. Sewell, you're just asking for your son to come back for a week before trial today?
Yes, sir.
Okay. I'll pass the witness, Judge.
Ms. Vickers,
I have no further questions, Your Honor.
Ms. Harkins.
I have no questions, Judge.
All right, you may call your next witness, Mr. Connolly.
Judge, I have no further testimony.
All right, and Ms. Harkins, do you have any witnesses to call, or do you have a report from the amicus that I need to hear?
Judge, I don't have any witnesses, but I can make a report. Excuse me. Judge, I have seen Peter quite a few times now when he's come down. You know, I have a limited time to see him in person, so I really do try to make an effort to go over there and see him in his dad's home, and see him interact with Ms. McKnight, who we've heard testimony is also very involved. And I also have spoken to his counselor. Ms. Sewell mentioned her name, Debbie Chambers, who has not seen him anytime recently, but did refer him for assessment for autism. And Judge, really what I have to say is I haven't heard any testimony of how this recent diagnosis or you know, investigation into whether he has autism would affect a visit down here in Pleasanton. And you know, it is true, and no one's denying that Mr. Huddleston has gone quite a bit of time without seeing Peter for extended periods of time. And my main concern in all of the investigation that I've done is that Peter needs consistency. And from what I can tell, his main trauma is the inability for his parents to communicate and co-parent. And also, I believe that it has not been good for him to go such a long period of time without seeing his dad. And I do think that the transition between homes will take a toll on him, because everything that I've heard from both parents is that when he returns to either home, it is a difficult transition, and that is the hardest time. As far as Peter's communication with either parent when he's not with them, you know, the parties agreed for Peter to talk to the other parent. I think it's daily, and that's hard. I mean, I have a 5-year-old. That's difficult, especially for a video call. And so I don't think I from my conversations and just observing Peter, I don't think that anything's going on in Mr. Huddleston's household that makes Peter not want to talk to his mom and vice versa. I think part of it is a scheduling issue, and he's having fun and he's getting disrupted. So my main concern, Judge, is the back and forth. Georgia is far. I know Mr. Huddleston has limited means, and for Peter to go back and forth so much, I think that's part of the problem. So my recommendation is for Peter to spend a significant period of time here with his dad, especially given that he missed out on a lot of time. And the parties all know that I'm the one that initiated the recommendation of him to stay with his dad until the final hearing. And I haven't heard anything today that makes me change my mind on that. So I don't see why that's not in Peter's best interest.
All right, does anybody have any questions for Ms. Harkins?
I don't have any questions.
Mr. Connolly? You're on mute.
I apologize, Judge. Just briefly, Ms. Harkins, part of your investigation is you spoke with Ms. Chambers, correct?
That's correct.
All right. And what was her perspective on the matter? Did she have any thoughts with regards to Mr. Huddleston's work schedule and who the child was with?
Sure. Okay, so I think it's important for context purposes to go back to the first time I talked to Ms. Chambers, which was in January. And at that time, she had been seeing Peter quite a bit. And, you know, she's the one who indicated to me that the main trauma is being ripped apart from both parents, parents fighting, and the need for consistency for him. And so I initially got that from her. And so I kind of tailored my investigation to that. And then in my latest communication with her, I basically told her what I had recommended. I told her what the state legislature has determined is appropriate visitation for over 100 miles. And just gave her the whole rundown and included the fact that he, I thought at that time, had certainly been recently diagnosed with autism. And so she said, I haven't seen Peter in a long time, but I know he loves to spend time with his dad. I can't see any reason why he couldn't stay the 42 days as long as dad doesn't use the CBD gummies, which is a past issue that has been discussed, and that dad isn't working most of those days. So she did say that. Now, I know for a fact Mr. Huddleston is going to be working a lot of those days. So my recommendation hasn't changed because I know he comes home at night. It's not like he's gone 2 weeks on, 2 weeks off. But that was Ms. Chambers's response to me.
Okay, nothing further for Ms. Harkins, Judge.
Any follow-up, Ms. Vickers?
No, Your Honor.
Do you now arrest Ms. Harkins?
Yes, Your Honor.
All right, a closing argument, Ms. Vickers?
Well, Your Honor, this is a very limited issue, but it's in the end, it'll be the crux of the case, or part of the a large part of the case. But I mean, we're talking about the 42 days as if my client is currently under an order that where he is the conservator with the standard possession over 100 miles, and he actually isn't. He's actually still the primary custodial parent of this child. And we haven't had the luxury yet or the means yet to have the actual hearing on the motion to modify, which is not till July. So while I understand the logic of using the 42 days, if my client has this child till the day of court on July 17th, when the decision will be made on the modification, he'll have something like 46 or 47 days instead of 42. So it's kind of like the argument is kind of backwards, because technically my client is entitled to possession under the current court order that hasn't been modified except for some interim temporary orders. Nobody's named joint managing conservator with the right to determine the child's residence except for him. And we have this huge period of time, and I get we're going to have to negotiate, we're going to have to deal with that at a merits hearing. There's this huge period of time where this child did not see his father through no fault of the father's. And now it's a concern that he's far away from his mom and he doesn't get to see his mom, but nobody seemed to be very concerned about that during the time period, a year and a half, whatever it was, that my client had zero contact while all the Georgia stuff was playing out. And so all I'm asking is that my client have a few extra days beyond the 42-day presumed standard possession order for somebody who has visitation over 100 miles. I don't think under these circumstances, that's asking for a whole lot. There is no reason why autism has anything to do with that. We don't have any scheduled doctor appointments that are going to be of great significance that I've heard about. We seem to have the excuse of, well, I can't get his medication. Frankly, I don't think that Ms. Sewell has worked very hard to determine whether or not that can be addressed, and I think it could be addressed. I am assuming Mr. Huddleston could certainly go to a doctor and the doctors could figure something out. There's people that travel all the time and get controlled substances and prescriptions for that when they're in a different location. So I just think that's an excuse. Nobody has testified that anything untoward has happened during Mr. Huddleston's visits up to this point. And so I don't see why he can't have an extra few days for possession, given all of those facts, until we reach the merits hearing on July 17th and 18th.
Mr. Connolly?
Judge, we're not here today to relitigate everything that preceded the filing of the emergency petition in Georgia, but a court there found that there was good reason to believe that this child had been medically neglected, and that is why they issued emergency jurisdiction. That is after picking up the child after he was with his father for an extended summer period of possession. I'm not here to argue about all that today. What I'm simply saying is, first off, I understand the position that we haven't had a modification, but I believe under the 1214 signed agreed temporary orders, it specifically lays out specific possession periods for Mr. Huddleston. And on page 3, it says undesignated periods of possession. Mom shall have him at all other times. She's not violating orders. She is just adhering to the agreed temporary orders that are in file. She has made the child available. As soon as we got a call from Ms. Harkins and they said, let's do summer period of possession, the first argument that we got was, hey, he'd get 42 days if he had the over 100 miles. We said, great. You know, this is a 5-year-old who has been diagnosed with autism by a primary care physician. Another licensed professional counselor has referred him to a specialist to get a detailed diagnosis, which mom started working on, but that person couldn't finish or decided they wouldn't finish because they had gotten too many calls from lawyers and various other people subpoenaing records. And she just said, I'm not going to get involved in this. Mom is trying her best to make sure that the child is getting the care that he needs. That's what this is all about. She's trying to get him in to see another professional. She's not arguing that the child should have no relationship with the father or that he can't get any treatment in Texas. That's not at all what she's saying. What we have heard again and again from Mr. Huddleston is he just doesn't believe there's a problem with his son. He testified that in his deposition. He doesn't believe that he has autism, and he hasn't done anything to take the child to try to get a professional to diagnose the child. What we're asking for is, you know, an opportunity to argue our case on the 17th, and by the same logic that was given to us, he can have 42 days. We would like the 2 non-consecutive weekend periods of possession that are built into the family code on the same logic that was given to us, or just some period prior to the final trial so that mom can see her son and it not be, you know, almost a month and a half of going away from the mom after he hasn't spent more than 10 days away from mom in 2.5 years. That's the simple request that's before the court, Judge.
And Ms. Harkins.
Judge, I said most everything I had to say in my report. I would just say that based on what Mr. Conley just said, I think it was me who initiated the summer possession conversation back early May. And I didn't start with 42 days. All I said was, I think it would be good for Peter to spend a good portion of the summer with his dad from the time school gets out until the time that we come back for court. I understand the argument. He's been there 10 days. Why suddenly let him go longer? But I haven't heard any evidence and I haven't seen any reason why. He's happy here. I've seen him here and he seems happy. So, and from what Ms. Chambers told me, he wants to be with dad. He likes spending time with dad. So that's why I've recommended what I've recommended.
All right. I find that I have subject matter jurisdiction and jurisdiction over the parties in this case. I'm modifying the prior orders to include that if the mother gives a written notice by Friday, June the 16th of 2022, the mother shall have possession of the child on any one weekend beginning on 6 p.m. on Friday and ending on 6 p.m. on the following Sunday. So, I mean, that's basically the extent of my order. It's sort of just the one weekend. And so I also need to add this, of course, Father's Day weekend is off the, can't be Father's Day weekend. So just sort of the standard possession or type order. So it can't be this weekend because it's Father's Day weekend. So, and just the little logic behind my ruling is like, we only really have 4 weekends to go here. If we take out Father's Day weekend, there's not a whole lot. I don't think it's be fair that we do. Either she's going to have we don't have a whole lot of room to spread out these 2 weekends, so I'll just say 1 weekend's going to be enough.
And just to clarify, by 5 p.m. on June 16th.
Well, it just says in the standard possession order, it just gives us a day. So if you want to
Okay.
put a time on it, you can put a time on it. But in the standard possession order, it usually just says by April the 15th. That's sort of what I'm doing, is just going by the same language that's in the standard possession order, but I'm just changing the date to June 16th rather than April the 15th.
Okay,
I don't think
understood.
it doesn't need to be time, I guess.
I think it's just as long as before midnight, I think is what the family code would say.
Yeah, I think that's it. But okay, and now in regards to mediation, so Ms. Vickers, I sort of already heard Mr. Conley's motion for mediation. What is your position?
Well, Your Honor, the issue with the mediation, there's a couple of issues. First of all, while I almost never oppose mediation, I think in this particular case, we have a parent that lives in Georgia, we have a parent that lives in Texas. That doesn't seem to be changing anytime soon. Mediation, the heart of mediation is compromise. Frankly, at this point, there seems to be very little room for compromise. Most of the traditional ways of compromising when people are arguing about primary conservatorship are not going to be in existence for this particular case. I also am concerned that scheduling mediation in the next, basically at this point, 30 days, because we have to schedule it for our merits hearing, because I certainly think that we can't use that as an excuse to delay the merits hearing. I mean, and the other issue is, frankly, my client is of limited means, and at this point, he doesn't have any money to pay for a mediator. And so I don't see the value in this particular case for mediation. Again, I don't usually object to mediation, but in this particular case, I don't see that it's going to have a lot of value.
And Ms. Harkins, do you have a position on mediation?
I get both sides, Judge. I think I would have no problem attending mediation, except one of the issues will be finding a mediator with time that suits all the schedules before the final hearing date. So far, the two names that I circulated, Mr. Conley, you don't know this, but we've lost some of the dates on their calendar already. So I think that will be tough. But you know, I always agree to go to mediation typically. So I see both sides. I understand there's not much middle ground is what I'll say.
All right, and Mr. Conley, do you have, I already sort of heard your motion, but since I just allowed them to argue, I'll allow you to argue again.
Sure, Judge. Thank you. We had pulled some dates for a couple different mediators, and I had sent those to Ms. Harkins this morning. It sounds like some of those might have fallen off, but you know, I tell clients all the time, you know, at mediation, you have all the control. At trial, you have no control. That a judge is going to make the decision for you. And, you know, like I said, I took Mr. Huddleston's deposition. He sounds like a reasonable guy. You know, I am always sort of optimistic that there is an ability for two people to come to an agreement. I think it's better if you can come to an agreement, but I also understand sometimes we just have to try cases. I personally think it would be worthwhile. It's in the local rules that every case needs to go to mediation, and if not, you need to get clearance from the judge to basically bypass it. So I'm not trying to delay anything. We certainly want a resolution to this case in July as well. But if there's an ability, particularly David Willis, it looked like had some dates in June and early July. You know, I always believe it's a good thing for parties to go through that process.
All right, but Mr. Conley, I think the gist of Ms. Vickers' argument is that I don't think there's going to be any mediator that's going to convince your client that the child should live with the father. And I don't think there's any mediator that's going to convince Mr. Huddleston that the child should live with the mother. And if we can't get past that point, what else is there to mediate?
I understand that's Ms. Vickers' opinion on the matter.
I mean, is that are you telling me that your client would be willing to mediate to the point in which she would allow the primary conservatorship to remain with Mr. Huddleston and she would get some sort of visitation?
I'm not in a position right now to say what she would or wouldn't agree to at mediation with regards to something that's central.
All right.
I'd like to remain optimistic that with a good mediator that they can talk to both, that people might be flexible and open to certain proposals. But I don't think I'm in a position to say what she would or she wouldn't agree to.
Okay, then I'll ask her. Ms. Zoll, can you unmute yourself?
Yes, Your Honor.
All right, my question to you is, will any mediator or any persuasive person be able to persuade you to allow the child to remain with Mr. Huddleston and he be the one that has the primary conservatorship of the child from this point forward?
Honestly, Your Honor, no, sir.
All right, and Mr. Huddleston, I'm going to ask you the same question, so unmute yourself. Will any mediator or any persuasive person be able to persuade you to change the current court orders to allow your child to live in Georgia and the mother be the primary conservator of the child?
No, Your Honor.
All right, I'm not going to order mediation because I just think if we have two people with no middle ground, that mediation is going to be, especially in this case where we have people that can't really afford the mediation. So I'm not ordering the mediation in any sort of limit. And then there might be something about limitation of time. And if I remember correctly, in my standing orders, it says mediation must be ordered. And if you don't go to mediation, then there are time limits on trial. So I'm going to amend the standing orders to say that there are no time limits on the trial and will remain set for a 2-day bench hearing.
Understood.
All right. Anything else for the court to consider today?
No, Your Honor.
All right. Thank you, everyone, for being here. I wish you all the best of luck as you prepare for trial.
Thank you.
Judge.
Goodbye.
Did you know? Inmates can be charged for the cost of their incarceration. In Michigan, MCL 801.313(1A) allows for up to $60 per day.
Good morning, Your Honor. Kathy Kakish, Assistant Attorney General for the State Treasurer.
Thank you. State Treasurer versus Michael Kiernan and the University of Michigan Credit Union. File number 23-105-839-CZ. Time and date set for show cause hearing. Ms. Kakish appears and Mr. Kiernan appears. Counsel, you may proceed.
Yes, Your Honor. As indicated, this is the time and date for the show cause hearing that is being held under the SCAPRA, which is the State Correctional Facility Reimbursement Act. I did submit a show cause hearing brief with 3 exhibits, and Mr. Kiernan was served with the brief and the 3 exhibits, and a copy to the court was provided. Your Honor, in sum, what I have to say is basically what is in my brief, and that is going through the points for the SCAPRA hearing. First of all, Mr. Kiernan is a state prisoner, and he is subject to the jurisdiction of the Michigan Department of Corrections. He's been sentenced to a term of imprisonment where his earliest release date is March 27, 2033. And his maximum release date is in June 2052. Now, this court does have jurisdiction over the matter because it is the Huron County Circuit Court is the sentencing court for the underlying criminal conviction. Now, under Michigan law, Mr. Kiernan is indebted to the state for his cost of care. His cost of care through his earliest release date within the next 10 years, his earliest release date is in 2033. The cost of care is in the amount of $421,560. And attached to our brief is exhibit number 1, which is an affidavit from the Michigan Department of Corrections, which provides a breakdown for this cost. Now,
Ms. Kakish, what does that break down to in amount per year?
It really does not break down to amounts per year. It goes by the per capita payment of each facility per year. So they go to the facility and they go to see how much it costs for that facility when he was there at that particular facility. So basically, every single prison facility has its own costs per year. Now, we don't have, every year, things, the costs are different, Your Honor. So they calculate it by the year in which he was in that particular prison. Now, having said that, the affidavit of cost of care uses the final 2021 per capita figures. So that means the costs for 2021 are actual, but the costs for 2022 onwards are estimated costs. And of course, as time moves, we know that the costs will increase. So if he were to stay in prison through his maximum release date in 2052, we're looking at $1.2 million. But we definitely know that his earliest release date is 10 years away from now in the amount of $250,000.
By this point, you're probably screaming at me asking what he's in for. I wasn't able to find the actual docket, but I did find a couple news articles related to the original incident. And it appears that Mr. Kiernan was charged with OWI, operating while intoxicated, stemming from an automobile accident that happened back in 2022. He was driving just after 10 p.m. on June 25th in Hume, Hume Township, when he ran a stop sign and collided with a Yamaha motorcycle being driven by a 32-year-old father of 6. Tragic. Unfortunately, the motorcycle driver did not survive the accident, and Mr. Kiernan and his passenger were severely injured. He was charged with 1 count of OWI causing death, which could earn a prison sentence of up to 15 years, a second charge of OWI, which could add 1 to 5 years, and then his habitual offender status could possibly double the maximum sentence. And the reason he has a habitual offender status is that he has 5 previous OWIs. This actually makes his 6th.
Now, Mr. Kiernan has 2 assets. The first asset is an immediate asset in terms of cash, and that is found in the University of Michigan Credit Union bank account, where it currently stands at $32,000. Now, the money flows into that account on a monthly basis in terms of pension payments from the Nationwide Retirement Solutions, Inc. Now, he currently has 401A and 457B accounts with Genesee County that are managed by Nationwide. The total amount currently standing in those 2 funds, which are governmental private funds, is $679,000, depending on the fluctuation of the exchange market. Now, to the historical procedure, the facts of this case, on January 9th, 2023, this court entered an ex parte order which freezes the money flowing into the bank. It freezes the bank account itself. So the money is continued to flow into the account, but the account itself is frozen. And then later on in March, we learned, the state treasurer learned that the 2 retirement accounts are actually government accounts, not 401k accounts. 401k accounts are usually protected by ERISA. Government accounts are not. So that's when we learned about the nature of the accounts, we filed an amended complaint, and we named Nationwide as a defendant. Why? Because we really need to know from Nationwide if there's going to be penalties and the amount of taxes for going into these accounts. That we will discuss that further on in the brief. However, the ex parte order directs Mr. Karanen in the event that if he does not hire an attorney to send in writing to this court and to the Department of Attorney General any written objections he may have against this entire case. We have not received any written objection from Mr. Karanen. Having said that, though, we are aware of the fact that he is objecting to the disbursement of any funds to the state of Michigan, and he is, his argument will be related to the second issue in our brief, which is related to preferring creditors over his obligation to pay towards his cost of incarceration care. Now, there's no doubt that the funds in this case are SCAFRA assets, specifically that, as I mentioned, these funds are not protected by ERISA. They are governmental funds. So that is one issue. But the main issue, as I said, was that Mr. Karanen believes that the money, he has a house, and he wants to maintain that house, understandably. But we're looking at the next 10 years. His adult daughter, upon information and belief, lives in that house rent-free. So he wants his monies to be paid towards his mortgage to the house. That's my understanding of what his argument may be. But Your Honor, SCAFRA is very clear that, and the Court of Appeals and the Michigan Supreme Court, they made it exceptionally clear. And I listed various case names by these two courts in our brief. They made it very clear that a prisoner cannot prefer creditors over and above his statutory duty to pay towards his cost of incarceration care. Specifically, the Michigan Court of Appeals in Shaco, which is listed in our brief, 218 MISH-App 185, entered in 1996, specifically said that they are not going to entertain anything related to a prisoner preferring creditors over their statutory obligation to pay creditors. That's our information with respect to his argument. The only defenses that a prisoner has under the SCAFRA, generally speaking, are defenses that a court, a circuit court under the SCAFRA must take into consideration. And therefore, that's the third issue in our brief. The Court of Appeals has made it very clear that every single circuit court reviewing a SCAFRA case needs to take into consideration the legal or moral obligation of a defendant towards his minor child, spouse, or dependent. And that statute is basically one very long sentence. It reads from MCL 800.404, paragraph 5, and it reads.
I read it. You go get right to it.
MCL 800.404, paragraph 5 states, at the hearing on the complaint and order and before entering any order on behalf of the state against the defendant, the court shall take into consideration any legal obligation of the defendant to support a spouse, minor child, or other dependents, and any moral obligation to support dependents to whom the defendant is providing or has in fact provided support.
In conclusion, upon information and belief, Mr. Karanen is not married and he does not have any minor child or dependent. So, Your Honor, we are asking that he does have his full, he does have assets that cover his full cost of incarceration care. In exhibit number 3, we submitted a proposed order. We're asking for the full cost of care. We're asking for a portion from the bank and the remaining portion to be taken from the funds. Thank you.
You're welcome. I've just been advised that Nationwide is.
Hello,
Please state your name.
my name is Sonia Curran. I represent Nationwide.
SANIYAKHARE.
Yes, Your Honor. I apologize. I've been trying to join the live stream since 9 o'clock and it kept saying, host is in there. We'll let you know. To let you in.
Sounds like you have insufficient bandwidth because we're having problems. We're having problems hearing you, but you may proceed.
Can you hear me, Your Honor?
Yes, I can.
Okay, I apologize for the delay. I have been waiting in the Zoom host room. And for some reason, it just now let me in, but I did have a chance to watch some of Miss Packish, am I pronouncing your name correctly? Some of her statements on the YouTube live stream. But I'm counsel for Nationwide, and our position basically is that, you know, we would like to pay in accordance to the plan documents. And, you know, currently we are not paying anything right now, but what we would like, since the participant and the state have the same claim, we will pay as the court directs, but we would like the court to issue an injunction to both the participant and the state, so they cannot file suit against us once that decision has been made. And we are just waiting to pay in accordance with the plan documents. We're waiting on the plan documents. Get the plan documents, we will review and see if a lump sum payment can even be made per the plan documents. And once the court issues a decision on, you know, who needs to be paid, and it's in accordance with the how, which is the plan documents, we'll probably seek a motion for interpleader under 3.603 and pay in accordance with what the court would like.
Very well, thank you. Excuse me, Mr. Kiernan, your response.
Basically, I went through the documents Nationwide gave me. They said that they're basically said with my age and the type of accounts I have, the payments can be made. The only concerns I have is that the rate amount of taxation is taken out of the funds. So I do not have obligation to the state of Michigan or the federal government on the amount that's distributed, because those funds are taken pre-tax, and so tax will have to be taken out when there's a disbursement.
Thank you. Ms. Kakish, again, final argument and your response to a request for injunction, as well as the comments made by Mr. Kiernan.
Yes, Your Honor. With respect to the injunction, I do not understand. I heard the word interpleader. I didn't understand where that came from, but Nationwide is named as a defendant. So we don't know where the interpleader is coming from. With respect to the injunction, Your Honor, that is easily resolved. Normally, Nationwide did receive a copy of this show cause hearing brief and a copy of the final order. Usually what will happen is that somebody from Nationwide or their attorney would contact us to add and ask to see if they can add language to the final order. Unfortunately, it did not happen in this case. What we can add is a paragraph indicating that Nationwide shall not be held liable in implementing the terms of this of the final order. With respect to taxes, Your Honor, generally speaking, taxes are covered by prisoners because an asset is usually what a prisoner has. And we usually take from what is available. Taxes are usually paid out, are taken before a prisoner receives his assets. In this case, yes, I did contact Nationwide. I was unaware at the time that Ms. Kerr was representing them, and Nationwide did not inform me that they had counsel, and that was back on Monday. I did contact Nationwide and ask them two questions. One, what the penalties would be for withdrawal, and two, what the taxes would be for withdrawing. I received documents from them, and those are the documents that I sent to the litigation coordinator at the prison, who handed them over to Mr. Kiernan. I believe it was delivered yesterday or the day before. And that's where Nationwide indicated that there is no penalties either for the state or the federal government. What we're looking at are taxes. The taxes are 20% for the federal government and 4.25% for the state. So I calculated it. We are asking for $393,000 and $393,000 from those two funds. If we calculate the 24.25%, the 20% from the federal and the 4.25% for the state, that means a total of $95,317 are the amount of taxes. Mr. Keranen has almost $700,000. There still will be funds left for him, Your Honor. Thank you.
All right, the court has heard the respective arguments of counsel as well as pro se defendant in this case. Based upon what the court has heard and the issue before the court as well is, and the court has to consider the legal or moral obligation of a defendant toward a minor child, spouse, or dependent. There is no minor child, spouse, or dependent in this case, and as a result, the court will grant the relief requested by the state in this matter. And I will require that the language that Ms. Kakis just mentioned a moment ago be added relative to the liability aspect of Nationwide. And that will conclude the proceedings, but Ms. Kakis, you have to submit an order to, actually you did submit an order to the court, correct?
Correct, Your Honor. But as indicated, that sentence needs to be added.
Yes, so I'll allow you to submit a supplemental order to the court for the court to sign. And can that be done within 7 days?
Oh, yes, Your Honor. I would contact Ms. Carey so that she would approve that language that, because they tend to use a lot of legalese languages in such order. So I'd get her approval. And yes, I can submit it under the 7-day order, or I can email it to the court.
Whatever works best for counsel in this case. That'll
Thank
conclude
you.
it.
Thank you.
This case was a bit of a roller coaster to watch and very unexpected. So instead of giving you the background summary, I'm just going to let you watch it and take the same journey I did, trying to figure things out.
Who do I have joining me from the jail? You in orange, what's your name?
This is James.
What's your name?
I said James.
Winhoven?
Yeah, correct.
Okay. All right, this is in the matter of James Edward Winhoven, file number 23-21410FC. I have Timothy Churchill appearing on behalf of Mr. Winhoven, and I have Isaac Sneed appearing on behalf of the people. It does appear that this is the date and time, double check, for arraignment in this matter. Mr. Churchill, do you and your client waive the reading of the felony information?
Yes, good morning, Your Honor. I would waive a reading of the formal information. Client would stand mute.
Okay. Have you received a copy of the people's request for discovery, felony information, and witness list?
Yes, I have, Your Honor.
All right. And are you asking the court to enter a plea of not guilty on your client's behalf?
Yes, I am, Your Honor.
All right. So, Mr. Churchill, this morning, Mr. Coast from Pretrial Services contacted us and prepared a motion affidavit and bench warrant. We weren't quite aware at the time that he was in custody because our records didn't show him in custody because his GPS tether was removed on July 3rd of 23. The device was returned to JSG monitoring. without getting it put back on. And I'm not sure what day he was taken into custody, but obviously he's in custody now. So what is he in custody on, Mr. Churchill?
Well, Your Honor, he's in custody right now on the 2 charges in this complaint. I had thought this is kind of an unusual situation. If you can bear with me a moment here. His bond was originally set in the amount of 100,000, 10%. That bond had other conditions too, that if he were released from jail, he'd have to have a monitor on, which he did. After the bond was set, about 4 days later, the victim found out the bond was reduced, had a fit, contacted the prosecutors, wanted bond reviewed, and the district court judge moved bond back where it was. He was then incarcerated. After posting, it was reduced to 5,000 cash, which was paid and then refunded after he was rearrested.
Hold on, Mr. Churchill. Hold on, Mr. Churchill. So the victim in this case requested a bond hearing?
Yes, was upset with the bond. We had a hearing on that last.
Hold on. Was there a bond hearing where his bond was raised?
Yes, back to the original amount.
Okay, got it. All right, go ahead.
Okay, well, as I said, his bond was reduced to 5,000. He got out. There were no problems, but the victim was upset, so it went back to 100,000 with the bond condition of the tether. He got arrested on the 27th, but due to his special medical needs and the fact he's autistic and on SSI and has autism and was having some major medical issues going on, you'll see a memorandum in the file where Judge Shadler stated that the parents could appear at jail and transport him to his medical appointments, which they did on July 3rd. He had an MRI of the brain that was scheduled a week and a half before that, but it was involved having to have a radiologist there for dye and contrast and all that. He was taken, and when they got him to the hospital, they found out he still had his tether on. So the tether had to be removed because he couldn't have any metal on to go in the MRI machine. And the parents didn't realize that until they were ready to put his gown on. Normally when they get returned to jail, they don't leave a GPS monitor on. And that's something we might need to deal with for future medical appointments. But so anyway, that's where we're at in regard to the bond issue today. And I was going to further ask if the court would consider a reduction in bond because of defendant's kind of unusual situation here. If I may allocute on that a second, Your Honor.
Well, Mr. Sneed, are you prepared to address bond in this case today?
No, this information is all new to the people, at least for me as of this morning. I'm covering for Mr. McCready. He'll be back in the office next week. I'd ask if the court would like to entertain a bond hearing that we have some time to maybe discuss this with Mr. Churchill about the conditions and follow up with the victim again regarding the current circumstance of the tether removal.
So, Mr. Churchill, because this is first appearance in front of me, and I only have a felony information, so I don't have much more information than that and what you've given me. I think in this case, I can set this for a bond hearing so that the people have an opportunity to respond. It appears that there's potentially a victim who would like to speak as well at the bond hearing. So, and I do have them in the courtroom and they would like an opportunity to be heard through the prosecutor as well. So I'm not going to address bond at this time, but I can give you a date for that and you could submit a sentencing or a bond motion and allow the people to respond, Mr. Churchill.
Okay.
Miss Adams, I'm looking for July 17th, something during the week of July 17th. for about 30 minutes. Could be Monday, Tuesday, Wednesday.
Your Honor, could the court allow me to run and grab my schedule? It's 2 offices.
Sure.
over. Okay, sorry. I didn't
Sure.
have- Okay. Momentarily. I'm back, Your Honor. The 17th is fine if it's in the morning.
No, Mr. Church, I'm waiting for Miss Adams to give us a date that week. Hold on.
Judge, we could do Tuesday, July 18th at 10 a.m.
Mr. Churchill,
Yep, that'll work.
Mr. Coast, or I'm sorry, Mr. Coast, I know you're here. Mr. Sneed
That Tuesday, July 18th.
at 10 a.m.
Yes, that's fine for the people.
All right, so I'm gonna set it for a bond hearing and pretrial conference on July 18th at 10 a.m. And is there anything else? And I'll enter a plea of not guilty on his behalf. And we'll see you back July 18th at 10 a.m.
And
Thank
there's
you.
a few other things I want to advise the court of. I will be talking to the prosecutor to stipulate to filing a motion to have the defendant forensically examined for competency and criminal
So,
responsibility.
okay, so Mr.
Just to
Churchill,
let
you're
you know
making,
where this is heading.
hold on. So Mr. Churchill, you're making a motion for forensic examination as to competency as well as criminal responsibility?
That is correct, Your Honor. Yes.
All right, so I need you to submit the paperwork for that today.
Okay.
Mr. Sneed, any objection to that?
No, Your Honor. Thank you.
All right, so Mr. Churchill, you could submit the request for competency as well as criminal responsibility. I think those take about 60 days, so go ahead and submit that. I'll need 4 copies of each request.
Okay.
And then I'll
will-
sign them on receipt. And then they'll get returned to you and you can send that, a copy of each of those plus a copy of the police report to the forensic center.
Okay, very well. And one other thing I wanted to advise the court of, my clients advised me that the victim in this matter is the niece of the chief prosecutor there. And maybe asking me to file a motion to disqualify the prosecutor in this case because of the relationship with the victim and Ms. Weiss, the chief prosecutor. But I'm not, that just came to my attention this morning. I've not had a chance to address it.
Okay, Mr. Sneed, all right, so Mr. Churchill, you can file that motion and have it ready for the 18th as well.
Very well.
Mr. Sneed, do you have any information on that?
I'll have to look into that, Judge, and we
Okay.
can reply to the motion accordingly. Thank you.
Okay, all right, so Mr. Churchill, you can submit that motion for July 18th as well.
Very well. Okay, thank you, Your Honor. I'm sorry, we had it down at 10 o'clock. District said be here at 10 o'clock for arraignment on the 5th, and I guess you were calling me earlier and,
My arraignments are 8:30 in the morning.
okay, I was given time for the info.
I'm sorry, District Court gave, it's okay, District Court obviously gave me the wrong date and time. All right, so we'll see you back on July 18th at 10 a.m. Thank you.
Thank you, Your Honor. Have a good day.
Okay, so after watching that, I really didn't know what to think. Disability, possible competency issues, bail revoked because of the victim, and she's the prosecutor's niece. I was a little confused, but then I realized I didn't even know what he was charged with. So, of course, I had to look that up. And he has 2 charges. The first one is kidnapping. The second one is criminal you-know-what conduct, assault with intent to commit you-know-what penetration. I haven't seen that one in a while. So that's pretty intense charges. Okay, so maybe it kind of makes sense that he's locked up. And if it was that serious of charges, was there something in the newspaper? Gotta Google that too. I ended up on Facebook, and on Facebook there was this post. It was actually made by the victim. And there is a picture of a flyer that is posted on a corkboard, And in case you can't read it, it says, one of our workers was physically attacked on 6/15, and while the attacker was arrested, he was then released back into our community on a small bond. We need to come together and protect our community. Call the prosecuting attorney's office at phone number and let them know that we, as a community, are not okay with this. If there is no answer, please leave a message. Tell them that you do not feel safe with James Winhoven out in our community. And there's the little hangy tags to pull down the phone number. And I said, okay, that's unusual. And the message at the top is actually from the victim as well. I've copy and pasted it. These are not my typos, so don't yell at me. I will own my typos, but these aren't mine. I'm asking anyone to please message me with any info on James Winhoven that could be useful to put him back in jail. Even if you think it's small, anything will help, as most people know they let him out. He was very clear with what he was planning to do to me, had no problem telling cops that it was him and his motive was kidnapping and to R-word me. No, I wasn't his first victim either, but who's next if we don't work together to put him back where he belongs? So please, anything anyone has or knows someone that has info that will help, please message me. I thought that was a little interesting too. You don't usually see a victim posting on Facebook. And then I scrolled down and it just so happens that there is a video of the actual attack posted by the victim on Facebook, along with several photos of the defendant. And she posted the exact same message at the top of that Facebook post. And this is the video of the attack. As you can see, he drags her off camera over to the right. It appears that it's actually a cop like recording the security camera feed, and that's who makes the comment about the counter. But then the defendant runs back in front of the counter and out the door, and the victim is chasing him. So she chased him out, and I think the entire video is less than 30 seconds, and that is the entire incident from what she is saying. So I don't know what to think. What do you guys think? Should he have been put back in jail with his bond conditions changed? And have you ever heard of a victim being able to get a bond reconsideration hearing? Because I don't think I have. Let me know. Thanks for watching as usual.
Boston, can you hear me?
Yeah.
Okay, Caitlin Boston, you just hold on a second here. You know what we need from you, Caitlin, is what's that? We need a good address for you, a good mailing address.
You can have my mom's address.
Okay, hang on just a second. Let's see how long this warrant's been out for you. Caitlin, we can't have you just blowing off court. You got to show up when we want you to show up, you know.
Okay.
The case is came from June 2021. So the case is over 2 years old. And bench warrant quash was set for May 25th of this year. And you weren't present. So we're just having a heck of a time getting you here.
I know.
Well, are you living in Forks or Port Angeles?
In Port Angeles.
Okay. And you know how to do Zoom yet? Do you have a telephone or tablet you can do Zoom on?
I don't have a phone right now.
Okay, so what you're really telling me is I don't have a good reason to quash the bench warrant. I'm probably going to keep bail right where it is, unless I know I can get you to court. And if you don't have a phone, you can't.
My mom.
What?
Well, my mom lives in Forks, and she is. I think she's willing to help get me to court.
Yeah, well, see, we got to get past the I think, and we got to get to the I do. So we're kind of past the, you know what I'm gonna do, Caitlin, is if Melissa, if Clown Public Defenders is off the case, we want to put them back on.
Okay.
And so I got a problem here, Caitlin, because we don't actually have court on the 3rd. We got 4th of July is on Tuesday, so we're not coming back till the 10th. And right now I'm going to keep bail right where it is. I can't change bail. I know. I don't want to do that. I don't want to do that to you, but we've already been through this 2 or 3 times. You call the court.
My mom, I promise that my mother will help me get to court.
Well, your mom needs to get in here and talk to the prosecutor about that, because I'm not going to do anything different until she actually talks to the prosecutor. Right now, we're going to keep bail right where it is, and we're going to come back to court on July 10th. And you're going to have your attorney, Mr. Kressel, and we'll let Mr. Kressel know that he's been appointed to represent you. And if Mr. Kressel and Mr. Fleck can work out a different arrangement, we can always change bail after Mr. Kressel and Mr. Fleck have had a chance to talk. But right now, what I'm looking at is we've been through this at least twice, and so we're not going to change bail. We're going to keep bail right where it is, and we'll see you back here in court. If you do get bailed out, we're going to need to see you here in court at 1:30 on July 10th. July 10th is a Monday, so we'll see you July 10th at 1:30. Okay.
Okay.
See you then. Thank you, jail.
Thank you, Judge.
Hi, good morning. Listen, I said bail on you the other day because you weren't here and I wasn't sure what your situation was. It sounds like you turned yourself into jail after talking to your dad. Is that what happened?
Yeah.
Okay. So I'm a little bit concerned about you because I don't really know what your living situation is. And I'm concerned about you using when you're out. So here's what we're gonna do. We're gonna keep the bail right where it is right now, okay? You'd have to post bail to get out. And I'm pretty sure I appointed Clown Public Defenders to represent you. So, you know, Doug Kressel's gonna be your attorney. We're gonna let Mr. Kressel know that you're in custody. Now I got $2,500 cash on both cause numbers. Do you think your dad's gonna post that bail or not?
Yeah.
Okay, well, we're gonna bring you back to court on July 10th. We're not gonna bring you back next week. We're gonna bring you back on July 10th at 1:30 in the afternoon, July 10th at 1:30. Clown Public Defenders represent you. You're gonna have to post $5,000 cash to get out. You can have no new criminal violations. You're gonna have to abide by all no contact orders of the court. So for example, the private property that you were on that day, you can't go back to that address. Anyway, we will see you July 10th at 1:30, okay?
All right.
Okay.
Not happy. Hi, who are you?
Pardon?
Who are you?
John Dahlgren?
Well, that's an old
You're here for the ticket.
Yes.
I'm not gonna wear my robe because Dahlgren won't care if I don't wear a robe.
Come on up.
All right.
That's a 3A02939335. How you doing, Dahlgren?
Good, good.
You staying honest?
Oh, yes.
I figured.
That's why I got the seatbelt ticket, because he asked me if I was wearing my seatbelt. I says, no. I says, okay, well, I'm gonna give you a ticket. I was just honest. So.
Well, why weren't you wearing a seatbelt?
Oh, I'm in and out all the time. You know,
I do. But why? What are you not still working? Are you? Is that why you're in and out?
I start late and quit early.
No, but I mean, are you cruising timber? What are you doing when you get in? You cruising timber?
No, not cruising timber. Side riding, just making sure the operations.
Yeah. Oh, I see. So you're actually,
you're
actually still logging.
Well, yeah, I'm not out there setting triggers. I can't do that. You know that. But yeah,
I do know that.
Hey,
we're old.
Oh yes.
Well, Dahlgren, you criminal, can I borrow your pen? We're gonna let this criminal go.
All right.
You okay with me letting you go?
Oh, certainly.
Just don't get in an argument with that guy and have him bring that up. Dahlgren, he's been around forever.
Oh,
Dahlgren's been
yeah.
logging since before Noah. All right, you're gonna get a copy of that dismissal, okay?
Okay,
Don't make me stupid.
no. I won't. No, I won't.
I know you won't.
I know I'm all good.
So he's in custody on the Superior Court matter.
Right.
But what I'm asking the court is just bump this to July 10th so I can have a better assessment of what we're doing with this current case. At the very least, there's some witnesses listed that are probably going to be a bit of a challenge to contact, and that my investigator is trying to do some follow-up. But those are all issues I need to discuss with Mr. Hillstrom. So I would ask us to put this over to July 10th for status.
Mr. Murphy, that sounds very reasonable. Are you okay with that?
It's fine with me, Your Honor. I would like to address conditions of release, though.
Oh, yes, go ahead.
So originally bail was 10,000 cash or $100,000 bond, and then that was set May 25th, and then on June 1st, the court ordered the bail to $2,500 cash or $25,000 bond. I think based on Mr. Hillstrom now being in custody on assault 2 and assault in violation of a court order, domestic violence, in the same person, I would ask that bail be increased back to the 10,000 cash for $100,000 bond.
What was the date of the new offense?
June 9th. June 9th.
So that's happened since we found probable cause on this one.
That's
is what
correct.
you're saying.
Yes.
Mr. Kressel, he's making a good argument.
And unfortunately, it's new information. I was out of the office last week. I did see the probable cause statement. It appears to be involving the same person.
Right.
But other than that, I can't really address, and I would just reserve.
Well, Mr. Hillstrom, I don't have the probable cause for the new charge, but part of why I lowered the bail was on the strength that you weren't going to have a new offense. Given that there's reason to believe you have violated the court's previous order, bail on this matter on the 679800023 is now $10,000 cash, which is where we started. Let me grab my water. So $10,000 cash on that now. He's not getting out until they post another 7,500 on this one.
So, Mr. Hillstrom, this case is being set over. Next Monday is technically a holiday and there's no court. So we're putting it over 2 weeks. You also have court on Friday. I'll be down to see you to discuss these issues, but you have court in Superior Court on Friday as well.
Okay, county jail. Is that it for the county jail, Melissa? Okay, thank you. Now we got Kettle. There's Kettle. Is that Kettle?
Yeah, Mr. Kettle's going to be a change of plea. We got 3 case numbers. He's been in for a chunk of time. I just need to find my file. Here we go.
That's not food. No, never mind.
So he's going to be entering a guilty plea. I'm not sure where you want to start. We got 67960023, which is a violation of the no contact order. 6627-0022, which is a DUI. From a period of time ago, this was the first one in the series. And then the most recent was 665-00023, which was an assault charge. He's been in custody for a good chunk of time. Some of the issues is that he's in the county jail, and logistically, it's hard to coordinate things, but I think he's got a couple of months under his belt.
Okay, before I start filling out J&S, are we doing a plea on the alcohol offense, the DUI?
We can start with that one.
Okay, I just need to make sure I got the right J&S. We got 2 J&Ss.
We got 2 J&Ss. One's a DUI for over a 0.15, and the other 2, we got an assault 4 DV and a violation of no contact order DV. The recommendation total, if I'm remembering the state's recommendation, I think it was 30 days total. And he's got like probably a good couple months under his belt. But I will hand up the plea of guilty on 662700022, which is the DUI over a .15. Recommendations, mandatory minimum 2 days, 5 years probation, all the standard DUI conditions, drug and alcohol assessment, apply with any treatment, DUI victims panel. I believe, if I'm remembering correctly, he had an assessment, but I know he's been having some challenges being in the county jail. And there was an assessment, and then he had some medical issues. That assessment has since changed. But he's gonna have to get up to speed and probably get that updated when he gets back out, especially with everything going on.
And Mr. Kettle, I'm jumping ahead a little bit. You intend to stay here in Forks, maybe live with your family, don't you?
Yes, Your Honor.
Okay.
And Your Honor, yeah, that kind of, the other two cases, I believe one involved his mother, if I recall.
Yeah, that was no contact. I think.
And I think at some point, I know the no contact order was lifted because she was providing transportation everywhere.
Right.
And then there was a civil no contact order that was entered, but I think that one was also lifted, but I'm not sure on that.
I'm not sure. I did it on a Thursday or Friday, and then we had a violation. We haven't gotten to that one. So.
No, we haven't gotten to that one yet, but I think if I'm remembering what my client has told me correctly, it was set for a civil hearing and either she didn't show up or it was stricken. So, but I'll rely on the court's information because I don't have that.
All right. So on the 6627-22, Mr. Kettle, I'm looking at a statement of defendant on plea of guilty for DUI over a 1.5. Says you're age 30, you got through the 12th grade. I'm assuming that's here at Forks High School. And I'm sure it was, you know, the maximum is 364 days in jail, $5,000 fine. When you plead guilty, you're giving up your right to a trial by a judge or jury, giving up your right to remain silent, giving up your right to hear and question the state's witnesses, giving up the right to present your own defense. You're giving up the presumption of innocence to make and prove the charge beyond a reasonable doubt, giving up your right to appeal a finding of guilt. I'm not bound by anyone's recommendation. You understand all those rights, don't you, Mr. Kettle?
Yes, Your Honor.
Says here, your statement is on December 16th in Clallam County, I drove a motor vehicle with a BAC of 257 and was too impaired to drive. I'm assuming that's your statement. You went over this with your attorney, didn't you?
Yes, Your Honor.
And I remember there was a factual basis. I just reviewed that, but I happen to remember this. So I'm finding there's a factual basis for the plea and that it's knowingly and voluntarily made. Now, how come Mr. Kressel and Mr. Murphy, we got a recommendation of 2 days?
This
mandatory minimum is 48 hours for DUI over 1.5.
Correct. And this was his first DUI. He doesn't have much history.
Right.
This is kind of a classic case of someone who's had some issues for a period of time, but been able to stay mostly out of the court system. But in the last year or two, it's kind of snowballed. But he had also, after this incident, basically a near-death experience, was in Harborview. And so let's just say Mr. Kettle has had some eye-opening experiences in the last year and a lot of time to reflect. He does need treatment, that's without a doubt. But we're probably going to need an updated assessment to see exactly what level of treatment, because he had an assessment done right after the DUI, then all this stuff happened. It was a matter, I don't know if he still needs residential treatments or if he's just been sober long enough he needs IOP, but he's definitely going to need treatment supervision. It's just, I don't know what level.
Right. So, Mr. Murphy, I don't know if you have an emergency response fee in mind. Mr. Kettle he's been in and out of jail.
There's on here 133.16, if I'm reading the handwriting correctly.
Is that what that is? 133.16, Mr. Murphy?
If it's written by me and it's badly done, yes, I think it's 133.16.
It looks like 133. It could be 153, but it looks like 133.
133.63?
What, 133.16?
16. Okay, so,
Yes, it's 133.16. I can confirm that.
I'm only going to order the emergency response fund because Mr. Kettle, when's the last time you actually worked, Mr. Kettle? Do you recall?
It's probably been like 8-9 months.
Right, and he had a serious hospitalization. I want him in treatment. I don't want him spending money on anything else. So your total legal financials is going to be the 133.16 for the emergency response fund. The biggest thing is, the biggest things are you can't drive a motor vehicle without a valid license or while impaired under drugs or alcohol of any kind. You can have no new criminal law violations, have to comply with the rules and regulations of the Department of Licensing, including an interlock. This is the page I messed up last time. Probation for 60 months. Now, go ahead.
And Your Honor, I believe, because I have a couple different recommendation sheets. One was from the DUI and then one was from Global. I think the concern on all of these cases, aside from the addiction issues, there may be co-occurring issues.
Right.
So I think the state's requesting, if I'm reading the offer sheet correctly, of both the mental health assessment and the drug and alcohol evaluation.
That's right.
Okay, so I'm checking off that he needs to provide a new and updated substance use disorder evaluation, but also a mental health evaluation. I need him to start that within 30 days of the judgment and complete both of those within 180 days. I don't know what our current assessment availability is in Forks, but it's got to be done sooner rather than later.
If he's in Forks, WEO should be able to do co-occurring assessments.
Right. So Mr. Kettle, when you're on probation, if Ms. O'Brien tells me that you're not calling her or that you're not getting an assessment or that you're not showing up for meetings, I'm just going to put you back in jail.
All right, Your Honor.
Well, I know, and I hate doing it. I don't take pleasure in that. I just got to make sure you don't hurt yourself goofing around. And all of that is going to be per treatment / probation. Whatever Ms. O'Brien tells you you got to do, you got to do. Can't use alcoholic beverages or non-prescribed drugs at all. Today is 6/26/23. You can look this over, Mr. Kressel. I tried to check every possible box to make sure we don't miss anything. Only LFO was the 132.
Yeah, and that's much appreciated. So Mr. Kettle, the judge cut you a huge break financially, basically imposing just the 133.16.
Okay.
But you have both, you need both the mental health and the drug and alcohol assessment, because the concern is there may be a co-occurring issue, which both issues need to be addressed. And that can be done through WEOS. And then presumably a DUI victims panel, and you're going to be under supervision of court's probation on the DUI for up to 5 years, but you'll only be on active probation while you're in treatment. But if you get new cases, the court's going to have a whole bunch of jail time to play with on all three of these cases. So you want to make sure you follow through.
And I can't drive unless I have an interlock, right?
Correct. And that's going to be between you and DOL. But yes, standard conditions for DOL is going to be an interlock. It's going to require SR22, relicensing fees, and there's a whole bunch of things you're going to need to do to get your license back. And then I'm just going to hand up these other two forms. You got 665-00023 and 6796-0023. One count of assault for duty, one count of violation of a protection order. and hopefully the math is correct, but the intent was all three of these added together is 30 days, and he's probably got a couple months under his belt.
Okay, the six, well, again, Mr. Kettle, you already know this. You're giving up your right to a trial by a judge, a jury, giving up the right to present a defense. Maximum punishment for both is 364 days in jail, $5,000 fine. I'm not bound by any agreement. If I thought you needed to do a year in jail on both of these, I'd do it. And trust me, if I thought you needed that, I would. Do you understand all those rights?
Yes, I understand, Your Honor.
Okay. So on the 679623, it says on May 13th, 23, I violated the terms of a no contact anti-harassment or protection order with a household member, and I had just signed that order like 2 days before or something.
Yeah, and if I recall, this is the one, I don't want to be mixing up the case. I think he was asleep on the
porch or something.
Porch, yeah. But yeah, but as far as the status of that, I don't know the status, if that was still in effect, or if the mothers didn't come to the hearing, or, oh, here we go.
What's it say? What did she tell you?
No show, it was dismissed and closed. Okay, so
There
it
you go.
appears the civil no contact order is no longer in effect.
Okay.
So I will defer to the mother's wishes. I know she was helpful with
Yeah.
Mr. Kettle in the past, but
Right.
if there's not a no contact order currently. in
Well, the
effect-
problem we had is when, and you know this, Mr. Kettle, if you start using, you scare your family.
Oh, I know.
So hang on. I know. We all know now.
Sorry.
Everybody knows. That's all right. So anyway, on that one, violated the order on May 13th, and then on this one, January 7th, this is the 6650, January 7th, in Clallam County, I intentionally touched or struck another without their consent and not in self-defense, household member. I'm gonna find that both pleas were knowingly and voluntarily made. Now, let me just, and that there's a factual basis. Let me do the 6650 is the assault 4th degree. 4th degree, and the 6796 is the VNCO. Okay, and they are both domestic violence because they are household or family members. So on the
Yeah, and I explained to him that this, I believe it's a moot point because he may have, I thought I saw something in there that suspended his firearm rights, but if not, both the assault and the violation of no contact order would suspend his firearm rights until reinstated by the court.
Right. So the 6796 is the 364, 352. So let me see, that is 8 and that's 12, and then 5 is 7. How many days does that add up to in your mind, Mr. Kressel?
I was getting 29, but I could be off. I was getting 12, 15, and 2. I don't know if the court wants to do
12, 15, and 2. That's right.
That would be 29, or if the court wants to do 12, 15, and 3. Either way, he's got a couple months under his belt, but.
Yeah, so, oh, there we go. Notice of ineligibility of a firearm. Might as well do those here pretty quick. Okay, so I have a total of 15 days on one and 12 on the other. Total jail time. And we think he has a total of 27 days here. And we think he has credit for 27?
Yeah, the latest violation, which he's in custody for, was on May 13th. So it's already June 26th. So he's probably has about 6 weeks on that. And then on the original DUI, that I think he was in for about a week or so. But yeah, it's expected he's got the credit.
Well, and Mr. Murphy, I don't have a good reason to impose any illegal financials on Mr. Kettle. He's, Mr. Kettle, how's your mental health lately after your last 6 months? Are you functioning? Well, how are you doing?
Yeah, I'm doing better.
And you
Your
think
Honor.
you can get a job? You think you can get a job anytime soon?
Yeah, that was my plan.
Okay, what we're gonna do then on this one is he can pay court costs of $200, and then a conviction fee of $43, so a total of $243 on that one.
And Your Honor, I would request
$244.
the $100 domestic violence, $15 domestic violence assessment.
Okay, let me get that right box. Domestic violence assessment, $100, so the total is $343.00. It's the same thing though. Now, on this one, Mr. Murphy, Mr. Kressel, do we want him on a probation on this one too or not?
Yes.
Okay, so we're gonna put probation for 24 months.
And
Go
Your Honor,
ahead.
for simplicity, it'd probably be best to keep the conditions the same as far as
Right.
requiring of drug and alcohol and
Yes.
it's not entirely clear if it's co-occurring, but
Right.
it's suspected to be. And so he should be able to get the services he needs here in Forks.
So attend meetings per treatment, same thing I said on the other per treatment, probation, can't use alcohol or drugs, obtain substance use evaluation, mental health evaluation. Any questions that Ms. O'Brien has, if I happen to miss a box anywhere, I'm sure we'll hear that, because you are under supervision there, young man. We know each other now. We have some history, and I will remember you, I guarantee you. And if I see you in here because you're having fights at home or because you're using, I'm just gonna put you in jail for 6 months, no questions asked. So
I understand.
I know you do. I don't want to see you back here. I want to hear about you doing well. I want your mom to tell me you're doing well.
So Mr. Kettle, a couple things. Yeah, when you get out, you need to have an assessment scheduled for both drug and alcohol and mental health. And West End should be able to do that if you're in PA. There's a number of agencies that can help out with that. But for the DUI, you're also going to drug and alcohol, or excuse me, a DUI victims panel. But one of the first calls you should make is to Lorraine O'Brien. She's going to be your probation officer. She'll kind of walk you through that. The court's not imposing a separate no contact order, and it looks like the one that was in place is expired. So whether or not you can see your mom's between you and your mom, but your first step is getting in the treatment.
Sounds good.
And Your Honor,
How you
did the
doing?
court-
Yes,
did the
yes.
court receive the submission of a biological sample?
Oh, I don't think I checked that box. We do need to get a biological sample. I need to find that where that box is on that. It's somewhere on those. What is
And Mr.
that?
Kell, that just means a DNA swab, but just a little Q-tip on the cheek. It's no big deal, but they'll do that before you're released.
And Your Honor, I don't know if the form's been updated, but based on a recent, I don't know if it was the Washington State Supreme Court or the Court of Appeals, but that because he's indigent, that biological sample cannot be, or the fee cannot be imposed.
Yeah, I'm looking for ways to not impose fees on him at all. I'm looking for that box. Well, there's the DNA fee. I found that box, but I don't care about that. I care about the condition. Consumer awareness. It isn't page 1? I'm doing his firearm ineligibility while you're looking for that.
Yeah, if not, it can always be written in.
We can always write it in too.
And I also, I emailed Mr. Downing and Ms. Freeman a minute order regarding the biological sample.
Well, it's okay. I checked a box, which I think says that, and I put 2 cause numbers on one notice. So declaration. Here's the notice of ineligibility to possess firearms. I don't know if I
think Mr. Murphy's concern is sometimes the jail without a specific order.
Oh,
even though it might be in the JNS.
Right.
So if Mr. Murphy sent an order, I would have no problem agreeing to it.
Are you gonna send an order, Mr. Murphy? You want me to? Okay. Right, well,
Fine, yeah, it should be right there.
mine aren't either, obviously. I'm doing. Okay, I'm doing a minute order for the biological sample. Now, before I forget, I did an ineligibility of possession of firearms. Do I need, look at that. There's an order for submission of biological samples. Do I need a declaration of non-surrender for a firearm?
So that's connected with the order to surrender and prohibit weapons, and that's Mr. Kettle to enter if he has no weapons to surrender.
In
I
my
have no
understanding,
weapons.
he has,
I figured.
Yeah, my understanding, he has no weapons, so he would.
I don't know if you want to fill that out for him to sign or not. I'm working on the minute order requiring submission of biological sample, which somebody filled out.
Comes to the jail or?
Yes.
Okay.
Yeah, that's
Okay,
one. The
so-
non-surrender is something he signs. Okay, and I think this will cover it for a swab. I don't know if Mark typed it in real quick or if it comes that way.
I believe Mr. Murphy did that.
Oh, Murphy sent it.
I have a feeling Mr. Murphy's done this a few times.
Has Mr. Murphy done this a few times?
Maybe, just a hunch.
Yeah, they're gonna swab you, Kettle, because there was a domestic violence and that's just part of state record keeping. And the jail's gonna make sure and do that, we think. So does Mr. Kettle get out today?
It's expected he would. So he's gonna, Mr. Kettle, one of the first phone calls you need to make is to Miss O'Brien. And then also.
The sheriff's office took my cell phone. Do I go back to them to get it?
Any property taken, that's gonna be between, it depends where it's at. If it's in the jail, in your personal belongings, you'll get that when it was released, or excuse me, when they took you into custody. If it was booked as potential evidence, that may take an extra couple weeks, depending where it is. But if it was taken by the jail as part of your personal property, that you should get when you're released from the jail.
Okay, so that's it for the county jail. Kettle?
We got two for Forks.
Well, I know, we're going to go to the Forks jail here in a second. So I think that was it, county. I forgot that you had Kettle there. Or is that it for Kettle? Did we get Kettle all wrapped up?
I believe so. I'm not sure who's.
Now, Mr. Kettle, first thing you do is
see
get
ya.
in contact with, get in contact with Ms. O'Brien and make sure you go get your assessment and we'll be okay. You and I'll be okay.
All right, I'll call in a bit. Thank you, Your Honor.
Thank you.
Thank you, Your Honor. Matthew Tyler from Centerville and Zach Thompson from L&T Auto Repair. Will you both please raise your right hand? You swear or affirm any testimony you're about to give here will be true to the best of your knowledge and belief? Yes. All right. Mr. Tyler, this is a claim for $6,500, which is the statutory limit. You claim that L&T Auto did $10,000 worth of damage to your vehicle. Yes, sir.
I didn't. Why don't you just type it in? Mr. Zach Thompson, what is your position at L&T Auto Repair?
Owner.
All right. How come there's no Z in there then?
I'm unsure why it says Joshua Thompson. He has never Then an owner, registered agent for L&T Auto Repair.
Okay, well, he's suing L&T Auto Repair LLC. All right, now, Mr. Tyler, I had trouble frankly sorting this out. You claim that they owe $10,000. There's several invoices here, but they didn't add up to this. Now, this is a Ford F-150 pickup.
Yes, sir.
2013.
Yes, sir.
Is that even worth $10,000?
It's a Ford Rounder. It's about $50,000 truck. To be honest with you, you look them up. I had just bought the truck and I was doing a bunch of upgrades to it. I gave $45,000 for it, and I was having L&T was going to do a bunch of work for me, and in the process, they broke a bolt off in my engine, and I submitted pictures for it, and the thermostat. So they kept saying they couldn't get that bolt out. They couldn't get that bolt out. They drilled on it for like a year, they said, and they wouldn't give me my truck back. They kept giving me a loaner. The loaner kept breaking down. So I went through 2 loaners, probably 6 different times. They had to come and tow them back because they just kept breaking down. The brakes.
All right,
brakes
well,
went on.
we're gonna have to break this into smaller parcels here.
Yes, sir.
Also, do you have anybody else here from South Park Ford or anybody else that can testify?
I didn't know that I had to have them here. They gave me all the paperwork that
Well,
shows
you
that.
don't necessarily, but the burden of proof is on you. And
Right.
are you a mechanic?
I am not. I am not. CJ Auto Park Ford and his mechanics wrote notes in all the work they did to this truck for fixing it when it left L&T and went to the Ford dealership in Sturgis.
All right, when did you first take it to L&T?
I honestly cannot tell you the date.
What year?
20, the end of 21, I believe.
Well, I have a request date dated 11/16 of 21. No, wait a minute, that's a South Park. 3/27 of 21. You went to L&T Auto Repair for a engine oil pump, remove and replace,
Yes,
thermostat and gasket, ignition oil. You had $1,513.05 worth of work done on March 27th. On March 9th, March 29th, I guess, you had spark plugs, $1,300 worth of work. And that's it. So what did you employ L&T Auto Repair to do?
Okay, so this truck, it's a special truck and it has a supercharger on it. So this truck, it has a just a regular oil pump on it, and that's a weak point for these trucks. It's a known weak point for the 6.2 liter V8 Ford engine. So I took it to L&T to have them put a billet oil pump in there, so I wouldn't have any problems with it. You know, so I could go out and have fun with my truck and use it for what it's used, what it's used for. And then I was having them do new shocks, new spark plugs, lights, front and rear lights, like backup lights. They're for this particular truck, a rear brake light was $1,500. They were installing that for me. They were installing the fog lights for me, and all the suspension, which was about $6,000 with the suspension.
All right, well, how do we get from that to where you believe they owe you $10,000?
Okay, so I went to L&T finally to get my truck back, and finally to get it back, I had to call the police to get it back. So I got my truck back, and as soon as I
All
left
right,
their
so
shop.
slow down.
Okay. All right.
When did you get it back?
It was a year. They had it a full year. It would have been the day before it went to Ford. When I took it to Ford the very next day. Everything
Well, the Ford stuff is dated January 13th, final, and open date 11/16 of 21.
So L&T had my truck for 13 months.
If I may, Your Honor, he is right. It was there for an extended period of time. These invoices, since they were paid, they were closed out. I could not provide. If I looked back through our records, I could provide an exact pickup date for it, but I just currently do not have that in front of me. But it was there about a year.
All right, so it's there 13 months, so that's a drag. You can't use your truck through all 4 seasons. So you had to call the police to get it?
So what I did is I went in there, and they wanted to give me my truck back, but they wanted me to bring it back the next day because they didn't install the body protectors on the bottom of the truck. They're called skid plates. So they didn't finish installing those, and there's a couple other things they wanted to finish up, tidying up. I'm like, no, I was like, I don't want you guys to touch this truck no more. And they're like, well, and the bill was paid. I 100% paid them. I didn't owe them any money. So
All right, just a minute. How much did you pay them?
I think about 4,000.
All right, well, this isn't where we're just sitting around the kitchen table. This is a lawsuit, so you got to establish the total that you paid.
Well, I submitted all the paperwork to the court. I didn't know that.
Yeah, but you're the plaintiff. I'm not supposed to like figure it out, but I often do. I got one bill for $1,513.05. I got another bill for $1,340.09. And then I have something from Livernois Motorsports for $774.50.
Yeah, that was for the thermostat they installed. They broke it. They broke my Livernois thermostat when they're installing. So they broke that, and then so to put the oil pump in that in, put the oil pump and the thermostat in, they pretty much had to take the whole top of the engine off. They did take the whole top of the engine off. They broke a bolt inside the engine, is what caused all this. They never could get that bolt out, so they took this glue, this orange silicone glue, and glued the engine back together. And that's what Ford's trying to say, and they gave, they gave you supporting pictures, and they're saying that all this damage, this is Ford, notes that the damage was caused due to the work that L&T did on my truck.
Now, I might be missing something, but I don't think I have any pictures. I don't think I have any pictures.
I have pictures.
Just a minute.
I thought everything got submitted.
Maybe in here and I'm not seeing them.
So Ford took
Just a minute.
pictures.
I don't have any pictures. All right. No, I don't. I don't know who is they who submitted pictures.
So me and my wife or who submitted them, but we didn't take them. Ford took them because Ford noticed all the problems that they were having when they started digging into this engine. So Ford started taking pictures.
When you say Ford, you're talking about Auto Park Ford in Sturgis?
Yes, sir. So there was CJ, which is the head of service, which L&T even called and talked to him. And then there's their master technician that did all the work. And they were both taking pictures, CJ and the master tech. I don't know his name, but I do know that he did put notes. There's notes at the bottom of the Ford bill, and it tells you what was wrong and why it happened. You know, what caused it. You know, like I can't believe the pictures are not there.
Well, you're the plaintiff, and so
Yes,
you
sir.
have the burden of proof.
Yes, sir.
I have a couple of invoices from Auto Park Ford.
Yes, sir.
That are hard to determine. How much did you pay Auto Park Ford?
About $18,000 total, but they did other work too. I had other stuff done. Everything wasn't L&T's fault.
Can we provide the invoice for the 18,000? I'm showing just.
Well, I
on
don't
motor.
see him. Now, Mr. Tyler, this isn't as easy as you thought it was. You're in your car. You don't have any documentary evidence. You don't have any of the receipts in front of you. You're just shooting from the hip, trying to go off the top of your head. And this is a lawsuit, and you're the plaintiff, and you have the burden of proving it. There's no pictures, and I have to like try to figure out what's what from looking at the invoices that you don't have in front of you. So I'm not that smart. I have 3 invoices from South Park Ford that are part of this complaint.
I didn't submit the ones that didn't have anything to do with what L&T, you know.
Right. Well, the ones that you have don't add up to $10,000. Mr. Thompson, you have them in front of you?
Yes, sir.
All right, well, let's go to the first one.
Okay.
Diagnosis number 1.
Yep.
Vehicle has no oil, believes the drain plug may be loose. Please advise. There's no dollar amount attached to that.
And the reason behind that, sir, is because that was under his service contract, with probably with Ford. It was either aftermarket or it was still on the truck. I'm unaware. I have a better idea for that. But that's something that Ford covered on behalf of him.
So there was no charge to him for that?
No, sir.
Ford, I have aftermarket. I have aftermarket warranty that I paid $3,000 for. They paid $1,100, and L&T knows that.
All right, let's go to the next thing. All right, at number 2, install new rear leaf springs, $674.78. Did you have anything to do with the leaf springs on this truck, Mr. Thompson?
No, sir. They were dropped off to us. We never performed the work.
Install front shocks and springs.
No, sir.
You didn't do that either?
No, sir.
All right, then, number 4, install brake light. Install fog lamps, number 5. Replace a fuse, number 6.
Yes, sir. That was.
Number 7, new thermostat, new oil pump.
Yes, sir.
Install front and rear facing camera.
No, sir.
Remove and replace valve cover gaskets that was covered under service contract. Then we have remove and replace camshaft timing solenoids. Did you do any of that work?
Yes, sir.
And then 11, remove and replace idler pulley. Then the variable 900. So he has what I see here as a bill from Auto Park Ford for $3,298.
Yes, sir. And when I went through and tallied up what, I think would fall on us, I came up with a total of $1,150.16 for the things that we named off.
I agree with around $3,000. I don't know why some of those bills are on there. He is right on the camera. They did not install the camera. They did not install the shocks. They did not install the leaf springs. I didn't know that, they did not do those. He's absolutely right about that. But
this is a long way from $10,000. Well, let's hear from you, Mr. Thompson. So you believe you could be responsible for $1,150.15. What happened? I mean, obviously you don't want to take somebody's vehicle and keep it for a year and a month. And what happened?
To keep the long story short, we had a mechanic and service manager that thought they could take on a little more than they could. And it was always a different story. I'm not actively involved at the shop every day, so it's hard for me to be down there every single day to get an update. So I'm going off their word, right? With that being said, they were feeding me this, feeding me that, saying, it's going to be done this day. And then I get down there, the next week, it's still not done. And it's always something else. And it was truly just them not getting it done. Whatever the reason is for that, whether it's, them just simply not doing it, them not knowing how to do it, them scared to work on it, I can't tell you. None of those employees are still employed with us, and they haven't been for, the service manager's been gone about 6 months now, and that technician has been gone for over a year, for multiple reasons like this. And, we tried to, sit down with Mr. Tyler and his wife, one day, and, it turned into a whole fiasco. It was, we met at the Wendy's on, 131 there right in front of the Tractor Supply, where Mr. Tyler started throwing insults and attempting to fight us in a parking lot. And, we were trying to resolve the issue. It didn't work out that way, unfortunately. We try to make every customer as happy as we possibly can, but at certain points, there's not much you want to do for a customer when they're acting like that. I get why he was upset. I truly do, but there was different ways to handle it. And I truly apologize. That $1,150.16, I'd be more than happy to take care of. I'd be even happy to throw in an additional $349.84 just to bring it to an even total of $1,500. Just add a little bit extra on there for them. But that's pretty much what the issue was on that, sir.
All right. Mr. Tyler, anything else you wish to add?
I do. I've lost my whole engine over this thing. The camshaft and all that. The oil, they didn't put the drain plug back in, and it lost all the oil. And then that's why I had to go to Ford, and Ford had to replace all that timing chain and all that timing belt and all that stuff. I believe that bill alone was like $1,600, and there was nothing covered on that under.
Why was that?
I believe that
Just a
bill
minute,
was
just a minute. I don't see it here. In what you submitted. I don't see any $1,600 bill.
There was one for $1,600, one for $3,500. It had to do with the timing chain and timing belt. I don't have that number exactly in front of me, but that's what happened to the engine when it ran out of oil, because they didn't put the oil pan back on. They didn't screw the oil pan back on, and they tried to glue the engine back together because they couldn't get the bolt out of the thermostat, which they're not denying that they couldn't get that bolt out, and they literally glued my engine back together.
No, there's nothing in the on-case file that I don't have. The problem is, as I said, you're not doing a very good job of presenting your case. You don't have any of the documents in front of you. You don't have anybody to testify to support your claim. I don't see any of the things that you're talking about.
I didn't know I could
I
have
went through
anybody
them.
here. My wife is here. I didn't know that she could be here. So he went
Yeah,
inside.
I mean, you could have, and I'm trying to use the documents you gave me to give you some leeway, but they don't say what you say they say.
Can I have
A lot of this stuff that
have a
was
1 minute
covered
recess?
by the service contract.
Can I have a 1 minute recess?
No, this is the time and date for the hearing. I gave you a recess. Missing bolts and gasket, it was all covered by the service contract. You're not out any money. Replace valve covered gaskets, covered by the service contract. Rocker arms, you're not out any money. Somebody else covered it. I'm gonna go with the figure that he acknowledges, and you're fortunate to get that. I find for the plaintiff in the amount of $1,500.
And what are the, sorry to interrupt,
And
Your Honor.
$83.50 in cost and $76.16. So it's $1,656.66.
And that's due 30 days from today, right, sir?
21 days.
21 days, perfect.
No, 30 days.
Okay.
You have 21 days to appeal. All right, Mr. Tyler, this is harder than it looks.
Yes, sir.
Lawyers don't just show up and throw some spaghetti at the wall and hope it will stick. There's more to it. So he acknowledges some, in fact, even more than perhaps he needed to. If he'd said nothing, probably nothing would have happened. But I find for you, he's got 30 days to pay it. And that solves and resolves this claim. All right, I think you were wise to get that aftermarket insurance for what that's worth. I mean, you got a lot of money into this truck, 65 grand or something. It must be a nice truck, but I can't see. You're not in it now, are you?
No, I had to sell it. It blew up.
No.
It ended up blowing up.
All right.
Can I confirm one more?
All right, that ends this session.
Thank you, sir.
Perfect. Thank you, guys, sir.
Thank you. All right, it is harder than it looks. Hope he got a lot of money out of it because he put a lot of money into it. But he didn't prove his claim very well. All right, that concludes our day. Tomorrow is arraignments, pre-exam conferences, and sobriety court.
Is there anyone out there who still isn't clear about what doing drugs does? Okay, last time.
Good morning, Mr. Brown.
Oh, yeah.
And so by appearing this morning, I'm going to quash the warrant that was issued by the city of Longview. I'm going to give you 3 new court dates. Do you have a pen and paper available?
Yeah.
Okay.
No, I don't. Hold on, I gotta go up front. I just want to, you got a pen and paper? Okay, I don't want them, I just want 1 court date, because I'll get confused. And I need to get your phone number. Is this attorney?
No, this is the judge. I'm striking the warrant that was issued. I'm going to give you 3 new dates. You'll still need to contact your attorney after today.
I need to call the courthouse and get my attorney's number. I need to get on it. I've been lazy.
I can give you that. I can give you that number as well, Mr. Brown.
The one court, give me the one court date. Just the first one.
I'm going to give you 3 court dates. The first one is May the 4th at 10 a.m.
All right, May, hold on. May the 4th at 10 and Zoom.
Yes, that would be on Zoom.
What was it? What was it? I forgot. I said 10 May 4th. Is that what you said? May 4th at 10 o'clock.
I did.
All right, I'm not bad. I'm thinking something else. I want to tell you something. All right.
Mr. Brown, if you could just listen to me for 1 second, I'm going to give you 2 more dates. June the 29th at 9 a.m.
I'm not going to write them down. I can't even write the first one down. I'm like really confused. Oh yeah, I'm just going to take a year GOC with that when I talk to my attorney. I don't want to go to jail. That's what I want to talk about. I'm not having a hard time. I'm frustrated.
I understand that you may be frustrated,
but that's okay. I got the first court date. So when the next court date, okay, they'll give me 3 more court dates, so it'll be all right.
No.
But yeah, I'm going to try to get this handled. I don't want to keep going to court for the next 10 years. I mean, the last case struck out for over a year. Until I took a strike.
Mr. Brown, I'm also going to give you
Mr.
Brown, I'm going to give you your attorney's phone number at this time. You ready to write that down?
Yeah, I can write it down. Give me a paper. Paper's so small. He gave me a little notebook paper. I write like a fucking 3rd grader. All right, what is it?
You need to call them and set up an appointment.
Okay, yeah, I do. He's booked out like a month. And I gotta get my number on my phone and write that down. So I just haven't had a pen and paper and everything. But yeah, I'll get on to it. And before I can make any kind of deal, I have to go see him. So that's what my plan is.
It sounds like a good plan. I'm going to give you a couple more court dates. So we'll see you via Zoom on May the 4th at 10 o'clock.
I'm not going to be able, I can't right now. I'm running out of paper. All right. I got the first court date. Every court date is 3 more, so it's okay. I did nothing wrong. You can prosecute me for this. Yeah, all right. Thank you. Is that it, Your Honor?
No, I'm going to advise you of 2 future court dates. June 29th at 9 a.m. in person at the Hall of Justice in courtroom 6 with a trial date of July the 10th at 9 a.m. also in person in courtroom 6. Call your attorney's office. They can remind you of those court dates if you're not able to write them down right now.
Okay. I need to get an afternoon appointment because but the reason why I missed court, Your Honor, is because I thought to see my attorney, I mixed up on my court date to the attorney. And I called him when I was with my appointment card. I didn't realize it wasn't, I thought it was an appointment card for to go to court. So I got it mixed up. That's the only reason why I didn't even know I had a warrant.
I understand.
My DOC officer didn't tell me.
Mr. Brown, I'm glad that we were able to work this out and get the warrant quashed. So talk to your attorney. We'll see you back here on May the 4th. Thank you, sir.
All right, there we go. Bye.
Bye.
This is your brain. This is drugs. This is your brain on drugs. Any questions?
Today I have for you one strange TPO, which is a neighborly dispute over the burning of sage.
I take it Timothy Weatherby is the one in jail garb, correct? Is that you, Mr. Weatherby?
Yes, sir.
All right. Normally, I would take you last because we have two cases to cover, but since the jailer's there with you, we're going to do you first so that they can return to other duties. The court will call two cases, one filed, well, actually, neither one filed. Both of them, State of Kansas versus Timothy Weatherby. Could we have an announcement of appearances?
Yes, Your Honor. May it please the court, the state of Kansas appears through Assistant Ellis County Attorney James Rutherford. Mr. Timothy Weatherby appears pro se from the Ellis County Jail by Zoom.
All right, Mr. Weatherby, we have the first case that was scheduled for this morning. This would be the violation of a no contact order that you were arrested on July 7th. And then the court now is in receipt of another probable cause affidavit that you were arrested yesterday, again, for a violation of the no contact order, again, involving the same individuals. Don't say anything yet. I just wanted to advise you of the two cases. Mr. Rutherford, the position of the state regarding the lifting of the no contact order.
Well, Your Honor, I'm not sure the no contact order from the case that we had, the criminal case, actually matters too much. There's a PFA from the DM case that's still in place. So I'm not sure it matters. Our position would be to leave it in place.
Right. We can't lift a PFA anyway, as part of a criminal case, Mr. Weatherby. So you'd have to file in the PFA case, and that's not before the court today. But so I'm not going to lift the no contact order that's in effect. Now your no contact order is in effect on a potential criminal case arising out of your violation of a PFA order. In other words, Mr. Weatherby, you're complicating your life pretty dramatically. Unless you like jail, you got to quit. Well, then you better quit talking to those people because they got an order against you.
Yes,
Okay?
sir. It's illegal if I can speak now, first, sir. I was walking.
No, I don't want you to argue. Mr. Weatherby, you're not doing yourself any favors by arguing the facts of the case.
No,
I'm
sir.
just giving you a precautionary warning. We'll have a trial and you'll get all the chance you want to testify at the trial. But right now you don't have a lawyer and anything you say potentially could be used against you. I don't want you to dig yourself a deeper hole than you may have already dug. So it in your best interest not to say anything, but it is your opportunity if you want. So I've given you the warning.
So I'll take your warning and heed your warning, and I'll go home today, and I will stay in my house unless I have to go to the supermarket or go to church. That's it.
Here's the problem, Mr. Weatherby. I've read the affidavits. You live in the same building as the people that have the PFA against you.
That's what the hard problem is.
So you probably need to make other arrangements, I'm telling you, because you cannot contact these people directly or indirectly in any way. You can't say even good morning to them. You understand?
Yes, sir.
All right. Because every time you do, they're going to call the police, which they have every right to do, and you're going to get picked up and put in jail, and you're not going to get out. You understand?
Yes, sir. All
right. Now, Mr. Rutherford, we now have him in on a violation of the no contact order arising from the earlier arrest, which would be 23 MR 242. What's the state's position? Do you want to keep him in jail? What do you want to do?
Oh, Your Honor, I mean, I don't think revocation of bond, since there's no case filed yet on this one, is warranted. But the state would like to set a bond since he was OR'd in the previous MR case. And apparently an OR bond did not get the message to Mr. Weatherby not to violate his bond conditions. So the state's going to request a standard bond for a Class A person misdemeanor of $1,000. And perhaps that will keep Mr. Weatherby from violating this order again.
Weatherby, the state's asked me to put $1,000 cash or commercial surety bond, which means you got to put up $1,000 cash or you got to pay a bondsman, whatever they charge for that type of bond. Do you want to be heard regarding the bond?
Yes, sir. I don't have any. I live on a fixed income, and I just barely make by means. I'm more than willing to do anything the court asks me to do. I just don't have any money right now, sir. And I like to go to church on Sunday. I like to go and help out at this place called the Ark. I volunteer there, and there's other things I like to do around the city besides just being in jail. And I'm not going to make any contact with these people. The only way that my bike got stolen the whole time when I was gone, and I'll be on foot. The only time I'll be going out there is to catch the access bus to go to Walmart, and that's it. I'll be out that, and other than that, I'll be at my house.
Are either Paula or Terry Wilt on the screen?
They are not, Your Honor. I'm not sure we even spoke to them.
There's somebody up there trying to talk. I don't know who that is. Up in the right corner of my screen. Ma'am, you're still on mute. Are you Paula Wilt? Ma'am? If you're Paula Wilt, would you raise your hand? That is Paula Wilt.
Okay. I wasn't sure if we ever got a hold of them.
Yeah, I'm on, sir. I'm sorry. I'm not used to doing this on my phone.
That's okay. I had Zoom problems yesterday, so it happens. Ms. Wilt?
My husband's here as well, sir.
Okay. Mr. and Mrs. Wilt, here's our dilemma. Mr. Weatherby is on a fixed income. He doesn't have the money to post a bond. I know you don't want to be bothered. I know you don't want him to talk to you, but he won't be able to post bond, so he has to stay in jail. He's asking me to let him out of jail and promising he won't have any contact with you, but I want you to weigh in on that.
I'll be honest with you. I don't completely trust him right now. I can be going to the car and he won't leave me alone. And this has happened more than once.
No, it hasn't. It was one time when I was apologizing to them about me talking to them. I was apologizing. I had my hand on the door. And that's what the whole thing about the door thing was. I wasn't trying to.
Okay, all right, Mr. Weatherby, all right. But Ms.
I'll
Wilt.
stay completely away.
Ms. Wilt, he's promising to stay completely away. I know he didn't do it the last time, but if we don't agree to let him out, he's going to have to stay in jail.
What, sir?
Mr. Wilt? Yeah.
Now, supposedly it's sage that he's burning, but I have a feeling it's a mixture of sage and marijuana, and it makes everybody in the household sick.
If he promises not to burn any sage or marijuana, will that help? If he does that again, all you have to do is call the police, tell them to show up, and they'll knock on his door and check.
Okay, because my wife is on oxygen.
We're going to pause right here for a second and dig into this one just a little bit because I'm a little confused. The whole idea of a TPO is to protect someone against physical harm, and smoking can be physically harming, but generally that is not what initiates a TPO. It's more violence and assaultive contact, stalking, things like that, where you're worried about your body being touched, hit, things like that. You know what I'm talking about. So I started doing some research to see if I could find any criminal cases related to neighbors who had some kind of criminal charges related to smoking, and I really couldn't find anything criminal. There are quite a few civil cases. I did find one from back in 2015 where DC neighbors had a legal case over smoking, and the judge actually barred the smoker from re-entering their home when they refused to follow his non-smoking ban. And then the article goes on to summarize quite a few other cases that have happened in the past. But they're all civil cases where one neighbor is smoking, actually smoking something, and the other one is suffering harm from the secondhand smoke, which we know cigarette, tobacco, secondhand smoke can be dangerous. If he's smoking sage, I think that brings us into a whole different level that could almost get into like a religious aspect, but I'm not even going to comment on that. But another interesting thing I found was this actual flyer that is your legal options for tenants suffering from drifting tobacco smoke, which is crazy. Apparently, this is a pretty big issue. But it's talking about suing the neighbor directly, and also that your landlord could be responsible for it. But it also says make sure you have suffered significant harm before you take a claim to court, because it has to be a justifiable legal claim in order for this to happen. So that's why I'm really confused by this judge taking so much time with these complainants and making sure that they're okay with releasing him from jail. I've never heard that before. I'm totally baffled by this case. This is crazy. Let me know what you think.
And it gives her a major migraine. It gives me a migraine. I found out I have to have surgery done. And then my roommate, she just had an emergency C-section, and she has a newborn coming.
Okay.
And
Well,
we don't want all that. We don't want to be.
I understand. I understand. So if he promises no more burning of sage, marijuana, or any substance like that, and that he'll completely leave you alone, he won't say good morning, he won't say boo, he won't say anything. If he promises to do that, would you be opposed to an OR bond?
I would, but I don't know about my wife.
I'm scared, to be honest with you, sir. But I'm going to leave that in your hands, Judge.
I know that's.
Your Honor,
Go ahead, Mr.
may I suggest that rather than the $1,000 bond, he can be supervised by court services, and the Wilts can have a direct line to whoever's supervising him to let them know if he violates or any bond conditions.
That's a good suggestion. Mr. Weatherby, let me ask, do you have any alternative place to live on a short-term basis? Nah, I figured that. It never fails. Weatherby, you're digging yourself a heck of a hole.
Yeah, I'm not trying to either. I wasn't trying to.
Well, you're doing it. You're not trying, but you're doing it. Okay. These
And we've asked him, Judge, we've asked him numerous times to quit burning that stuff. I went to the doctor's appointment Monday for my hypoxia and asthma. My oxygen was 88. They wanted to put me in the hospital because of that crap.
Okay.
I don't want to die.
I understand.
I'm only 42 years old.
Okay. I can appreciate
I'm sorry. I'm not trying to yell at you.
No, that's okay. I understand. This is an emotional time. And I'm trying to come up with a good solution. Okay. So Weatherby, look at the situation you put yourself in. Look at the difficulty you're causing to the Wilts. And here's what we're going to do. Ms. Arias, do you know Mr. Weatherby? Is there anything that would prevent him from being on supervised bond?
Your Honor, I'm not familiar with him. We can send over an application to the jail and look into it.
Okay. All right. Here's what we're going to do. Mr. Weatherby, they're going to send over an application. Can you read and write?
I'm legally blind, but I can write.
All right. They're going to send over what's called an application for supervised bond. You need to fill it out. If court services agrees to accept you on supervised bond, you'll be released on an OR bond to be supervised by court services. Okay? If they don't accept you, you'll stay in jail, and we'll have another bond hearing later on this week or next week. Okay?
Your Honor. So they'll let me out today, you're saying?
No, I'm saying you fill out that application and court services will look it over, and they will contact me as to whether they will accept you on supervised bond. If they accept you, then you will be released. But on this condition, and Ms. Weatherby, I'm going to tell you right now, if the Wilts call and say you contacted them in any way or you burned any substance in your apartment, any sub, you don't burn incense, sage, marijuana, you don't burn nothing, okay?
That's I talked to my manager about that, about the burning the sage thing, and he said it was okay.
No, well, I'm telling you it's not.
Okay, you tell me it's not, that's fine.
Okay, you can't do it anymore.
Okay,
Understood?
yes, sir.
And this is something the Wilts need to take up with your landlord, but you're the one that's got potentially 2 criminal cases against him. Okay? So I can't order the Wilts to do anything, but I can order you to do something. You're not going to burn any of that stuff anymore. That's a condition of your bond. You understand?
Okay.
All right. And you obey all the laws, you follow all the rules of court services. There's a bunch of them, and you don't get to say, I did 7 out of 10 or 70% passes. You got to do 100%. Do you understand?
Yes, sir.
Okay. Court services will send that over. You fill it out. They'll review it. They'll contact me later today or tomorrow and let me know whether they've accepted you. And if they have, you can then go out on supervised bond. Mr. and Mrs. Wilt, thank you for joining us today.
Your Honor,
And here's the thing, Mr. and Mrs. Wilt, if he contacts you in any way, and I know all he did the last time, according to the affidavit, was he said good morning or something, but he's not allowed to even do that. If he contacts you, do what you did the last time, call the police or call the court services office at the courthouse and they will intervene. Do you understand?
Yes, sir.
Yes.
I have another question for you, sir.
Uh-huh.
I'm also on court services. How is that supposed to work?
What do you mean? If you're on court services, that's fine. I mean, if they're supervising you, they'll continue to supervise.
They're not supervising me.
He's doing what he's supposed
I'm
to
doing
do.
what I'm supposed to be doing. I go through Nick.
Right. Okay. It won't affect that at all.
He just doesn't want to get in trouble and wind up
I
back
don't
in
want to get in
jail.
trouble to go back to jail for all this going on.
You won't. You don't get in trouble. You're doing the right. If you're doing all you're supposed to do, you don't go back to jail. Mr. Weatherby, he said good morning to you or whatever the other day, and that was a violation of the bond. And so that's why he's in jail. You do what you're supposed to do, you won't go to jail.
It would help if you would quit drinking.
Well, okay. Ms. Wilt, we have 3 other cases to go and I've
I
got
know,
to
I'm sorry.
So I've got to
sorry.
I can't solve every problem on this kind of a hearing, but I
No,
appreciate you being here. Okay.
All
You
right.
just keep doing what you're doing. If you have any problems, you let the police or court services know.
Yes, sir.
I mean, any problems with Mr. Weatherby, understood?
Yes,
Mr.
sir.
Weatherby, you got your warning. If I have to see you again, it ain't going to be pleasant. Do you understand?
Sir.
Okay, get that paperwork filled out and we'll see what court services says. All right?
Okay.
Room. I didn't do the weather, wasn't even there when say they found it. Why y'all keep bringing me up here and y'all be in court date and not bring me up before? Here we go.
Morning, Ms. Henderson. Will you take your hat off for me, please? Thank you. This is the State of Kansas versus Pamela Henderson, MGI 21 CR 203. Ms. Henderson appears by Zoom with counsel, Mr. House, stated by Mr. Goso. This was set for hearing Tuesday afternoon on Ms. Henderson's motion to suppress, but Ms. Henderson, you didn't appear in court on that day. Where were you Tuesday
They didn't tell
afternoon?
me, never mind, I thought I was doing June. I didn't know nothing about the court date.
All right, well, you were in court when that date was set, but you're here now. I did issue a bench warrant for your arrest, but I am not going to execute that. I'm going to withdraw that warrant since you appeared this morning. What we need to do next, we are set for a one-day jury trial to commence on July the 13th. We do need to address the motion suppressed in advance of that. I have availability next week. Mr. Gasso, do you happen to know your officer's schedule? Or do you
Your
have
Honor,
next week?
I do not believe that is going to work for next week.
Okay. If we do the following week, I have the morning of the 20th and the morning of the 21st.
I would prefer the morning of the 21st. I'm actually scheduled to be here for an afternoon hearing. And I've got a doctor's appointment or an eye appointment on the 20th in the morning that I think I've rescheduled like 3 times already.
All right, Mr. House, are you available the morning of Wednesday, June 21st?
Yes, Your Honor.
All right, so Ms. Henderson, you need to come back to court Wednesday, June 21st. Don't leave yet, Ms. Henderson. Wednesday, June 21st at 9 o'clock. You got that date and time down?
Let me write that down for you.
Ms. Henderson, do not leave yet. If you walk out the door, you'll be arrested. Do not leave yet. June 21st at 9 o'clock, come back here. Any questions about that? I need a verbal confirmation, Ms. Henderson.
Excuse me?
I need a verbal confirmation. You understand your next court date is June 21st
Yeah, I
at
got
9
it.
o'clock.
Got
All
it
right.
in my hand. Can I go now?
You
My
are free to
foot
go.
hurts,
Thank you
my
for
foot good.
asking.
Can I go, please?
You are free to go.
Thank you.
Thank you, Pam.
Call me Hank next time, shit.
So June 21st, 9 o'clock, we motion to suppress on Ms. Henderson.
Ms. Jones? You're muted, Ms. Jones. I can't hear you.
Oh, there we go.
Now
can you?
Yes,
Hello,
I can hear
everyone.
you.
Okay.
Hello.
Morning. Hello. I seen you Wednesday on TV.
Okay.
I was so happy.
You are always a joy, Ms. Jones. All right, where are we on her case?
Your Honor, the only remaining balance is $133.84. And so that would essentially be court costs. I don't know if I'm looking at the ledger.
I paid today.
You did?
Today?
Yes, sir. You know I wasn't gonna come before you without paying.
Oh, she did. Oh, okay. So what she did is she paid the court.
Okay.
So what we will do is I'll indicate escrow released to plaintiff, and then this case is dismissed.
Thank you. And
I can't see you no more.
Well, you can always see me. You don't have to get in trouble or do anything like this to come see me.
I'll wait watch you on TV. I don't want to come
Okay.
back.
All right. All right, Ms. Jones, you take care of yourself, all right?
Yes, Judge Simpson, can I say one thing?
Yes, ma'am.
The reason why I'm before you now is because when I stayed in Town and Country, you said that I did not have to move until you told me to. So they made sure I didn't get before you again. And that's, you hear me? That's
Yes,
why people
ma'am.
don't believe. That's right, because you the man. They made
Thank
sure
you,
I
Ms.
didn't get
Jones.
there. Have a beautiful holiday, and I'll be looking for you again on court cam.
All right. Thank you, Ms. Jones. You take care of yourself.
You
God
too.
bless you.
God bless you, sir. Bye-bye.
Bye-bye.
What's the amount in
Stevens, you're representing Ms. Powell, is that correct?
Yes, sir, Your Honor.
All right, and are you ready to proceed?
Yes, we are, Your Honor.
All right, are you gonna be calling Ms. Powell as a witness today?
Yes, sir.
All right, Ms. Powell, if you'll raise your right hand, on the patient oath, and do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, go ahead, Mr. Stevens.
Thank you. Please state your name for the record.
Rose Powell,
Rose, how long have you been in jail now?
since May 7th.
And you're being held on 2 different charges. Both of them had $15,000 bonds, is that correct?
Yes, sir.
One's a state jail felony of theft and the other is a state jail felony credit card abuse.
Yes, sir.
Okay. And you have not been able to post those bonds, have you?
No, sir.
You nor your husband have that kind of cash money to post the bonds.
No, sir.
If the judge were to reduce the bonds to an amount that you could afford, okay, do you have transportation to get to and from the courthouse?
Yes, sir, I do.
And where, tell the judge where you actually live.
We reside in Warren, Texas, which is Tyler County.
And you do have vehicles. We've talked
Yes, sir.
about that before. Okay.
Yes, sir.
And your husband has some medical problems.
Yes, sir.
He has stage 3 cancer.
Yes, sir, yes, stage 3 melanoma cancer.
Okay, and since you've been in jail for the past couple of months, he's greatly deteriorated. Is that
Yes, sir.
what you've been told?
Yes, sir.
Okay. And you folks are on fixed income. You're both on Social Security,
Yes, sir.
and you have no criminal history
No, sir.
whatsoever. Is that correct?
No, sir.
And so you are retired, so you have Social Security, correct?
Yes, sir.
Okay. Are you asking the judge to make both of these bonds personal bonds?
Yes, sir.
In other words, you and I talked about a personal bond that would be where you would be able to sign and get out. Do you understand that?
Yes, sir.
Okay. That's what you're asking the judge to do. Is that correct?
Yes, sir.
And if he won't do that, are you asking him to reduce them to about $1,000 each?
Yes, sir.
And if he were to do that, is that an amount that you think your husband might be able to work towards trying to get you out of here?
Yes, sir.
Okay. I'll pass the witness, Your Honor.
State, any questions of Ms. Powell?
Sir.
No, not asking you.
Yes, Your Honor. Ms. Powell, I noticed that you were saying yes to quite a few of the questions that Mr. Stevens asked you. The answer to the question about criminal history isn't exactly a yes answer, is it?
I'm not understanding.
Okay. He asked you, isn't it true that you have no criminal history? And you said yes.
Okay.
That's not quite true though, is it?
I was in jail only one night in Jasper County.
Well, you also served 3 years of probation for forgery.
Yes, yes, ma'am. That was years ago and it was supposed to have been dropped off of my case, is what they told me.
Your criminal history shows that you served 3 years of probation, so it wasn't dropped.
Okay.
But regardless, your question to Mr. Stevens is not, you do have criminal history, correct?
Yes, ma'am.
Who was the victim in that forgery case?
Ma'am, I don't remember.
Well, isn't it true that it was a family member?
What year was it?
And who's the victim in these alleged cases?
Your Honor, I'm going to object to the question. I think it's irrelevant at this point when we're talking about a bail reduction.
No, I'm gonna overrule the objection. I think that criminal history is one of the relevant bail factors that the court is supposed to consider.
So who's the alleged victim, ma'am, in this credit card abuse case?
Cousin.
I'm sorry?
Cousin.
I didn't quite understand what you said, but that's a relative of yours, correct?
Ms. Curry, I think she testified that it was her cousin.
That it was what, Judge?
Her cousin.
Okay. So again, that's a family member, just like the last time.
Yes, sir.
You live in Tyler County, correct?
Ma'am,
How far away is that from here?
about 3 hours.
What kind of vehicle do you own?
We have an SUV that's 2019. I have reliable transportation to get to and from court or probation, whatever.
And you sent a letter to my office, is that correct?
Yes, ma'am.
I'll pass the witness, Your Honor.
Mr. Stevens, any follow-up questions?
Just a couple. You live a long way away.
Yes,
but
sir.
you do have reliable transportation, is that correct?
Yes, sir.
Is there any doubt in your mind that you would not be able to make it to court for any
No,
of
sir.
obligations?
No, sir, none whatsoever.
That's all I have, Your Honor.
That's great.
Nothing further, Judge.
All right, Mr. Stevens, you want an argument on the bail reduction?
Well, Judge, there's not much. We have an elderly lady here that's on Social Security. Her husband's at home on Social Security. He has some bad medical problems. We're just asking you to give her PR bond, Your Honor, to let her out of here, take care of her husband, take care of the report business. If you don't believe that's appropriate, we would ask you to reduce the bonds to about $1,000 each one.
Okay. And Mr. Stevens, she testified that she has a 2019 SUV vehicle.
Yes, sir.
Does she have any other assets that she can use to secure her bond?
No, Your Honor, I've already asked her those questions. Let me ask her, do you have any cash in any banks?
No, sir, not that I know of.
All you own is your Social Security
Yes, sir.
check that comes in.
Yes, sir.
And do you own any property that you could sell, pawn, or mortgage in order to put toward the bonds?
No, sir.
She has no assets, Your Honor, at her disposal to help us.
All right, thank you, Mr. Stevens. Ms. Curry, anything?
Nothing further, Judge.
Any argument?
No, Your Honor.
Okay, all right. The court's going to take the evidence and arguments under advisement, and I'll issue a look at the end of the day.
Good afternoon, Your Honor.
Good afternoon. We ready on Ms. Powell?
Yes, sir. Ms. Powell.
Right, this is cause number CR 23-134, State of Texas versus Rose Marie Powell. Ms. Powell, if you'll raise your right hand, place your oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor.
All right, you can lower your hand. Just speak up loudly and clearly for me during your testimony. You can put your hand up. Ms. Powell, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Bill Stevens. Are you pleased with Mr. Stevens as your attorney?
Yes, sir, I am.
Do you feel like you've had enough time to talk with him about your case, that you've had all of your questions answered, and that you understand everything that you have read and signed in the legal paperwork today?
Yes, sir.
Mr. Stevens, do you believe that Ms. Powell is competent?
Yes, Your Honor.
And have you explained to her her rights and change in this case?
Yes, sir, I have.
Do you believe that she is entering into this plea intentionally, knowingly, and voluntarily?
Yes, sir, I do.
All right, Ms. Powell, you are charged by, I think you're charged by information with a theft of property, Class B misdemeanor greater than $100, less than $750. The range of punishment for a Class B misdemeanor is confinement in the county jail for up to 180 days, and a fine, if imposed, not to exceed $2,000. I see the plea agreement in your case is that you would plead guilty to that crime. State is recommending that you be convicted, that your punishment be assessed at 58 days in the county jail, that you would receive 58 days credit per time served. You would be ordered to pay restitution of $600 to the victims in this case. You would also be ordered to pay reimbursement fees of $665 and fines of $500 in addition to court costs of $270. Is that the plea agreement you want to accept today, Ms. Powell?
Yes, sir.
All right, understanding the plea agreement and the range of punishment, Ms. Powell, how do you plead to theft of property greater than $100, less than $750?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes, sir.
Has anyone threatened or forced you to plead guilty today?
No, sir.
All right, the court accepts the defendant's plea of guilt. Mr. Stevens, any objection to the stipulation of evidence?
No, Your Honor.
All right, the stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
Nothing further, Your Honor.
Is there anything further from the defense?
No, Your Honor.
All right, Mr. Carwell, I will need a recitation of the stipulation of evidence. I don't have that in the paperwork.
Yes, Your Honor. Give me just a moment and I'll pull the case up.
Mr. Stevens, do you have the stipulation of evidence there with you?
I do not have it in my file.
No, I'm talking about in the plea papers that she signed today, all of this.
I don't think so, Judge. I'll look.
We'll need to do that.
I believe Ms. Curry had those completed and emailed out, but I don't know the status of where they're at now, Your Honor.
Got the papers, Your Honor, but stipulation is not in here.
Ms. Curry, we are doing the plea on Miss Rosemary Powell. I've gone through everything. The only thing that we lack is the stipulation of evidence. Is that something you have access to?
Yes, sir. I emailed it to Miss Taberham, but I can pull it back up right quick. Would the court like, Judge?
If you'll just read it, that'll be fine. And it needs to get to Mr. Stevens and Ms. Powell so they can sign it and submit it with paperwork.
Okay, is Miss Burns in the jail courtroom? Okay, I'll email it to you as well then. It says, on or about April 25th, 2023, while visiting with relatives, I, Rosemary Powell, took money and things from the possession of which did not belong to me. The total value proven of things I stole was $600. When I did this, I intended to deprive the owners of the property by keeping it for myself.
All right, there's no objection to that, Mr. Stevens, correct?
No objection.
Okay. All right, and based on the evidence presented, the court will follow the plea agreement in this case. The court hereby convicts Rosemary Powell of theft of property. Court, that's a class B misdemeanor. The court assesses her punishment at 58 days in the Maine County Jail. Awards her 58 days credit towards that sentence for time spent in jail. Court orders her to pay a fine of $500. Reimbursement fees of $665, court costs of $270, and the court assesses restitution in the total amount of $600, with $200 being owed to 202, as reflected in the court's judgment. Ms. Powell, you hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. When you get out of jail, I need you to report to the courthouse. If you are unable to pay all of your fines, restitution, and reimbursement and court costs at once, you'll need to meet with our court compliance officer, Ms. Liz Harmon, and set up a payment plan. Failure to report, failure to have a payment plan, failure to comply with that payment plan will result in this court issuing a warrant for your arrest and bring you back in jail. Do you understand that?
Yes, sir, I do.
Okay, all right, step over with the deputy and be.
Thank you, Judge. Might be excused.
Yes, thank you, Mr. Stevens.
Thank you, Mr. Stevens.
Ma'am, thank you, Todd.
That was a plea paper.
Thanks.
Ms. Rogers, were you done?
Yes, my objection was to allow the defendant or
Say
the
whatever he
witness
wants. To let him see whatever he wants.
to answer the questions that are presented to him.
Counsel. You may be upset, but you got to control your behavior.
The people are ready and waiving opening statement.
Judges, as Sydney, the copies, I can't read this. these tickets you just sent me a half an hour, 10 minutes before trial, I can't read these.
They are light.
well-
It's a picture of a copy. They are light.
They are light, but I can read them. Just for example, on ticket ending in 753, any person who has custody of an animal shall prevent, blah, 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 blah. I can read it, counsel. So I don't know what you're looking at that you can't read it. It is light, but I can read it.
I'm looking at the copy that was sent from the prosecution judge, and I'm pretty sure being that we're the defendant and these are criminal charges, I have a right to be able to review these tickets. I understand the
No,
court.
there's no question, sir. I have the same copies, and I'm just saying I can read it. So it's not totally illegible. It is light, but it is readable.
I can't make out my client's driver's license number. I can't make out the section number. I can barely make out the handwriting on any one of these citations. I mean, Sid, you have to agree that it's difficult to read. Like I can't see the section. I can't even see the section numbers on these tickets.
Well, I don't know if you're seeing something different than I'm seeing, because again, I agree
Judge,
it is light,
Judge,
but it is legible. Yes, sir.
This is what I see. This is what I see. I have 4 tickets I have 4 tickets.
I have the exact same thing, counsel. I have the exact same thing in front of me. 4 tickets on one page. It is light. I agree it is light, but I can read it.
Sydney, can you tell me V128751? I can't read the section on that.
652A.
I can see it on mine. It is light, but I can read it.
Judge,
counsel.
I understand, but the defendant is telling you that we can't read the photocopied citations.
Then we will come in and we will do this in court, and you can have a copy of it in court.
I want the originals. I don't want a copy. I want the originals.
I know what you want, sir. I can't give you what we don't have. You show me the law that says it has to be produced, then I will follow what you've asked for. But you have not done that. You don't seem to want to do that, sir. But I'm not dismissing it. So if you want to read this document where I'm saying it is legible, we will do this trial. We will do it in person, and you can sit there and read it and show me how you cannot read it. But I'm not going to keep going over this. I told you I'm not dismissing it. So
I understand that, Judge. Give me 2 seconds. Let me see if I can decipher what was sent to me. Hang on. Judge, I'll proceed on what was sent to me. I guess the last thing I do is the court asked for a statute. The last thing I will argue is Michigan compiled laws 257-728, an arrest without a warrant for a misdemeanor citation. It indicates when a person is arrested without a warrant for a violation under this act, or an ordinance substantially corresponding to the provision of this act and punishable as a misdemeanor under these conditions, the arresting officer shall, and I use the word shall, meaning that they must prepare.
I understand what shall means, counsel.
As soon as possible and completely as possible, an original and 3 copies of a written citation to appear in court containing the names and addresses of the persons, the violation charge, and the time and place, blah, blah, blah.
Let's back up a little bit. The arresting officer shall what?
Prepare as soon as possible and as complete as possible with an original and 3 copies of a written citation to appear in court containing the various name, charge, location, stuff like that. The officer shall inform the offender of the violation, which we're not contesting, and shall give a second copy of the citation to the alleged offender, which again, we're not contesting, Judge. What I'm saying is that this particular statute indicates there has to be an original produced and that the court doesn't have the original.
Ms. Rogers.
Yes. Could you, Mr. Hill, could you please repeat the language that it has to be produced to the court?
No, it doesn't say that. It says a person arrested. What I'm saying is that the original copy, I mean, it's common sense. The original copy is filed with the court.
Correct.
And
So
it was filed with the court. It was
Correct.
filed with the court.
How do we know that, Judge?
The court made a copy of it. So it was filed with the court, because the court does not produce it now, because that was filed with the court, but the court had produced a copy of what they took in. It was all photographed and they made a copy of it. It says it must be produced to the court, and it was.
Judge, the copy you have is from Ms. Rogers, yes or no? Ms. Rogers?
No.
Yeah.
No.
Yes. Yes,
That
it
is correct. Just for the record, that is correct. The copy that the court has that I gave to defense, I emailed to Madam Clerk sometime this morning. I got it from Investigator Green. This is a photocopy of his tickets that he has as part of his investigation. I believe the court rule does require that an original ticket be present at the arraignment. We are obviously very far past the arraignment. We're at trial stage here. That's how an ROA and a case number was created for these matters. The court rule does not say that the original ticket has to remain in the court the entire time. It just has to be there at arraignment. The defendant was arraigned. We're set for trial. The prosecution has given copies of the tickets to the court, and the people are asking to proceed.
Ms. Rogers, let me ask you a question. Were you there at the arraignment where the original ticket was provided?
I don't believe so. I'm not sure, honestly.
Okay, so we have no idea if there's an original ticket with a file, do we?
I don't do the entering at the beginning, so I don't know if the original ticket was there.
I'll rely on my previous argument, Judge. We're ready to proceed if it's denied.
All right, counsel, on a procedural matter, the tickets are submitted to the court. One of the clerks that does entry and case initiation based on the original ticket, they will enter it into the system. We can look and see, and we can see who the person is who had the ticket and initiated it, and indicate that they had this ticket personally in hand and it was presented to the court. Now, if Ms. Rogers wanted to go through that and she wanted to subpoena that witness and have that witness come forward and say that they had that ticket in hand, and based on their code that they entered into the system, they had the original ticket, they entered the case initiation, and that ticket was presented to the court. Because the court cannot find it now does not mean that there was any violation or lack in the process of how the ticket was initiated, original ticket that was entered into the system through case initiation. Now that's a long way to go, but certainly if Ms. Rogers wanted to do that, she could call a witness and say that person had that ticket in hand, did case initiation, and the court rules were followed and the ticket was entered into the system properly. Now, because the ticket is not available at this time, the original ticket or one is available of the four, but certainly they can put something on the record saying that ticket was presented to the court in a fashion that is required.
Judge, I understand what you're saying, but that's pure speculation. I don't think Ms. Rogers can.
No, I'm not saying that's speculation, counsel. We have an entry into the computer that someone entered it. Now, it would not be speculation if Ms. Rogers subpoenaed that person, have them come to court and say, I had this ticket in my hand and I entered into the system. That's what I'm saying. Okay. That's not speculation.
Sure. Is Ms. Rogers going to do that, or can I go forward with my motion?
I'm just saying she could.
Okay.
I would like to subpoena that person. These are new arguments. We just became aware of not having the original tickets in the court file this morning. I did not have that person subpoenaed, and based on the arguments that defense have made this morning, I would like to subpoena that court employee and have them testify about what was entered in the system and what was present, based on the arguments defense is making.
I would object, Judge, because this is the third hearing that the city has been aware that the original tickets were not presented to the court. We're ready for trial today, Your Honor.
And we're all about justice, counsel, not ambush or something or something. So no, we're all about justice, counsel. We're all about justice. If that was not something that was argued before, because we weren't in court, and I don't know about this argument before. I've not heard that before, but certainly she could respond to something that she didn't know there was going to be an argument.
Can I finish my argument, Your Honor?
Yes.
This will be the third time that she's been here. I am doing this pro bono. My client works for the Detroit Police Department. She's taking time off work to be here. She's taken time off work 3 different occasions. It's not my burden, Judge. This is the prosecution's burden. They should have known this was deficient when they were at the last 2 pre-trials. And
I'm not dismissing it, counsel. I am not dismissing it. So
it can be, Judge, it can be refiled. They can just refile it.
I know they can do that.
So, I mean, this is a complete waste of everyone's time, judicial resources, when it's the third hearing with no original tickets. They can turn around and refile it, and we'll address it then.
If defense's argument is for efficiency's sake of both the court and the defendant, to dismiss it today doesn't make sense because this process will start over again. And then the defendant will have to be arraigned and have pretrials and trial again. And it'll be a waste of the defendant's time and the court's time. The people are ready for trial today too. We have our investigator here. We have a civilian witness here that's been here for hours also. These are new arguments that have been made, and I want to address them fully. And
Let's
I
go
would
to
like to
trial.
have.
Let's do trial right now. I preserve my arguments. Let's go to trial. Let's do it now. I'm ready, Judge.
If we could do the trial in 2 parts then, because I still want to put that witness on based on the arguments that have been made earlier pre-trial.
Object, Judge. We're ready to go today.
These are big allegations that have been made.
Yeah, you know what, counsel, we can go today, but she can still ask for a witness and we can hold it in part. So just because we start today does not mean we have to finish today.
As long as the court knows I'm not waiving any of my previous arguments, just in terms
Certainly
of.
don't expect you to waive anything, counsel.
Thank you.
Okay, so I'm clear. We're gonna go in 2 parts. We'll start today with the victim witness and the investigator and adjourn out for the clerk from the court to testify.
You can do that. You can hold it in part. And
Okay.
if in fact that nothing, yeah, okay. All right.
I guess it's my turn, right? Sydney, you waived opening?
Yes, I did.
Judge, usually I waive opening in this situation. I think I need to kind of tell you what really happened. This is a situation where on August 30th, 2020, my client was walking her dogs, a golden retriever and a mixed pit bull.
Counsel, let's back up 1 minute. You said what date?
Is it?
You said August something? That's not the offense date that I have.
I can't read the ticket, Judge, so I don't know.
I have offense date of September 15th, 2022.
I'm sorry to interrupt, just to address, we could bring the investigator out and ask if he could bring in a hard copy of these tickets. We aren't dealing with the photocopies, if that'll help defense. I can ask him or he's on the screen now. I can ask him if he can provide his actual copies because I understand that these are a little light.
Can you just tell us the date that are issued in the citations?
The incident date happened on August 30th, 2022, and this ticket is issued on September 15th, 2022.
Okay, so August 30th, my client was walking down the street with a golden retriever and a mixed pit bull. A neighbor was walking towards with his dog. At that time, the neighbor's dog, not my client's dog, began lunging and barking at my client's dogs. She moved from the sidewalk to avoid any altercation between the 3 animals because essentially the neighbor's dog was barking at. Well, let me ask you this. Is there sequestration? You don't have your witness here, right?
The investigator is in the main room, but the witness is in the breakout room.
That's fine. Thank you. As the neighbor's dogs were lunging towards my client's dogs, she addressed it by grabbing the dog harness to correct it and actually gain control of the animals. The neighbor's dogs continued to bark and lunge at my client's dogs, to which my client's shoe fell off. The animals became loose. They approached the neighbor's dogs, to which my client indicated they're friendly. Please don't be afraid. They're not going to hurt you in any form or fashion. To which the complaining witness began to kick, punch the animals that were being walked by my client. The animal, my client's mixed pit bull, did bite one of the other animals, but not before being attacked himself. So I want the court to be aware. You'll hear testimony from my client that although the dogs approached the neighbor's dogs, it was the neighbor's dog that actually bit my client's dog first. The moment my client told the dog to leave it, she's a dog trainer, she's a foster dog for decades. She'll explain that the moment she told the pit bull to leave it, he immediately left it and stopped. The neighbor is the one, Your Honor, that repeatedly kicked and punched the dogs at that time while the dogs were actually sitting and behaving. My client asked the neighbor to stop, to be calm multiple times. He actually made contact with my client, the neighbor, and the dogs. And at one point, he tried to actually kick I believe one of the dogs, the golden retriever or the pit bull, missed and actually kicked my client at that particular time because there was a melee going on. Once the neighbor had actually made contact with my client, the golden retriever doesn't know that the neighbor was trying to kick another dog. You'll hear testimony that the dog did bite the neighbor, but it's not because the dog was unleashed or out of control. It was because his owner just got assaulted. So that's really all I want to say in terms of factually, Judge. You're going to hear that from my client. This is a situation where I think that, and Judge, your whole testimony that these charges or these allegations weren't presented to the police till 10 days after the fact. And the reason why they were presented 10 days after the fact is because the neighbor was so, in my opinion, out of control, sending letters to my client, dropping off letters to her house, demanding that dogs be euthanized. And at that point, I think when my client said that it wasn't their fault, at that point, that's when he decided that he was going to go to the police. I told my client in retrospect that I think she should have filed her own police report for being assaulted by the neighbor. But at the end of the day, she doesn't want to create chaos. She doesn't want to add to what's already a chaotic situation. And she didn't. I think she should have, but she didn't. I think the charges should have been initiated against the actual neighbor and for failing to control their animals. But I don't think the investigator ever asked my client's side of the story. I think from what she told me, she got tacked on the door a couple tickets. So all you have is he said, she said, and I think, you'll see my client's credible and she'll go into the actual nature of the injuries and stuff like that once we get into testimony. Thank you, Your Honor.
Thank you. Ms. Rogers?
Yes, thank you. The people call Mr. Daniel Kincaid.
Okay. You didn't want to make a opening statement at all?
I already waived opening.
Okay, all right. All right, let's see, where's my witness here? Investigator Green, wait a minute, who did you want to call, counsel?
Mr. Kincaid. He should be
I
in a
don't see
breakout
him.
room.
I don't see, oh, is he in a breakout room? Okay. Hopefully the system will work today. Some days it lets me bring people out of the breakout room and some days it doesn't. Yeah, there.
Thank you, Judge. Good morning, Mr. Kincaid.
Good morning. Let me swear the witness.
Oh, thank you.
Okay. All right, you don't have your name on the screen, so yeah, it should be. All right, Mr. Kincaid.
Yes.
Is that Daniel, last name Kinkead?
Correct.
All right, would you raise your right hand, sir? State your full name.
Daniel Hunter Kincaid.
Swear or affirm to tell the complete truth?
Yes.
You may lower your hand. Your witness, counsel.
Thank you. Good morning, Mr. Kincaid. Thank you for appearing today.
Thank you.
I'm going to ask you some questions about what happened on August 3rd, 2022.
30th. Sorry.
Oh, I'm sorry, August 30th, 2022. So on the day in question, what were you doing?
That evening I was walking our dog. I left our home, which is just north of Bloomfield, on Briarcliff. I was walking southbound on Briarcliff on the east side of the street. Yeah, I can leave it there.
Okay. And you said you were walking your dog, correct?
Yes. Yes.
And what kind of dog do you have?
It's a Beagle mix, Chelsea.
Okay. Is Chelsea your dog's name?
Yes.
Okay. And how big is Chelsea?
I'd say, I don't know, medium size. I don't think we've ever really weighed her, probably 30, 35 pounds, something like that.
Okay. And you only have the one dog, Chelsea, correct?
Correct.
Okay. And how long were you walking, Chelsea, before anything happened?
Maybe just a couple of minutes. We had walked down and had crossed the street and we're heading down further down Briarcliff, and we were probably maybe 2 or 3 doors down, walking southbound again. And that's when I saw her walking on the other sidewalk with what I believe were two large dogs. And yeah, I can leave it there. Sorry.
And when you're walking, was your dog Chelsea on a leash?
Yes.
And you said you're walking on Briarcliff, correct?
Correct.
Is that in the city of Detroit?
Correct. Yes.
Okay. And then when you're walking on Briarcliff, what happened? Did dogs approach you? Did a person approach you?
Both. So as we were walking, I saw her come northbound on the west side of the street, and she was on that side and she started coming across the street with her 2 dogs. And as they were coming, they were kind of angling a bit toward us, but often in our neighborhood, when people cross with other pets, they'll cut the angle, behind you. And I thought that's what she was doing. But, it's one of these things, like literally within, I don't know, 3, 4, 5 seconds, I could tell that they were actually starting to come a little bit closer. And a lot of dogs will do that and sniff, and I wasn't thinking much about it, but really literally in that moment, like from seeing her in the middle of the street coming across, and I could tell she was being pulled. From that, it was like instant boom. It was just, it kind of just blows your mind. They were on top of us. They came and got I believe the pit bull was right on Chelsea from behind right away. And the other dog was kind of coming around the other side. It's a mess. And I can hear my dog just scream, a scream I never want to hear ever again.
So you said one dog was a pit bull, the other dog was what?
I think a golden retriever, something like that.
Okay.
All right. Thank you.
And then I'll just close out that state. So they're on the pit bull is on her, and I it just happened so fast. I'm trying to get her, and then I just kind of like picked her up, really just trying to get her out of it and heave back. And now I'm on the walkway up to the home, whichever home.
Sir, I'm going to ask you to not use pronouns he or
oh, I'm sorry. The name, yeah. I have Chelsea, the dog. Sorry, I have Chelsea. I see that the other person's dog was attacking my dog in a matter of seconds, and as I heard that sound and saw it, I went to pick up my dog Chelsea, and I could tell the other dog was hanging on, and so I heaved as hard as I could back, and ended up kind of then falling down on my back. My dog is there. The pit bull is going to town on her back end. And then the golden retriever is coming around, and it was a kind of a melee. And then the golden retriever was on my left hand as I'm trying to brace to get our dog. And I could see Miss McAdow behind and in that scene, and she had a look of terror on her face and was stepping in to try to deal with one of her dogs at that moment.
Okay, thank you. To back you up a little bit, when you said you were walking your dog Chelsea, and then the defendant is walking the other direction, are you guys all walking on sidewalks?
Yes, initially. So I'm on the sidewalk headed southbound on the east side of Briarcliff. She was walking northbound on the west side of Briarcliff. But like I said, that within a couple homes there, she started to cross the street and look like she was going to angle past us, which again, we typically see there, right? People walk around you just to get to the other side. But in a matter of, 3, 4 seconds, it turned sharp, and I could tell she was getting pulled across. And at first I thought they were just going to like check our dog out. But that it just, literally in a split second.
Okay.
Yeah.
So from what you could see, so the defendant's dogs were on a leash, correct?
Correct.
Okay. And they were pulling her though? Is that why?
Correct.
It appeared she crossed the street?
Well, at the time I didn't know. I mean, dogs are, they're always there's tension on the line. So I thought she was just walking them and walking behind us. But then, again, this is split second stuff, like 1 or 2 seconds. I could tell it right in that moment, like, well, they're really coming closer. And I thought, well, maybe they're curious, but then the movement was very fast and in a split second.
Okay.
Yeah.
And when that happened, did your dog bite the defendant's dog at all?
No,
Okay.
her dog was attacking my dog from behind. My dog's face was never around. I mean, yeah.
Okay. Were both of the defendant's dogs attacking your dog?
In that moment, all I could see right then was the pit bull attacking my dog. That's when I heave back, and when I heave back, and I'm on my back, and I think the other dog, it must have been the golden retriever, was on my left hand. As I'm trying to grab my dog, it's it's a mess.
Right.
Yeah.
When you said on your left hand, meaning on that side or biting your hand?
Biting my left hand. So I'm trying to pull, on my dog, and I'm and all this, and then something's coming around and getting my left hand, which I can see like the dog there, and I don't know, it's just a melee of.
Right. So did the golden retriever bit you? Is that correct?
Yes.
Okay. And then the pit bull bit your dog, Chelsea?
Correct.
Okay. And then your dog, Chelsea, was bit from behind on the butt?
In multiple locations, I believe on her left rear leg and her upper thigh, underneath in her groin, and a bit like all around her groin, honestly. It was all in that area.
Okay. And were you bit anywhere beside your hand?
No.
After this happened, it sounded like it happened very quickly. What happened from there?
I believe there was a moment where Miss McAdow somehow, I think, got her pit bull off. I'm not exactly sure what happened. I think she told me later that she had pulled the dog's mouth and somehow got in there, which is amazing. Pulled the dog off, and I'm trying to get my bearings. My dog is howling. There's literally blood everywhere. And all I can think of is to get up and try to protect my dog. And I could tell it was not good. And as I looked to our house to figure out if we can get there quickly, I told her, I said, she was apologizing repeatedly. I'm so sorry. And I said, just don't leave. Don't go anywhere, please. It's coming back to me now. Anyway, so I tried to get my dog down there to get her home, and then got a piece of paper. My home is like four houses northbound on the street. Get to come back to her to jot some stuff down, and then and I barely remember the details there because all I wanted to do was get her information and go, because I knew we had to take the dog to emergency somehow because there was just blood everywhere, and I didn't know what was going on, but I thought that it was bad. So.
Okay, yes, thank you. So when you went back to the house to get the paper, was the defendant still at the location?
Yeah, she was still at the home where this happened. She was still there.
Okay.
Yep.
And did she give you the information that you're looking for?
Judge, I'm going to object to relevancy. Well, why are we talking about exchange of information when we're talking about dog not on a leash and whatever the other charges are? I don't see how this is relevant whatsoever.
Ms. Rogers?
I can move on, that's fine. When you came back to the scene, were the dogs still with the defendant or back at her house?
I don't recall. I believe they were, I have to imagine they were still there because I was very fast coming back, but I don't remember just beyond talking to her.
Okay. And so you had no interactions with the dogs the second
Correct.
time around?
That's right.
And going back to the original incident, the bite incident, did the defendant let go of the leash when the dogs were biting?
I don't know. I would imagine so based on what was going on, because I think then she was trying to get in, you know, to work in that, to help. But I don't know. I would have to imagine her hands were off the leash at that point, trying to do whatever. At that point, the leash wouldn't have mattered. It was, you know, crazy.
Okay. And when you went back to your house, did the dogs try to follow you back?
Judge, I'm gonna object to this line of questioning. I don't understand that relevancy. From what I can read on, I think the 2 citations, which would be applicable. Again, I can't read the section numbers, but any person who has custody of an animal shall prevent the animal from engaging in nuisances and failing to provide a leash. That would be the only 2 I think this testimony is relevant to, and I have no idea why the dog's following him back, which they didn't, but I'm not really sure where this is going.
We don't know the answer to the question if they did or not, but it goes to if they're off leash. If they're following him back, they're not on the leash then. It's directly related to the charges.
I apologize, Ms. Rogers.
That's okay, thank you. Mr. Kincaid, if you could please answer the question.
And that was whether or not the dogs were following me back to my home when, I don't believe, I never looked back to, but if they were, they would probably would have been coming after. I don't recall them coming after me.
Okay, thank you. Were you able, that day you said that your dog was bleeding and had a lot of injuries. Did you have to take your dog to the vet?
Yes, we took her to an emergency vet that immediately that night.
And what treatment did your dog have to receive?
She received a repair on a number of the wounds that she took from the attack. And it had pulled apart a lot of different tissue and stuff. So it took overnight to do. So there were, you know, I don't know there are drainage tubes everywhere. It's stitches it was just, I don't even know how to describe it. It was just a mess down there. You know, it was just a mess.
Okay, thank you. And has your dog fully recovered now?
Yeah, I think physically she's fine. The scars are still there for sure. I think physically she's doing well. I will tell you though, you know, since then it's just, you know, we have to really be careful because she gets really skittish. She is very afraid outside, and I'm trying to, you know, make her feel okay. But you know, we just take it one day at a time.
Okay. And did you have to receive treatment for the injuries to your hand?
Yes. Yeah. So that night I went to, sorry, or I can.
No,
okay.
Go ahead. What treatment did you receive?
So I'll just say that evening I went to the emergency room at Beaumont in Royal Oak. There was a long line there. I left, and they had told me to bandage up the cuts and everything, and to hold it together, and I could get to a Beaumont outpatient kind of thing in the morning, which I did. And there they cleaned the wound, they went through all the puncture wounds that were on my basically my left hand, the left side of my left hand. They cleaned those all out, and then did a kind of tape suture on that side of my hand, and that was it. Overall, you know, still to this day, you know, that part of my hand obviously feels a little funky, like it's asleep, but I've recovered fine.
Thank you. Do you know if you had to receive additional treatments for rabies?
Judge, I'm gonna object to relevancy.
There's a charge for unvaccinated dog, which would be a rabies vaccine.
Isn't that something that the inspector is going to testify to?
But if Mr. Kincaid had any additional treatment and injuries due to the dog being unvaccinated.
But he was, okay.
Relevant, counsel. Well,
I don't. Sorry, I don't believe I did get anything relative to that.
And did the defendant ever show you any proof of the dog being vaccinated?
No.
And if you could please identify if the person is on the screen, the person that was with the dogs that bit you and your dog on August 30th, 2022. If you can identify that person, if they're on the screen, and please identify an article of clothing that that person has on.
Sure. Sorry, it's a little small. I see Michelle McAdow. She's in the upper right part of my screen. I believe it's a kind of green, darker green shirt, red hair.
Thank you. May the record reflect the defendant's been identified.
Record so reflect.
And did you have any interactions with the defendant past August 30th, 2022?
Yes.
Judge, sorry, I'm going to object to this line of questioning for relevancy. Anything that's post, all I see is an unleashed dog and any person, again, I can't read it, but it has no relevance to the actual charges unless.
I don't know what the question is, counsel. If in fact the question, if it is not relevant, I'll strike it, but I don't know what it is, so I can't say it's not relevant at this point. But I'll hear it if it's not relevant, or if it's cumulative in some fashion, then I'll strike it.
Thank you, Judge. Briefly, the question is in response to, or because of defense's opening saying that there was issues post this, that the victim was constantly contacting the defendant and what was going on between the two of them.
I think you made that part of the argument, counsel. Go ahead.
Judge, it's not, Judge.
Yes.
It's testimony. My opening statement is not testimony.
I know it's not testimony, counsel, but you raised an issue on the record. And if she wants to counter that, then she can do that, because I don't know what your argument is going to be now after that, after you made an opening statement saying what was going to happen. It's relevant. Go ahead.
That's not testimony. What the proper
It doesn't
procedure-
matter, counsel.
Judge,
it's your opening
Judge,
argument. Your
Judge.
opening argument is a roadmap as to what you think the evidence is going to show. And if that roadmap goes askew, she gets to counter it. She gets to say something because she doesn't know what you're going to say in your. No, go ahead, counsel.
Judge, I have to put this on the record. I'm sorry. Okay, procedurally, this is done improper. This is completely improper. The proper procedure is to call him as a rebuttal witness if once testimony's on the record establishing there's a post discussion.
Also, did you say what the evidence was going to show?
Yes, and Judge, you have to wait for the evidence to
So
show.
how do I know what your argument is going to show when you close? So you said it, counsel. She gets to address it.
She does not get to address it because it's not testimony. If my client.
No, you get to address it because you said what you're going to show. If you tell the court what you're going to show or what the evidence is going to show, she can say whatever attorney said is going to show, let me show you why it doesn't do that. Yes, counsel, if you make an opening argument saying what the evidence is going to show, she gets to counter that to show that evidence did not show that. You did that, counsel. So
there's no evidence,
your
Judge.
objection
And that's
is
the
not.
reason why a jury instruction says that the attorney's opening arguments and closing arguments are not testimony. There has to
It's
be
not testimony, and it's not, no, it says it's not evidence. It says it's not evidence. But if you have told the jury what they're going to see, she can say, this did not happen. So yes, you can do that, sir. So move on. Go ahead, Ms. Rogers.
Thank you, Judge. Mr. Kincaid, did you have any interactions with the defendant after August 30th, 2022?
Yes.
And what were those interactions?
We reached out to her just to talk about what had happened and to make sure we could get vaccination records from her and just talk it through. And I can't remember the exact date that we met with her initially, but she did come. I think we'd reached out as she shared her information. At one point we met in our driveway. My wife and I were there speaking with her. I believe, I can't recall if it was prior to that or immediately following that is when I think I sent her a letter before that on September 3rd and put it in her mailbox, and I outlined, what had happened and how our family was impacted by it, but also in there had cited things where we wanted to make sure that given how this happened, this unprovoked, really kind of vicious attack happened, that no one else.
Objection, Judge. I'm going to ask the court to strike this line of questioning. This statement. Again, there's no evidence whatsoever.
And so I've already ruled. When you said what the evidence is going to show, she gets to show that the evidence that did not happen, or it did happen, or whatever. but yes, because that counsel, that's like saying you got a jury in front of you and you saying your opening statement, you're gonna see that my client never had a gun. And then you say when the other party says, did you have a gun? You say that's not relevant. There's no, I didn't say, no, you know, if you state what the evidence is going to show, she can rebut that. Go ahead.
Yeah, so to clarify, I had created a letter. I think I put that in her mailbox. I think she came down either later that day or the next day. We spoke about the letter. The letter is dated September 3rd. And in there, we basically, the key part of it was that we wanted to make sure that we could have the vaccination records to understand just that, to know that the dogs were vaccinated. And we also asked that, recognizing that we understood she took in other animals that she's doing a rescue, that she think about that carefully and that we make sure that nothing like this can happen again, in our neighborhood. And that meant that those dogs either had to be quarantined, like held back safely, and so like no one else could get hurt.
Sir, hold on one second. Now, Ms. Rogers, I think we're going a little far now.
Okay.
Because now we're not talking about the dogs at hand. There's discussion about other dogs they may be taken in. So let's narrow the focus to the dogs that were involved in this.
Yes, thank you, Judge. So you did have interactions with the defendant post this incident, correct?
Correct.
Okay. And you were asking for her documents and about, okay. And this is a neighbor of yours, correct?
Yes, down the street, yes.
Okay, so you do have future concerns because you guys are neighbors.
Correct.
Okay. You sent her the letter and then you talked in person a few days later, is that correct?
I believe so, yeah.
And did you ever contact the defendant post that, besides a letter and talking in person in the driveway?
We did. We provided it. We spoke with her in our driveway, talked about, I don't know what I can say on this anymore, the medical bills and just making sure her dog, that this didn't happen again. We hadn't heard back after that at all. We hadn't received any information to validate that the vaccinations. And so we sent her another letter, and that was on September 11th. And I cited in there just specifically what we were looking to get, the full vaccination documents of both of her dogs. Yeah.
Okay, thank you. So when you sent the second letter, any interaction past that?
No.
Okay. And did you talk to anyone from animal control regarding this incident?
Yes, there was a police officer or inspector that came and spoke with us about what happened.
Okay. And did he come and speak to you because you called, or how was he aware of this incident?
We had, I think we had notified the 12th precinct. I'm trying to remember now. I think we had notified the 12th precinct that this had happened. And I think that's subsequent to that. I think they had the officer come and talk with us.
I see. Okay. So then once you called, someone came to your house?
Correct.
Okay. And do you recall how far after the incident someone from Detroit Animal Control came to your house?
I honestly don't know. It was probably I think within, if not a week, then just a little over that.
Okay, thank you.
Yeah.
Nothing further from the people.
Judge, I just realized something. You didn't swear the witness in. Just to give you a heads up.
Sure I did.
I
started out before I let Ms. Rogers speak, didn't I?
Okay.
I thought I did. I could have sworn I did. Well, let me do that again. I thought I did that. First thing I did. Mr. McKay, yeah. Sir, I could have sworn I did this, but counsel says, and I trust that. Raise your right hand, sir. State your full name.
Daniel Hunter Kincaid.
All the testimony that you previously provided and any additional statements or questions that you answer Do you swear that those are the statements that you have made are truthful and the statements that you will make are going to be truthful?
Yes, I do.
You may lower your hand, sir. Thank you.
Sydney, before we get started, can you, from the left to right, the tickets, can you give me the section numbers? I have the middle one, the 5-1. I can't read the first two and the last one.
Ticket ending in 8753, section number is 613A.
Yep.
Ticket ending in 8400, section is 651A.
Okay.
Ticket ending in 8751 is section ending, or is section 652A. And then the last one is 622B.
Thank you. Mr. Kincaid, my name is Ryan Hill. I'm an attorney. I represent the defendant. I'm going to ask you a series of questions. I want you to pause and wait. Ms. Rogers may have an objection. And if you don't understand the question, just say, Ryan, repeat it, okay? And I'll ask it again, okay?
Okay. Yep.
In terms of trial prep today, did you speak to anybody besides Ms. Rogers? I don't want to know the context, but I want to know if you spoke to anybody or what you're going to testify here today about.
No.
Okay. Would you agree with me that those letters that you put in my client's mailbox, they also had a demand to euthanize the animals? Yes or no?
No.
You didn't make a demand to euthanize either one of the dogs?
No, I'd like to clarify.
No, I need a yes or no answer.
We did not demand. We asked that she share her vaccination records and ensure that she can keep her dogs safe so they can't hurt anybody. If she cannot, then we felt like that's the only other option given everything that happened.
So in those letters, you did make a demand for them to be euthanized if she was unable to provide vaccination, correct?
Good clarification, yes.
Okay, all right. And she provided you proof of vaccination, didn't she?
No.
She never did?
No.
Do you remember making an oral statement to her on the date of this incident where you demanded her to euthanize her dogs? Yes or no?
No.
Were you aware that you were being video recorded after the incident? Yes or no?
No.
Okay. Let me ask you again, Mr. Kincaid.
So, counsel, let me say this. I do not believe that the lawyer can ask a question and tell them how to answer at all. I do not allow lawyers to tell someone yes or no, because the answer is often not a yes or no answer, even though that's all you want. So I do not require witnesses to respond yes or no. You can ask a question, you can't tell them how to answer in this courtroom. So,
Judge, I'm so sorry, but when I ask a question that requires a yes or no answer, that's what I'm going to say. If it requires an explanation, Ms. Rogers.
counsel, I don't care what answer you want. The person has a right to answer as long as they're truthful.
I can't fathom this. I can't fathom when I ask a question on whether or not yes or no, did you
make. I do this in every trial. I allow the attorneys to ask the question, and I don't tell them, they can't tell a person how to answer. I don't care if you only want a yes or no answer. The answer may not be a yes or no answer. So the person has to answer the question as long as it is responsive to your question, but you can't tell them how to answer in this courtroom. So, and I don't think that is fair to any witness. Say, I want you to answer it the way I want you to answer it. No, you can ask the question the way you want it. You can't tell them how to answer because the answer may not be complete. Just because you don't want a complete answer, you don't get to tell them how to answer. And that's the rule in this courtroom. In every case, I don't let anyone tell a person, ask the question and tell me, I want to tell you how to answer it. So you can continue.
I mean, Judge, you just handcuffed me. I can't proceed.
No, I didn't. I didn't.
Judge,
you can answer your question, sir. What you're doing is
you essentially told me that I can't practice law like I've been practicing law for the last 18 years.
I don't care how you've been practicing counsel.
I cannot defend my client, Judge, restrictions. I'm sorry. I cannot.
What you're saying is, I want to handcuff, sir, I'm talking now. What you're saying is, I don't want you to handcuff me, but I want to handcuff the witness. I want to ask them a question, and I want to tell them how to answer. No, all I want is a truthful answer. You don't have to tell, they don't have to tell them. It's a truthful answer, sir. It doesn't have to be the way you want it, as long as the answer answers your question, not necessarily how you answer, how you want it. So that's the way we're going to proceed with this. I don't want a yes or no answer. I want a answer that a question the witness can answer the way he wants to answer, as long as it responds to your question.
I do have a procedural question. Has Ms. McAdowell done a written waiver of jury? Does the court know?
I don't know, you're her lawyer.
Judge,
Did you request it?
But no, I didn't. I want to know if there's a written waiver of a jury trial in the court's file. Ms. Rogers,
Did you submit
aware
one?
of, are you aware of a
You are
written
her
waiver?
attorney, sir. Did you submit a waiver of trial, of jury trial? Did you?
No, I did not, but I
Then
didn't.
how would it be in the court file, sir?
There's two other hearings. I just didn't know. Thank you, Judge. I'll keep on going. Mr. Kincaid, you heard the judge's directions, I guess. So if you want to elaborate, I'm going to ask.
It may be a yes or no answer. I don't know, but you don't get to tell them how to answer. That's all I'm saying.
I wasn't telling him how to answer, Judge. I didn't.
Yes,
say
you did.
yes.
You said yes or no. That is a direction from you to tell them how to answer. That's exactly what it is.
Because that's what I'm asking for, a yes or no.
That's what you want, counsel, but that may not
Judge,
be.
I'm on cross. I can ask my questions.
But you can't tell them how to answer. Answer any question you want. You can't tell them. I'm going to give you a question. I want to tell you how to answer. That's what I don't allow. You can ask the question. If the answer goes off, if he's trying to say something that is not a direct answer to your question, we'll strike it.
Judge, Ms. Rogers has the opportunity to follow up.
No, sir. I am telling you how I conduct my court. Ask the question. Do not tell them how to answer. If the answer is not responsive, we'll strike it.
I can't proceed then. I can't. If the court's going to restrict me on how I have to answer my questions, I can't proceed.
I'm not restricting you on any question,
You are,
counsel.
Judge. You are, Judge.
No.
I can't proceed, Judge.
Well, then don't proceed, counsel. But I'm telling you, you can ask any question you want. Just because they answer it in a way that you don't like does not mean you are not able to ask questions.
I'm at an impasse. I don't know what to do.
I don't know what you're going to do either, there, counsel, because I can't tell you how to practice law. I can only tell you how you can't tell a witness to do. That's the only thing I'm saying. You can't tell a witness what to do or how to answer.
And I've been doing it wrong for 18 years, Judge.
No, you're doing it the way other courts allow you to do it. I don't allow any lawyer to ask a question and then tell them how to answer. That doesn't make sense to me. That's not the answer I want to give.
As long
as it's responsive. As long as it's responsive, sir.
I give him 2 options, Judge. I'm not telling him how to answer anything.
Then what is that, counsel? I want a yes or no. You have told them how to answer. The answer may not be that clean cut or clear. The answer may come out yes or no, but you don't tell them in advance how you want them to answer.
Can I talk to my client in a breaker room, Judge?
Yes, you can.
Actually,
Were
Ms. Rogers,
will
you come in with me too, please?
Yes, if you'd like me.
Yeah.
Okay, Miss McAdoo, you were in a breakout room with Attorney Rogers earlier. If you touch your screen, you should see 3 dots and you should see something that comes up that says, join the breakout room. You can go back into that breakout room. If you can't figure it out, I can move you to a different breakout room, but I can't send you back into that same breakout room because your device is already saying you could go back in. She's gone back in. Oh, she hasn't yet. Ryan Hill has gone in. Do you see it, Ms. McAdoo?
No, Your Honor, I do not. I was not in a breakout room with.
I show that they had you in their scheduled one. I'm just going to move you. I'm going to move you both to a different breakout room.
Thank you.
All right, attorney. Okay, let's see. Attorney Hill.
Yes, Judge.
Ms. Rogers. Okay, I think we don't have audio for Attorney Rogers now. Let's see. Oh, she muted. Okay. Attorney Rogers?
Yes, I'm here.
Attorney Hill, there's something I want to bring up to both of you, and you can discuss how you want to proceed on this matter. But I see what it looks like might be potentially errors on two of these tickets, or something that on the ticket number V128753, although I have a light copy, it does not look like there's a officer's name on it or a signature. On ticket number 128751, although it is light, it is a different date for the incident.
Motion to dismiss.
This did happen at a different date, as I think the investigation was continuing on. We can piece this one out and do it as a separate trial, or we can combine them.
Okay, I would have thought that these were the same date because the ticket numbers are consecutive. I have 128751 and 128752. One date says September, looks like 11th. So I would find that that would be the September date on a ticket number that was earlier, and then the August date on the ticket that would have been consecutively, which matches the earlier tickets.
That is correct. If I could on direct ask Investigator Green on how these dates and tickets were issued.
Is that something you want to do in a breakout room with the investigator? Because to me, I can't fathom how the ticket numbers would have been out of order in that fashion. So.
Yes, I can ask him in a breakout room.
As far as the ticket that has no investigator on it and no signature, are you dismissing that one? Or Attorney Hill has requested a dismissal on that?
Is that 5-3? Is that 5-3?
5-3, correct.
Okay.
If
I could talk to Investigator Green in a breakout room.
Very well. Investigator Green, let's see, where are you? Investigator Green?
Yes,
unmute
sir.
your microphone.
Yes.
Can you touch your screen and go back into breakout room? You were in breakout room earlier, breakout room 2.
Yes, sir.
And Ms. Rogers, I'll put you into.
Sydney, I made you a co-host so you can.
Is he talking right now?
I have no idea.
You're absolutely correct. I apologize, Attorney Hill. I was just talking away and I was muted, didn't realize it. I was asking Attorney Rogers how one on ticket number V128753, which appears to be a ticket to me that has no officer signature on it or any type of I did raise that to both attorneys, and Attorney Hill has asked for a dismissal on that matter.
Yes, thank you for bringing that to my attention. I have spoke to Officer Green. The people are not proceeding on ticket ending in 8753, but are proceeding on ticket ending 8751.
Okay, I'm certainly like to understand how that ticket has a different date of incident. Certainly follow-on tickets we can do that, but that ticket has a earlier number than the second ticket. It's 12 days earlier than the ticket ending in 752.
Ray, I understand.
I apologize, I said that backwards. The ticket number is 11 days after, but it has a earlier ticket number. So I guess someone can skip a ticket and then come back and write another ticket later, but it's 7 days, it's 12 days later. That just seems a little bit odd to me.
Correct. I'll put testimony on in direct, but what happened here, animal control writes and investigates differently than Detroit Police Department does. And if you look, all of these tickets are issued on the same day of September 15th, 2022. But the top date is the incident date of when the behavior happened. So on ticket ending in 8751, the investigator Green attempted to give the defendant additional time to get in compliance. She did not, and that's why there's a later date on it, but it's earlier in the sequence of ticket numbers.
I imagine that'd be quite the subject of cross-examination, but certainly do you have an explanation for it? And we'll proceed, and obviously counsel can cross on that. So.
Okay, sorry, just for clarity, because I can't read the ticket. The one ending in 5-3. What is
That's
that?
the one that one's dismissed. That is a ticket that is any person who has custody of an animal shall prevent the animal from engaging in nuisance, menacing, potentially dangerous behavior.
Okay, and the 5-1, the one that the court may have had an issue with. What I can't read that. What is that one alleging?
Ticket is fail to vaccinate or provide proof of vaccination.
Okay. Okay.
And I'm actually reading this from the copy of the ticket. So
okay,
the photocopy of the original ticket. So
okay. I guess, Judge, I'm going to proceed with cross.
Very well. Thank you.
Mr. Kincaid, so you heard what the judge said. I may, because of habit, say yes or no. The judge has indicated that you don't have to answer yes or no. You can elaborate. So just what if I do say that and you want to elaborate, I guess you're allowed to, okay?
Okay. As long as it is responsive to the question. It can't go off on a tangent or talk about other things.
Sure.
As long as it's responding to his question.
Your dog Chelsea is a Bugles or a Beagle?
Beagle mix, yeah.
Okay. And let me ask you this. How long have you had her?
We got her in 2019.
Okay. And have you had any behavioral issues with that with Chelsea at all? Any viciousness, anything like that?
No.
Has she ever bitten another neighbor's dog two or three doors down from where you live?
No.
No. She ever attacked another dog?
No.
Now, your prior testimony, you indicated that my client's dogs were pulling. Isn't it also true that Chelsea, she saw the dogs, correct? And she was also kind of pulling you in that direction. Is that accurate?
I don't, it may be, I mean, I know she turned to them and was probably, leaning forward, but not, she wants to check them out there. That may have happened. Yeah.
She was barking. She was barking as well, right? Barking at the dogs.
I don't know. I really don't know.
Okay. So you don't know if she was pulling, you don't know if she was barking, right?
Yeah, right. Yeah.
Okay. And you said something interesting. You said I was trying to pull my dog away during the altercation and all of this. Do you remember making that statement?
Yeah, I don't know exact wording, but yeah.
Well, what do you mean by all of this? You were doing additional things to diffuse the situation, weren't you?
Well, when you mean like, so what happened when the dogs came across, I saw them, I thought they're going to pass by. As I mentioned, the split second, they were on us. Pitbull had gotten my dog. And that's when I realized, and this is happening literally split second, that this was happening. And I tried to get her out of there, but the dog was pulling on her. And all I could think of in the moment was to pull as hard as I could to free her.
Let me stop you there. You said in the moment you were trying to get her out of there. Isn't it also true you were upset, right? You were screaming and yelling at my client to get the dogs off, correct?
Yeah, when I was on my
That's fine. I don't.
Yeah.
Okay. You were also punching and kicking the two dogs that were on the ground, my client's dogs, correct?
No.
You never made contact with any of the dogs?
Well, yeah, them on, yeah, her one dog on my left hand and the other dog on my, no, I was not punching or kicking a dog. Look, man, I'm on
All
the
I
ground.
ask, I don't need an explanation. Ms.
Okay.
Rogers she has an opportunity to do that. Now, let me ask you this. I'm going to say yes or no, but if you want to,
Okay.
explain, I guess the court will allow you to. Isn't it true that when the dogs actually met, that your dog, Chelsea, bit the pit bull first?
No,
Okay.
no,
Okay. Isn't it also true that once my client gave a command of leave it, the pit bull stopped immediately and sat down? Is that true?
no. And
Okay. And did you ever actually attempt to kick one of the animals, miss the dog, and actually kick Miss McAdow?
no.
You never made any contact whatsoever with her?
No, I don't think so. Look, I'm on the ground. This is insane, right? Everything that's happening around me. I may have touched her, hit someone with my foot. It was crazy. I don't know how else to say this to you guys. Like,
I understand that, but let me ask you this. Isn't it true that after you might have touched her with your foot, which I would call a kick, after you might have touched her with her foot, isn't that when the golden retriever bit you? Yes or no?
No.
That happened before?
What happened was her dog got to my dog. I realized what was going on. I heard the scream. My instinct was to pick my dog up and just pull her out of that. When I did,
I heard that testimony before. I want to ask about the time when
counsel, don't cut the witness off. He may have more to add.
He's not responsive, Judge. I asked a question about.
I don't know if it's responsive because you stopped him.
Judge, you have to let me cross.
No,
you have to let me cross, Judge.
No, hold on. If it's not responsive, I'll strike it. But you can't stop him because I don't know what he's going to say. It might be something that's attached that is responsive, counsel. If it's not responsive, I'll strike it. Pardon me? He's describing, he said, counsel, he's describing something that was very active and he said crazy. He may not say it in the first word or the first sentence. Let him finish answering. If it's not responsive, I'll strike it.
Judge, my question was about a kick, not him to recite what he said already to Miss Rogers. Judge, you have to let me do my cross.
Counsel, you're the one that cut him off.
I cut him off.
He may not be done with his answer. No, you don't know what's responsive.
Judge, I'm sorry, this is impossible. I cannot effectively represent my client when the court's going to restrict me like this. I can't.
Counsel, I'm not restricting you. You're the one trying to stop the witness from testifying. If it's not responsive, I'll strike it.
Judge, let me rephrase
it. If it's not responsive, you said it's not responsive. He wasn't done. I don't know if it's responsive. If it's not responsive, I'll strike it. It won't be a part of the record.
Mr. Kincaid, I'm going to rephrase the question and please listen to me. I've heard what you said already to Miss Rogers, okay? You've already said you may have touched my client with her foot. You've already said that. That's on the record, okay? My question is very specific, okay? When you may have touched my client with her foot, did the golden retriever bite you before that or after that? That's all I want to know. That's the question I asked you previously. It's the question I'm asking.
No, it wasn't that clear cut, counsel, because I didn't hear it in that way. So he can answer the question. Go ahead, sir. Answer the question.
Look, the answer is I don't know. All I know is.
Thank you, sir. Now, if it was after, obviously the dogs were there, right? The dog bit you. Would you agree that you kick someone's owner, the dog's going to react, isn't he?
Objection, that's misstating the testimony. He never said he kicked the owner.
Hold on
Mr. Kincaid, if you can.
Hold on. What? No, counsel. How can he say what a dog's owner is going to do if he touched, kicked, or whatever? How do we know what that dog's response is going to be? He can't talk. He can't say what's in the dog's mind. You can't even say if the dog saw it. You don't know. So that's not a valid question. The dog would have done something obviously because he kicked the owners. I don't know what he would have done.
After this incident, you walked your dog home. Is that accurate?
Yeah, I went home. I would not call it walking my dog home. I would call it limping. It was bad.
The dog was, I understand. I did see the pictures. I saw puncture wounds. I saw that, but the dog did walk home, correct?
Yes.
Okay. Again, you've already testified to this, but you have no idea you indicated you had no idea whether or not the dog was actually on a leash at the time of the accident, correct, or the incident, correct?
Which dog are
no,
we referring to?
Either of the dogs, my client's dog, the pit bull or the golden retriever.
I saw her coming across the street with the two dogs. I saw two leashes and they were pulling her. She was coming across the street. And again, like I said, I thought she was going to pass by, but I could tell as they got closer that there were two leashes. They were pulling her across.
Okay, so you never once saw, again, my question is, you never once saw the dogs off a leash. You assumed that maybe they had gotten off, but you never saw that, correct?
Correct. Yeah. Okay. Wait, hang on. The other thing is, I don't think I ever said anything about them being off leash. I think that's been brought up on leash, off leash, whatever. I'm just stating what I experienced there. That's, I don't.
Ms. Rogers, isn't that 5.2? Again, I can't read the citation. Doesn't that 5.2 have to do with leashes as well?
I can read it if you will allow me to read the written offense. Do you want me to do that on the record, counsel?
Please.
I can read my copy.
Please.
It says fail to provide a lease and or a responsible person to hold on one second. That word is person. One word I can't read. It says dog off of owner's property.
I'm going to pull.
Fail to provide a leash and or responsible person for the dog off owner's property.
Ms. Rogers, I guess obviously there's no other witnesses. Can we dismiss that one? I know we're in the middle of cross, but if the only witness can't testify that there was she had him on a leash, she had him on a leash, and he just stated that he never once said that they weren't on a leash, can we dismiss that so we can kind of get to the nuts and bolts?
If I could do redirect, please.
Oh, okay. Well, then okay.
You're not done, are you yet?
No, I'm not done.
Okay.
Were you aware that my client's dog had puncture wounds and was bit by your dog? Were you aware of that?
No.
She never told you that in the conversations after this incident?
I don't think so.
Were you aware that her dogs were vaccinated at the time of the incident? Yes or no?
No.
Were you aware that she immediately went and got revaccinated after the incident? Yes or no?
No.
Okay.
Well, so to the point, brother, you're right. I didn't know that, but as you've probably seen in the letters we provided, we asked for that information so that we could know we never received anything back on that. Just as a note, okay?
I understand that, but you do understand why an individual would not respond when you're demanding that their dogs be euthanized as well, right?
No, we did not demand that they be euthanized. We outlined in our letter to her, we said, look, you need to be able to make sure those dogs are secured safely so this doesn't happen again. If that's not possible, then given what happened, we don't want anybody to get hurt. I don't think that.
If somebody was threatening to euthanize your dog, would you respond to them, sir?
Counsel, he has answered that question multiple times. He said he never demanded that they euthanize their dog. So he said that twice. Your questions on several occasions after that has said that he demanded that. He indicated he did not demand that the dogs be euthanized. So he answered that question. He said he did not do that.
You're muted, Mr. Hill.
My question is the court objecting or is Ms. Rogers objecting to my line of question?
No, I have indicated earlier, you asked a question and now you ask another question that says you demanded. He said just now, again, I never demanded that the dogs be euthanized, which you went into the next question. Well, if you such and such Counsel, he answered the question. He did not demand that the dogs be euthanized.
He
Move
did.
on.
He admitted he demanded it. He just had, he had some.
No, he did not do that.
Can I finish,
He
Judge?
said,
Can I finish, please?
Counsel,
Can I
I
finish,
listened
please?
to the evidence. He said he wrote a letter. He was asking about vaccinations, and he was saying that maybe that's something that should be happening, but he never demanded or asked that the dogs be euthanized. It was a follow-up to a question that he had put to them. Was the dog vaccinated, and some other questions, and he said there was some question about euthanasia, but he said he never demanded that that happen.
Let me ask you this way then, Mr. Kincaid, is that in your letter,
Yep.
do you suggest that if they were unable to keep their dogs under control, that you wanted the dogs to be euthanized?
Yeah, I mean, I'm looking at my document here too.
Can you read it? Can you read it to the court, please? Thank you.
So we ask that you take we request these actions. You ensure your dog is not capable of doing this again. To be specific, given your dog's unprovoked, vicious, and devastating actions, we request you either euthanize the dog or place it somewhere. No. But I'm not demanding. I'm saying I don't even know why I'm defending myself here. All I'm saying is
Sir,
okay.
Just finish what you were saying.
Okay, thank you. So that you either euthanize the dog or place it somewhere where it can no longer hurt anyone permanently. We're not telling her to euthanize her dog. We're saying just make sure the dog can't be somewhere it can hurt someone. But if you can't do that, then
thank you, sir. So the very first thing.
Objection. Could he please answer his question?
Here's a problem, Ms. Rogers. Is that you listen? In every other court in the building, you're going to have an opportunity to cross-examine. Okay, right? He just read.
Counsel. She also has the right to stop. Hold on, counsel. You know, counsel. I'm just going to mute you.
Unbelievable. You're
no,
letting
it is unbelievable.
You're letting
it is
him
unbelievable.
explain a letter that I asked him to read the record.
Counsel, stop. I'm going to give you the opportunity to talk. The person was reading something and you have turned it around. He never said, hold on, counsel. Counsel, stop. He never said, I am demanding euthanasia. He said, I want you to take measures to protect the community. He said that. He said, if you cannot do that, this is an option. There was no demand. He never said he demanded anything. He read the letter to us, counsel.
He did. And the judge, you know what he did? He started to explain it. And I asked him to stop. And Ms. Rogers objected. And then you just supported her.
Because it was still part of his answer to you from you.
No, it's not.
The question that you put before him.
Oh my God. Judge, when I say read the letter, I didn't say read the letter and explain it. That's for Ms. Rogers to follow up, Judge. I said
counsel,
read the letter.
Counsel, he read the letter. He said, okay, move on. Move on, counsel. Ms. Rogers, were you done?
Yes, my objection was to allow the defendant or
say
the
whatever
witness,
he wants. To let him say whatever he wants.
To answer the questions that are presented to him.
Counsel. You may be upset, but you got to control your behavior.
Judge, I don't get it. I'm trying, Judge. But when I ask him, and maybe no one can hear me, maybe I'm muted. When I ask somebody to read the letter, I asked them to read the letter. He started to explain the letter. And I know the court has restricted me from certain questions. I get that. But I asked him to read the letter. I didn't ask him to give me his spin on it.
But you put your spin on it, counsel. You put your spin on it. That's the problem.
I'm just trying to ask questions, Judge.
No, you put your spin on it. You turned that into a demand. He never said he demanded anything.
Judge, did you just listen to him read the letter? The very first
yes, I did.
thing he says is you either euthanize the dogs or move them.
No, he said these are options. That was the one option. He said,
okay, can you read the two options
take
again, please?
measures to protect everyone. Or you can do this. He did not say, we are demanding that you kill your dogs. He never said that.
I would just ask the court and Ms. Rogers, if you could listen to my question that I'm asking before objecting, because my question was very specific. I asked him to read the letter. I didn't ask him to so I'm going to ask this, Mr. Kincaid.
I'm talking about what you said afterwards, sir. When he had read the letter, and then you turned, when he gave the options, you still turned that into a demand. You were talking to the court then.
I did not.
He said, when someone's demanding, yes, sir, we have a transcript. So
I will, Judge, I'm going to order it. I'm going to order the transcript. Mr. Kincaid, all I'm asking you to do is this. I don't need any commentary. And again, You know what, Ms. Rogers probably won't have to go and redirect after what's happened here today, but what I'm asking you to do is this. Read the two options again, the two options you gave verbatim. I have a copy here. Read it to the court, please.
Yep.
And stop after that.
You ensure your dog is not so this, sorry, I have to front. I wish you all the best. I look forward to a day when we can both move beyond this incident. In the meantime, I am requesting 4 actions. 1, you ensure your dog is not capable of doing this again. To be specific, given your dog's unprovoked, vicious, and devastating actions, we request you either euthanize the dog or place it somewhere it can no longer hurt anyone.
May I stop you right there, sir, and ask that question? So the very first thing you say is either euthanize the dog or place it. You're meaning move the dog, not move it out of the neighborhood. Is that what you meant?
No, not necessarily. Just somewhere that can be secure.
Okay.
I mean,
okay. All right. But you do agree the very first thing that you ask for is either euthanization or place it somewhere else, right?
Yeah.
Okay. And again, to ask you a question, if someone asked you to euthanize your dog, would you have interactions with them after they asked you to put their dog down? Would you be a little hesitant to have a discussion with somebody after the very first thing they asked you to do is euthanize the animal?
I don't know. This is a pretty crazy incident. If our dog did all this stuff, I don't know what I'd be thinking. I'd be pretty scared, honestly.
Did you call the police that very day? Did you call them days after?
A few days after, yeah. We were.
It was after. That's fine. It was after you left these letters in my client's mailbox. You left 2, correct?
We did. We left 1 initially, and then we hadn't heard back at all, and so provided another one. And I think at one point we had also shared the emergency surgery bills too.
Can you look at the screen? Oh, hang on. Did you see that, Mr. Kincaid?
Yes.
All right. Are those the letters that you attached to my client's door?
No.
No?
No.
I'm sorry, if I could stop briefly. Whatever
I don't-
you're proposing as evidence, exhibits, I believe, I've never seen.
You've never seen these things before?
No, and they have not been. I'm sorry, Mr.
Oh, sorry.
Kincaid. Sorry, it's okay. The people have not been provided any of this. I don't believe so, at least. I can check.
No, you haven't.
I have or I haven't.
You haven't.
What are we looking at, Attorney Hill?
I just said no, well, nothing, because he can't identify it. So obviously I can't introduce it if he can't identify it.
Okay.
But you did state that you had sent 2 letters to my client. She didn't respond, so therefore you called the police. Is that accurate or no?
I don't know that the sequence was like that. My wife and I debated on this. I wanted the whole thing just to end, to go away. I didn't want anything else. I just wanted to get all the stress out of this thing and move on. And I remained, obviously concerned about the community overall, and we wanted to do the right thing to convey it to the police, and that's what we did. That's it.
Okay. You didn't call the police in retaliation because my client wouldn't communicate with you?
Objection, argumentative.
It's a question. It's a question, so it's allowed.
Thank you.
No?
No.
Have you ever had any instances with these dogs previously?
No.
Have you ever heard of any neighbors having problems with these animals?
No.
In fact, you've had other interactions with these dogs, correct? Like you've seen them out before and they've never been aggressive at all, have they?
I don't know that I've seen the dogs before.
I have nothing further. Thank you, Mr. Kincaid.
Judge, if I could proceed on redirect.
Yes.
Thank you. Very briefly, Mr. Kincaid, I know you've been testifying for a while now. Regarding if the dog was on the the dogs at one point were on the leash, correct?
Correct.
And was when the dogs were biting both your dog, Chelsea, and yourself, was the defendant in control of the dogs?
No, in control of the dogs? No.
And could you tell if she was holding the leash at this point?
Objection asked and answered.
This is a fresh.
No,
No,
I don't, when was that question asked?
it was asked
I
on
don't-
direct and he said he didn't know. He said he didn't know if she was holding the leash. He said, I
Okay.
assumed the leash might have been released because the dogs were fighting, but he said he didn't know.
But she can go into some clarification based out after a cross, so we can do that just for clarification. So go ahead, counsel.
Thank you. Do you recall if she was holding the leash or not?
When it was going on, the attack?
Correct.
I really don't know. I just don't know how to express it to everybody on this call, but it was crazy. I'm on my back, it was just crazy.
I see.
Yeah.
Go ahead.
That's it.
The whole incident happened over probably the course of minutes, correct?
Yeah, it was, yeah.
No, I understand. If you recall, was the defendant close to you, the defendant herself, close to you while her dogs were biting you?
I don't know. I recall kind of seeing her behind her dogs, because I think she was trying to stop them or pull them. She was, I don't know, behind them at some level, because I kind of came back and I'm on the ground and I'm trying to like fend off. I know the other dog was here and I could vaguely see her in the distance, over across the dogs, but she was behind them, I think, trying to pull them off, particularly the pit bull.
Okay. Could you tell if she was more than 6 feet away from you?
I don't know. It's probably around. I can't recall. I don't know.
Okay.
I mean, she was behind the dogs that are there. So I don't know what that distance would be.
Okay,
And,
thank you.
And can I say something?
If it's related to my question.
It is. This whole thing about kicking or so forth. That this is. I don't know how else to say to you guys. I'm on the ground trying to basically fend all this stuff off. I don't know where my feet are. I'm not, if somehow I touched her leg or, I don't know, like, all I know is, this is all going down and I'm trying to save our dog. I just never.
No, thank you. I understand this. Sounds like it was a very traumatic few minutes.
Yeah.
And then regarding of when you called the police, and the investigator came, did you give a statement of what happened on that day to the investigator?
Yes, I believe, yes.
And was this
Yeah.
a truthful statement about what happened on the day in question?
Yes.
And post sending your 2 letters to the defendant, did you ever send any additional letters to the defendant?
No, we kind of just stopped. We felt like we were stuck in it. I didn't want to relive it anymore. It was just, I mean, that's why this whole case, all this stuff even now is kind of gut wrenching. We so desperately as a family, we've got 3 little kids. We just wanted to move on. And I don't even know if that was the right thing, but we just wanted to move on. So this is all just rough.
I understand. Thank you. Nothing further from the people.
Nothing based on that, Judge.
Well, Mr. Kincaid, you could go back into the breakout room, or we can put you back in. Or well, hold on one second. Attorneys, can we release Kincaid?
Sure. I mean, I don't.
Yes, he can be released.
All right, Mr. Kincaid, you're free to sign off.
And Mr. Kincaid, I'll give you a call on the phone later today.
Okay, thank you.
Thank you very much for appearing today.
Thank you.
Sydney, before I call my witnesses, the very last ticket, the 5-2, is, you said section 622B?
Correct.
Okay, counsel, if I can assist on that, I do have 622B.
So I'm looking at control of dogs, section 621, 622. There's no B.
Where I just looked at it.
It says dog license requirements. This code shall not apply to any dog temporarily within the city. 622 6-2-2 is dogs within city limits for less than 30 days.
Wait, I'm confused. Are you looking at 622B?
I'm looking at 622. Section 622 doesn't have a B.
I'm looking at it. On Muni Code, I see section 22B. No owner of dog shall allow dog to be off property. Hey, do I have that right?
6-2-2.
Correct. I'm on just
I-
Muni Code online.
I am too, and it says 622 is dogs within city limits for less than 30 days.
Ms. Rogers, could you email that to, or I don't know, are you looking on the computer, which you can't show us? Can you screen share it with Mr.?
Oh yeah, I
O'Reilly?
can email it, but screen share is probably the easiest
Yeah.
to see what the problem is.
Unless that I'm on an old Muni code.
I'll show you what I have.
Do the same thing mild though, okay?
Okay, can you see my screen?
Yeah, that's not what I have. Dog restraint, prolonged tether, providence.
I got a Muni Code a few minutes ago.
Sure, okay, and you guys, that section 5.2, you're going on. No owner of a dog shall allow a dog to stray on a public street or unless held by a leash, which is extended more than 6 feet. Okay, all right, thank you. Judge, I guess I would have a motion for directed verdict on the 5.3 ticket, the 622 dog restraint. I think there was no testimony. Actually, the testimony was that the dogs were on a leash. He was unsure whether or not the actual dogs were off a leash.
Counsel, one second. The 5.3, I thought Ms. Rogers had not objected to your motion to dismiss.
No, she did object and she wanted to put proofs on, unless you're going to stipulate now, Sydney.
That was the ticket where it doesn't look like the officer signed the ticket.
So first, I think this motion is premature as the people have not rested. I still have another witness.
Oh, you do?
Investigator Green.
But if he wasn't there, can't we just take care of this now?
Well, I need him I have an issue with a date. I need him for the document cases.
Okay, but let's just, okay, I'm not gonna tell you your case, but just the facts of the leash thing, can't we address that ticket without him or no? And there's a reason why I'm asking that. Because what's left?
That'll be the document cases.
Then I'm not worried about those. What I'm saying is if you're gonna stipulate to that, then you know that everything was corrected, then we don't have to go to trial on those. That's what I'm telling you.
You can handle your motion first, but I can't stipulate to it.
Okay, so I'd have a motion, Judge, to dismiss, being on the fact that directed verdict, the only witness to the incident could not establish that the dogs were off a leash. He assumed because there was an attack going on. And I don't think that they've established their burden, so I'd ask the court to dismiss.
All right, Ms. Rogers.
Yep, thank you. Looking at this ticket, looking at the Muni Code and what the victim witness testified to, that this incident happened over just a few minutes. It was a very quick incident. Clearly the defendant was not in control of her dogs. If the defendant had the dogs on the leash the entire time and allowed the dogs to bite a person and another dog, that would be a whole different charge here. This happened very quickly. The defendant or the victim witness said that he couldn't see everything, that the dogs were once on the leash, but when they were attacking him, he thought that they were not on the leash and that the defendant herself was behind the dogs. He wasn't sure how far away they were. She could have been more than 6 feet away from him, but the defendant was not in control of these dogs while they were attacking the victim witness, or that would have been charged differently if she was controlling them and telling them to attack. It doesn't appear that they're on the leash here. It's hard to, for the victim to remember everything that happened here and the details of everything because this was such a traumatic event and happened so quickly. But the dogs were not being controlled by the defendant.
Can
And that
can
is
you go
clear.
can you go back to the Muni code so I can see the language of that?
Correct. Yes.
Okay, I'm reading it. I'm just gonna do it out loud. So no owner of a dog shall allow the dog to stray on public or private property other than the private property of the owner. That does not apply unless held properly by a leash, which is extended no more than 6 feet or under restraint, provided that police dogs accompanied by their trainer while inactive, those dogs are trained and not subject to. All right, Ms. Rogers, let's see. Counsel, I'm having a difficult time finding how this is applicable in this case. If we break it into parts, no owner of a dog shall allow the dog to stray. Okay, that obviously didn't happen. Other than the private property owner unless held properly by a leash, which that doesn't apply, or which is extended no more than 6 feet or length or under restraint provided that police dog. I don't see how this language applies in this matter. You were speaking of, and I know there is something out there somewhere that talks about even that the dog must be maintained or his conduct or activity must be controlled. I don't see where I have that in this statute or in this section under the Muni Code. I don't see anything that says the dog was did have a leash or a tether. But it does not, in this section, it does not talk about maintaining some type of control. I believe that is something out there in one of these sections, but I don't believe the section that it was charged under is applicable.
Okay, thank you, Judge.
So Sydney, what does that leave us with? 2?
That's correct.
Can we plead to 1 under delayed now that she's in compliance with everything?
I can make it contingent on restitution.
As long as we have a hearing on restitution, I'm not going to agree to whatever numbers provided. We'll let the court decide, right?
Correct.
Actually, if there's already receipts for restitution and they appear to be as a direct result of this, I think that's something you might be able to agree on. So they're not making up numbers if they have from either the doctor's office or whomever did anything, and there's provable things and not just, well, I think I should get more money for something.
Judge, we can, Sydney, you and I will work that out, right? Like, the only reason why I say that is I had a case in Judge Bryant's where the guy was asking for 6 weeks of lost wages. We had to hold a hearing. So if you can do a 1-for-1 on a delayed, my client will pay. We'll agree to pay restitution. If there's an issue, then we agree that the judge can do a quick hearing. Is that okay?
There will be 1 guilty plea with a 12-month delayed sentence.
12 months.
That's the best I can do.
Sydney, listen, the 2 charges were dismissed. We're talking about a vaccination now, and we're talking about an unlicensed dog. We're not talking about unleashed and no control. Those were dismissed.
That's best I can do.
Can we go off the YouTube?
Yes, we can do that. This is just some, yeah. Let me do that.
Crystal, could you turn the YouTube off? Because they want to.
On today's menu, we have a scheduling and bond hearing with a backstory.
How's the case, people versus Regina Williamson?
Good morning again, Your Honor. Ashley Londy for the people.
Morning, Your Honor. W. Otis Culpepper for Ms. Williamson.
And good morning, Sandra White on behalf of Regina Williamson.
Let me explain what.
Well, hold on. I think Mr. Culpepper might have. I have his appearance. I see what happened.
We haven't put in a substitution. I wasn't aware.
Yeah, there needs to be a substitution instead of an appearance, but that I'll let Mr. Culpepper proceed. I don't think he'd appear if he didn't represent her, so. All right.
I wouldn't. I apologize. I didn't know that I had to do the substitution as well as the appearance with the court appointed counsel.
Yes, sir. Yeah, well, and just so that you know, and into the future, and for those listening, it's better to do the substitution. That way the flow of discovery can happen also to you without, there still might be issues, but the system is set up so that can happen. So that's why we would require that. But it would have been complicated in this case because Miss White was just put on the case and then you came in. So things got crossed, but we're good. We can move ahead, I think.
Right. Anyway, today is PCC, Your Honor. I have some requests if I can make to the court.
Yes, sir.
All right. Well, I don't know how since previous counsel she may have had discovery already. I don't know. I would need discovery, and at the appropriate time, I'd like to address bond with regard to Ms. Williamson.
All right. Did you want me to adjourn this out then?
Well, I was going to see if the court would consider listening to a bond argument today, because Ms. Williamson is employed at Ford Motor Company, and I would like, if there's a possibility we can maybe get this bond reduced so she can get back to work, I'd appreciate it.
All right. Okay. So, well, with the first request with regard to discovery, because of the fact that the PD was on the case, Ms. White comes into the case and I had signed that order. I don't know where discovery would be at this point in time. I think though that if you do the substitution with Ms. White, that discovery would then flow to you, or at least what's there would flow to you.
And Your Honor, to expedite the process, I put the email address that Mr. Culpepper could send his appearance to get the discovery quicker in the chat of the Zoom. So that should also help speed things up for him.
Thank you, Kai.
You're welcome.
Real good. Okay. As to bond then, before I set a date or what we're going to do.
Yes, sir. Your Honor, Ms. Williamson has no prior record whatsoever. She's a resident of the city of Detroit. I don't think any of the cases that she's charged with exceed 5 years. Her bond presently is set at $25,000 cash. She has no prior record. She's working. She has family in Detroit. I don't think that there's any question about her likelihood of flight. Her residency is well established. She's employed. I think if the court would give her a little more of a manageable bond, given that this is, like I said, this is especially after the fact in possession of a weapon. $25,000 cash seems a bit excessive for that charge.
Response.
Thank you, Your Honor. Defense counsel is correct. This is Ms. Williamson's first contact with the criminal justice system, as far as I can tell. However, I do think it's important to note that what happened in this case and what is alleged by the people includes her being an accessory after the fact to open murder, where the co-defendant is Angela Weems, who also has a PCC up later today. The case also involves that she pointed a firearm at Darian Taylor, who was the ultimate victim of a murder.
There were 2 small newspaper blurbs about the shooting and then the victim being identified. And then I stumbled upon this. A long wait for an ambulance caused confusion and frustration in Superior Township after a man was shot. A man was shot at an apartment complex in Superior Township. First responders were frustrated that a Huron Valley EMS crew was taking so long to get to the scene, so they called in an EMS crew from Canton to see who would get there first. Darian Taylor, 30, was shot in the back and killed, according to family members. Within moments, Superior Township fire crews were on the scene giving Taylor CPR and trying to save his life. Washtenaw County Sheriff's deputies were also quick to arrive. Huron Valley Ambulance was also dispatched but did not arrive right away. The closest ambulance was on a priority call that came in just before the shooting happened. Another Huron Valley crew was dispatched from the headquarters in Pittsfield Township. First responders were frustrated and asked for the EMS crew from Canton to come. Huron Valley arrived in 17 minutes. Taylor, unfortunately, passed away by the time they arrived. At the time of this article, which was June 29th, the shooter had not been located. This was on clickondetroit.com.
We are not saying that Ms. Williamson is the one who killed him. We are saying that Mr. Weems is. However, I do think it's important for the court to know that earlier in the evening where Darian Taylor was killed, that the facts do indicate and the evidence indicates that Ms. Williamson also pointed a firearm at that person. I do think it's important for the court to know as well that the defendant did have 2 firearms in her vehicle, and she, after this homicide occurred, transported the defendant to a location, and we believe the evidence will support a conviction for accessory after the fact to murder. I believe the bond is fairly set. I do believe that it's appropriate. I think the magistrate considered the facts. I think the magistrate considered the danger that Ms. Williamson may pose to the people that are in Darian Taylor's family if she is released. I'm not saying that anything will happen. The concern of the people, though, is that something could happen. And I do think that while accessory after the fact to a felony, in this case, open murder, is only a 5-year felony, it's an extremely serious charge. So I think the bond is appropriately set, and I'm asking the court to continue it.
Having her incarcerated also has the added benefit of accessibility, so they can go and talk to her and convince her to provide information on, the person who actually did it.
The one thing I always have to remind prosecutors is that if their view of the evidence was always accepted, people like me wouldn't need to have a job. We disagree with the recitation of the evidence as it will be borne out in court. And as I indicated previously, I just don't understand why a 5-year offense, even though a co-defendant is charged with a much more serious offense, and I get that, there's no indication that this defendant, even at its worst charge, should justify a bond of this nature.
Except for the fact that, accessory after the fact is going to be a 5-year. I think it always is important as to what that individual is the accessory to the fact after. What is the underlying crime? The underlying crime here happens to be murder. I think also the very fact that, and correct me if I'm wrong, Ms. Lundy, but the murder involved gunshots, or that was the method of?
Yes, Your Honor. The ultimate murder was a result, and the ultimate death was the result of 4 wounds, 4 gunshots that were sustained by Darian Taylor. 3 of those shots were fatal.
All right.
One other thing, Your Honor, it's interesting. I mean, if this were an aiding and abetting situation, if she had somehow aided or participated in this in any way, she'd be charged with open murder as well. The fact that that is not charged at all indicates that this defendant had nothing to do with the murder itself. And as bad as the murder,
there's a murder. My point is that there's a murder with 4 gun shots to an individual, and this defendant, it is at least alleged at this point in time, also has 2 weapons in her possession and aided in concealing, or at least alleged, aided in concealing either the discovery or having that individual come to justice. So I think all of that bears on the defendant's either flight, or it also bears, I think, more specifically on what would be her danger to the community. Motion for bond reduction at this point is denied. What do you wish me to do with this case?
We've set it for preliminary hearing.
Preliminary examination will be set in person, July 25th.
Your Honor, if the court please, I'm sorry, I have another hearing on July 25th in here in Detroit. That's a preliminary.
Are you waiving the timelines? I'll give you another date, but.
Can I do it in the afternoon?
Well, it won't be it's gonna be before me, and
Your Honor, I'm a
what-
little concerned, I'm sorry to interrupt, about setting the exam this quickly because defense counsel doesn't have discovery and there's quite a bit.
Well,
yeah, but if he wants his exam, I mean, and the stuff's not, because it's gonna be before me, so everybody better be ready to go because I will.
well, let's set it out then, a couple of days. I mean, until at least till the first week of August.
I got August 1st. Will that work for you?
Works for me.
August 1st, 2023, 9 a.m. That will be before Judge Barr.
The court wants this before Judge Barr, not before itself. Thank you.
Yeah, that's on the 1st. That's it. I don't need to keep it.
I do
got
have
plenty to do.
I do have
Thank
something.
you.
Okay.
Yeah.
I
Go
do have
ahead, what?
I'm looking at my calendar. I do have something on that day as well. And the second. My first open date is going to be the 7th or 8th.
I don't know that people get to pick their dates like this, but
okay.
that's
Well,
just, no, that's fine. Mr. Culpepper, you do it, and you guys. August 8th, 2023. This is the last time, 9 a.m. That case is now before Judge Burke.
And Your Honor, for the record, did defense counsel waive the 14 and 21 day rules?
Yes, I did.
I asked him, and I'm assuming that he's picking another date. He has done so.
Yes, we are.
All right, thank you. Bond will continue.
Ms. Williamson, we'll see you in jail.
We're behind the vehicle.
What's the vehicle description? It's a Nissan Sentra, 4-door, no tint, go up to 52nd Street.
So far, coming up to 52nd.
Eastbound on 52nd Street.
So far, eastbound on 52nd Street.
Going into the mobile gas station.
Pulling into the mobile. It should be 1033.
Alright, he's leaving. We're 1031.
Tempo, are you in the vehicle or on foot?
Vehicle.
10-4, 1031.
Stand by up there.
10-4, stand by for pit. 10-4.
If he runs, I gotta go. Don't help out.
Somebody behind me calling. They're in the bubble. Air 197, we'll call it. They're in the parking lot going around warehouse north of the gas station, the surface gas.
Anything.
Ready to set their unit call with.
10-4, units in 1031, Air 1 calling it.
All right, if y'all set up around the perimeter of that business, they can't go and get out. Hailing on foot, eastbound, towards the railroad track.
Stay in your car, stay in your car, stay in your car! Here, stay in your car! Here! That way, that way! Here goes, head out, you're under arrest right now, this dog! Park it, man! Park it! Here, park it! Park it, man! Park it! Park it! Park it! Park it! Park it! Park it! Get on the ground! I'm on the ground! Get on the ground! I'm on the ground! Come on, man! Ah, come on, man! Get on the ground! Come on! Roll over to your stomach! Roll to your stomach! Take him off me! Roll to your stomach! Off me! Get on your stomach! Come on, man! Put your hands behind your back! Put your hands behind your back! Put your hands behind your back! Okay! Put your hands behind your back! Other one! Now! Now! Let's put your hands behind your back! All right, get him off! Oh! Get on me! Get in there! God, boys! Gosh, boys! Gosh, boys! God, boys! How'd you do it? Why did you think that on me? Follow me! Follow me! I can't! Gosh, boys! What's wrong with your leg? I can't move it! Listen, we're gonna drag you out and you're gonna roll up and stand up. Your choice. I'm dehydrated. You're dehydrated. Just slow the car. Well, I grab one side, I'll grab the other one. Just take them out. Stand up. I'm trying to sit up. My legs are down. Your legs not tied down. Pull it out. There's a control unit coming in right now. Control unit, just go around that corner and go all the way, take that all the way back. Nice job. Good work.
State versus Mohammed Idris. Charges vehicle operator refused to comply with the police officer. There are 2 infraction charges as well. 3A0096934 is violation of a special trip permit, and 3A0096933 failure to obey traffic control device and failure to renew his expired registration on a vehicle. Mr. Kale, any contact from Mr. Idris?
Either Mr. Idris or a representative of Mr. Idris is present on Zoom, Your Honor. And I believe he may tend to proceed pro se, or at least without the assistance of public defense. So I would ask the court to inquire with him about that.
I will. So on the screen listed as Mohammed, authorized representative for Mohammed Idris. Is that right?
First of all, I object to public defender saying that I'm pro se, which I am not. I'm the authorized representative on behalf of the estate. And I would like to request for continuance due to I made a request for discovery, and there was no email provided to me. And I was informed that only a phone number is available. And I called that phone number and there was no answer. And I did not get any voicemail. And out of the 3 cases, I only received notice for 2. 1 is missing. I don't have the paperwork for that. Due for that reason, I would like to get a continuous.
All right, so let's start with this. Are you Mohammed Idris? Let's get the name straight to begin with.
That's the estate on the trust. I'm the authorized representative on behalf of the estate that the court is trying to administrate.
Well, the state's not charging the estate. The state is charging Mohammed Idris. So that's who we need to address. Is that you, is my question.
I object. If I have a question for, that's a question for the prosecutor, correct?
Well, you're here asking for a continuance because you want something else. I have to know who it is that is requesting the continuance and how you speak on behalf of Mohammed Idris.
I'm the authorized representative of the estate. Like my family name is Idris, given name Muhammad Ismail, for the estate, which is Muhammad Ismail Idris, estate on a trust.
All right, as I say, the estate is not being charged with the criminal offense. Muhammad Ismail Idris is being charged with criminal offenses. Now, you indicate that you only got 2 of the 3 notices. Which charges did you get notice of? Did you get notice for the failure to obey traffic signal?
I object to you're saying this has nothing to do with the estate. It has everything to do with the estate on the trust that's being charged.
Well, not to be argumentative, Mr. Idris, but the estate wasn't driving the vehicle. I suspect the city or the state will try to prove that Mohammed Idris was driving the vehicle. That's their job in this case.
I object. That's a hearsay. The court is assuming and presuming that's the case, which is not. So if you can continue with the continuous, I'll appreciate it.
Well, I'm going to ask the city or the state rather to establish probable cause at this time on the charge ending in, or the case number ending in 7205, which is the vehicle operator refusing to comply with the officer. You've already been sworn, Ms. Mann, so we'll go ahead.
The charge of refusal to give information on May 11th, 2023, Officer Kelsler responded to a request for assistance from Officer Turner, who had performed a traffic stop on a commercial motor vehicle that was traveling in a left lane prohibited for CMB southbound I-5 at milepost 96. The driver is later ID'd by his DOL photo on file as Mohammed Ismail Idris, and
I object.
Both officers within the ID, despite multiple.
Mr. Idris, hold on, Ms. Mann. Mr. Idris, please, let her finish.
Okay.
Let her finish. Go ahead, Ms. Mann.
Refused to provide both officers with an ID despite multiple requests by both officers. He was cited for operating a vehicle and refusing to comply with the police officer and released.
He was also charged with the infractions at that time.
Yes, Your Honor, and I have a probable cause for the special fuel trip permits violation as well, if you'd like.
Yes, why don't you give us that too?
On May 16th, 2023, Officer Turner observed a tractor trailer traveling south on I-5 near milepost 98, speeding and traveling in a restricted left lane. The officer made contact with the driver, who refused to identify himself, but was identified through his DOL photo on file as Mohammed Ismail Idris. While looking up his inspection history, it was revealed that the registration on the power unit had expired several months earlier and was revoked by the Washington State Department of Licensing. He was cited and released.
Is it my turn to speak?
All right, Mr. Idris, it's now your turn. Go ahead.
I object. I requested for continuous and I was not informed if it was denied or granted. And I do not consent to being for the court to move forward. If you guys decide to move forward, I prefer physically present instead of a Zoom call. If you guys decide to continue.
And what's the basis of your objection again? Why you want a continuance?
The reason I need the continuance is out of the 3 cases, the case number, I only got 2 notices, not the 3rd one. One is missing. And also I requested for discovery to the clerk of the court. And they said, I have to get hold of the prosecutor office. And I got hold of the prosecutor office. There's no email for me to request for the discovery. The only way is a phone number. When I called the phone number, nobody answered. So how can you guys continue without, I don't even have any discovery. So I don't know what's up against me. I don't have the details of the discovery.
Well, you've heard what's against you. Ms. Mann just repeated what she believes the state will be able to prove in this case.
It's not a proper notice.
Mr. Idris, hold on. It may be that the 2 infraction numbers appeared on the same document, case ending in 933 and case ending in 934, since they're both infractions. And then the second one would end in 205, which is a criminal charge. So that's a possibility. But based on your request to have this set over, we will set out the arraignment and you may appear in person. There's nothing stopping you from appearing in person.
Physically present.
Yes, in person. All right, although I believe there is probable cause been established, I'm not going to find that today to give Mr. Idris the opportunity to look at all these documents. And Ms. Mann, is there some better way for him to request the discovery in this case that he's talking about?
Not that I know of, Your Honor. I can check with my supervisor. If you...
Right. In the meantime, while we're looking for that information, Mr. Idris, I want to confirm a mailing address for you or for your estate. Let me check for a moment.
I object. I'm not a mister.
Pardon me?
I say I object. I want to make a correction. You called me mister. I'm not a mister. Mister is a title.
Is your address still on 8th Avenue in Seattle, mailing address?
I don't have an address. I have a location, a private location I can only receive for mail-in purposes only, for notices.
Is that a P.O. box in Tukwila?
That ends with 9998.
I'm seeing a P.O. box dated 88081, Tukwila, Washington.
There's a dash at the end, 9998. There's 999 and 8. Those 4 digits is very important to put it on there.
So 88081 dash 888 dash 9.
No,
I messed those
The
last
last-
4 up. 88081 dash what? What's next?
like I said, I don't have an address. I have a private location where I can receive for mailing purposes only. And the only thing I will indicate is the last 4 digit after the end of the location, what ends 9998.
Is that a street address or a mailbox? Post office box.
That's my mailing location where I can receive notices only.
We can't address notice to you at 9998. I need more than that. What happens, Mr. Idris, is if you don't respond to this, there's going to be a warrant issued for your arrest. We have to give you notice first. That's what we're trying to get established here.
I object. Notices can be sent to me through my private email as
Are you
well.
going to give us that private email?
The court has it on file.
Your Honor.
Candace, do we have that?
Your Honor, good afternoon. This is DPA Tom Farrow. Before we proceed beyond this case, I'd like to address the court.
All right. I'm trying to get a mailing address here. Mr. Idris, we have 2 addresses from the Department of Licensing. One is on 8th Avenue in Seattle, and the other is a PO box in Tukwila. If you're not willing to provide us with your email address, we're going to just send notice to those 2 addresses.
I object. Again, I'm going to make a correction. I'm not a Mr., which is a title. If you can call me with my proper name, which is a family name and a given name, I'll appreciate that.
Yes, Mohammed Idris. We're going to send notice to those 2 addresses that we have.
You meant to say
Unless you give us
my
something different.
family. You meant to say my family name, which is Idris.
All right, we're going to use that. That's what he sent to us, requesting information about court, correct? All right, looks like we do have an email address for you when you
Your Honor,
requested
just before we go
information.
on.
All right, Mr. Farrow, let's hear from you.
Thank you, Your Honor. I was listening on the YouTube. I wanted to address the court just to highlight the fact that Mr. Idris was given the constitutionally required notice at the scene on at least 2 of these cause numbers. There are citations in the record. Those were handed to him, and he was advised of the upcoming court date. That's kind of my first point. So I think if the court wants to continue, I don't know when he was first scheduled for arraignment, but it looks like this has been going on for a little bit. If the court wants to continue on those 2 matters, I'm happy to. I mean, it says here, it's checked the box for the ticket was served on the violator. I'm happy. I guess I could send something to one of these email addresses, but I would also urge the court to note that if you look on Jabs, we've tried sending mail to Mr. Idris. It is not, or it's been returned. Finally, Your Honor, and I'm not trying to be silly about this, but I've sort of heard these arguments before in court, and I think I know where we're going with this. The state's not satisfied legally that the defendant in this case has appeared today. I think he's claiming to be some sort of representative for some sort of estate or trust or other nonsense. But based on Mr. Idris's failure to appear today, the state would request the court to issue a warrant in the amount of $10,000. Thank you, Your Honor.
I object. Everything he said is a hearsay, assumption, presumption, and tacit agreement. It has nothing to do with the facts. He's not telling the truth, the whole truth, and nothing but the truth. And he was supposed to take a stand and write an affidavit. He's not doing any of that. He's just waiting for my silence, acquiescence. So I object to everything that he said.
All right, I understand that. Mohammed Idris, he makes a good point. If you're going to argue that you are a representative for Mr. Idris, Mr. Idris hasn't made a full appearance in court yet today. And therefore that would lead to the potential issuance of a bench warrant for your arrest for not showing up. So can we resolve that question at least, that Mohammed Idris has appeared for arraignment today?
I object. Again, it's what you're saying. Everybody in the court is saying is assumptions, presumptions, tacit agreement is a hearsay. You cannot use a hearsay or assumption and presumption in court. It's wrong information. And I object to all of that. And I am not a representative. Like I said I am authorized representative or an agent or an executor of the estate on behalf of the estate and trust.
And as I've indicated, the estate was not driving this commercial vehicle at the time these citations were issued. So I'm not going to accept that. I'm not going to carry this on further, Mr. Idris.
Do you have a power of attorney for this matter to continue?
Do
Where's
I?
your power of attorney? Or the court or yourself?
Mr. Idris,
or
I'm going to find the following. If you'll listen, I'm sorry, Mohammed Idris, if you'll listen, here's what I'm going to do.
I object. I object.
I understand. Your objections have been noted. I'm finding probable cause today for the charges. I'm finding that Mohammed Idris did appear today, even though he argued and objected that he was appearing on behalf of an estate or a trust. I'm going to enter a plea of not guilty to these charges, and I'm going to set a pretrial hearing in this matter. Now, Mr. Idris or Mohammed Idris, sorry, you may contact the prosecutor's office by writing. You have an email address that we have for you. We're going to send notice to the two addresses that Department of Licensing has and the email address that you used when you contacted the court of when your next court date is going to be. Mr. Farrow and Ms. Mann, I'll ask you to look for any contact from Mohammed Idris so that the discovery that he is requesting can be provided to him for his next court date. All right. We're going to set a pretrial conference for August 23rd at 2:30. I'm sorry, at 2 o'clock in the afternoon in this courtroom.
I object. If I prefer to be there physically present.
Come to court. You can do that. You do not have to be on Zoom. People come to court and have been here in court today.
That's why I asked for continuance. Why are you refusing my continuance? There is no proper notices. It's all based upon assumption and presumption in a hearsay.
You were given notice at the scene, as Mr. Farrow talked about on the infractions, and you were mailed notice.
That was not correct. Was he there? I was not given at the scene. He was not there. How can you accept his testimony? That's not, there's no affidavit, there's no witnesses.
Okay, Mohammed Idris, I'm not going to argue with you. I'm not going to argue with you about this. I can accept the sworn testimony of the officer who testified that he, in his citation, that he presented those documents to you on the scene of the stop. So if you want to continue to raise those arguments when you come back to court on the 23rd, that's fine. You can do that at that time. But we're not going to entertain any further arguments on that matter today.
I object.
I understand. And that's noted in the court record. I have a judgment for him.
Your Honor, I hate to be a pain, but again, I know where this case is headed. I have to object on the record that the person who claims to be some part of a state or whatever does not appear to be a licensed attorney and is thus not authorized to make objections on the record on behalf of any other party. If Mr. Idris would like to proceed pro se, I would ask that the court read or go through the pro se colloquy with him, but otherwise I would ask that his objections not be noted. And I would renew my request for a warrant. Thank you.
I object
Thank
again.
you, Mr. Farrow.
I object again. What he said is not the facts. He's assuming.
Are you an
presuming.
attorney, Muhammad Idris? Are you an attorney? You licensed attorney in the state of Washington?
You haven't answered my question when I asked you, does the court have a power of attorney against this case? And all three of you guys refused to answer. And the prosecutor.
I don't know what that is. I don't know what it is that you're asking.
You don't know what power of attorney is? You have to have a
It's got
power of
nothing to
attorney
do with the
continue.
criminal case.
Is a civil, is not criminal. Is it not?
No, these are criminal charges. At least one of them is.
Who's the executor of the estate? on this
Mr.
case?
Idris, you're missing the point. You're setting yourself up for more trouble. As Mr. Farrow points out, in order for you to represent yourself, you take a great risk in this case. And essentially, that's what you're saying you're doing.
Everything is a trust, is it not?
I don't know. I have only your
administrating my
testimony to that effect.
You're forcing me without my consent to administrate my estate without my consent. So I object to that gentleman. I want to get his name. Is he the prosecutor for this case? What's his name?
Yes, Tom Farrow. Can you see his name on the screen?
Tom Farrow. Is he the prosecutor for this case?
I'm going to assume so. He's here talking about it.
And I'm going to need the discovery from him. When I called, how come nobody picked up the phone?
Well, I have no idea who you called and what the situation was. All right. So I'm finding probable cause in the case ending in 7205, refusing to comply with the police officer. Ms. Mann, do you have request on conditions of release?
I object. That's a hearsay.
For both, the state requests personal recognizance with no criminal law violations, no driving without valid license and insurance, Your Honor.
I object. The fact is not being indicated onto the record. Are we even on the record?
We are on the record. All of this is on the record. It'll be there for you to review if you choose to do that.
Is everything being recorded?
Yes, it is.
Your Honor, the final thing I'll note for the record is even if this individual does reach out to the prosecutor's office, I'm not authorized to talk to a representative who's not an attorney, nor am I allowed to speak about a case with an individual who may or may not be represented and who certainly hasn't indicated that he intends to proceed pro se today. So I'm just at a bit of a loss here.
I object.
Understand that?
I'm not the
Mohammed
decedent.
Idris, you're attempting to create a roadblock that there
Is he
seems to be
saying
no
I'm
way
the
around.
decedent?
Mr. Farrow
Is he
makes a
say-
good point.
Is he saying I'm the decedent? Is that what he's saying? Does he have
No.
a proof that I'm the
Are
decedent
you,
of the estate?
Mr. Mohammed Idris, are you representing yourself today in this case? Are you going to represent yourself on August 23rd when you come back to court?
It's impossible to represent myself, is it not?
No, it is possible. It's not necessarily a wise choice to represent yourself, but it's possible. Do you
Where's
understand
my-
that you are, if you represent yourself, you are held to the same standards that an attorney is held to in terms of understanding the law and procedures of court if you choose to represent yourself?
I object again. Is the court using my bond? Where's the appearance bond? And the bid bond? I do not understand. I do not comprehend, and I wish not to proceed.
Under those circumstances,
Where is my bond?
Mohammed Idris, you should contact an attorney to give you some advice as to how to proceed in this matter.
I object. Where is my bond? I need my bond back. I need my bid bond. Or I'll write one and overnight it. Where's my bid bond? And who is the highest bidder of the case?
All right, on this case, State of Washington versus Mohammed Ismail Idris, case number 3A0257-205 WSP, charges vehicle operator refusing to comply with a police officer. I'm entering a plea of not guilty to that charge. I am finding probable cause, first of all, on that charge. I am entering a plea of not guilty to that charge. It's obvious from Mohammed Idris's responses, he doesn't want to enter a plea of guilty to this charge today. We're not going to allow him to frustrate the procedure of the court by taking an irresponsible position like this. The conditions on your release, you are released on what's called your personal recognizance. That's your promise to return to court. Your court date is going to be August 23rd. We're going to send you notice to the two addresses that we have from the Department of Licensing and also to the email address that you contacted this court about. While you are waiting for that August 23rd court date, you are not to commit any new criminal law offenses, and you're not to drive without license and insurance.
I object.
Your next court date is going to be?
I need more time. August 23rd. It's not enough.
It's plenty of time for court here. So we're going to do it on August the 23rd.
I object.
At 2 p.m.
How can a trustee tell an executor what to do? Because I'm occupying the office of the
This
executor.
is not a civil matter. It's a criminal matter that you have to come to court on the 23rd of August, 2023. I am not going to.
I am the executor and beneficiary of the trust. Am I not? You're the trustee.
I have no idea.
The prosecutor is the
Not an
trustee.
issue for this court. Mr. Farrow, I'm not going to issue a bench warrant today. I don't know how to answer the question that you've raised, which I think is a good one about your ability to provide response to Mr. Idris's request for discovery.
I'm not Mr.
I don't have the answer to that. So, Mr. Idris, you're able to get the order that I've just signed from the Thurston County District Court website under the clause number. Let me find it. 3A0257205. Your next court date will be the 23rd of August at 2 o'clock, and you are certainly welcome to be here in person on that day. Thank you, Mr. Idris.
I will
That's
not
all
be
for
there in
today.
person.
Mr. Farrow, thank you.
Thank you, Your Honor.
Ms. Mann, thank you.
Thank you, Your Honor.
Candace,
Your Honor.
thank you. Who else can I thank?
Not
I guess a pro tem or commissioner or whatever that was hearing the case, and he didn't know what to do with them. So now it went up to Judge Sam Meyer, who's done this before, has a little experience, and he's not playing games. And he seems like he's trying to reason with him, and he actually gets through a little bit, and then the guy kind of like pulls back and is trying to remember what he's supposed to do. He seems like he forgets what he's supposed to do. But I actually have the video for this one, I think.
And on the Zoom call there, it says, it's going to read the trustee of the person, Mohammed Idris. Could you come on the Zoom call?
Can you hear me?
I can.
I'm gonna have to go through
Can
and
you
put
activate your
bookmarks
camera?
for each case. This stream is
Yes.
so freaking long.
Give me a second.
He's
Hi
traveling.
there. So are you, is it Mohammed
his-
Idris?
Van.
The trustee. I'm the trustee. The trustee of the person is here, and all the beneficiaries have been already named.
Okay, so I'm looking for Mohammed Idris. If you're not him, you're free to go. We'll issue a warrant for him.
I am the trustee of the person.
So, okay, I'm not sure what that means. You're gonna have to explain that to me. I mean, I know what a trustee is. You want to have a trustee over as a person, that's someone who governs their affairs if they're not able to manage their own. Generally, people aren't trustees for themselves. And so that's why, you know, and if you're, I'm not sure exactly what that means. And you're gonna have to explain that to me.
What I mean
Like I
by
say,
the
if you're, I mean, I'm sorry.
what I'm saying is the trustee of the person is here, and all the beneficiaries are already been named. And it's on a trust, and that trust is private.
Okay, do you have a name?
Because you are claiming that you are the trustee, or the prosecutor is claiming to be the trustee, and the investors.
No,
are
I'm
claiming
not.
to be the beneficiaries.
So, okay, I'm gonna stop you there for a second because I'm
And
not
I-
claiming that.
I'm just gonna leave this
No,
on
you
the
can't
screen.
finish. When you say you are claiming to be something that I'm not doing, no, I'm not going to say that because that's not true. I'm not claiming to be anything other than the judge in Thurston County District Court who's on this calendar. So I'm not the trustee of anybody.
Well, you're here to come after my personal trust, correct?
No, no. Why would you think that?
Like, no one's home. For real,
I
for real.
object being a trustor.
Okay, well, you're not one. I'm just trying to find out who you are.
Real quick, I gotta tell you guys, the dogs bark all the time. They don't listen to me, especially the little one. I got this little thing just to try. It's the high pitch noise, which I really hesitated doing. I don't like doing that. But I only had to do it a couple times to get them to do it. And I press it, they come running to me, lay down in their beds, perfect, and stop barking, because they'll go crazy when the mailman comes or whatever. Unbelievable. And then once I started saying certain words to train them with it, like, where was this for the last 10 years of my life?
I can't get any clearer when I said the trustee of the person is here.
Okay. Is the person here? You're not going to answer that.
The trustee of the person is here.
Okay.
And the beneficiaries have already been named. Is on a trust, and it's private, and my trust is private.
Okay. What's the state's position on where this case is headed? And then I can come back and speak with
Your Honor,
who I assume the trustee of the person is the person named as Muhammad Idris. And so, but let me hear from you what the state's position, I mean, these cases look like there's a fraction of failure to control a traffic device. There's a special fuel trip permit. And then there's a failure to comply charge.
Yes.
So what's the state's position on where we're going from here?
If Muhammad Idris is not present, the state would ask for a warrant.
Muhammad Idris I'm going to consider him present based on his verbiage. I know he's operating under a lot of false premises, but that's kind of on him. So,
right.
But I mean, what is the state where we're at here? If the state wants to go to trial on this case, we'll set it for trial, and then
the state would ask the court to set dates.
Okay.
Within speedy trial, the state also would like to clarify whether Muhammad Idris is intending to go pro se or if he will have counsel at trial.
So I was looking at this too. Like, he pauses and he thinks about it. So he did it in the first trial too, and I thought maybe he was just stoned out of his mind or something. But look at him. I mean, something's not right. And I'm not really sure what it is. But real quick, just to answer the question, because I don't like anybody to think that I'm not doing that. But there's certain times where they're barking when, I'm trying to do a stream or I have a really bad migraine. And it helped me train them not to bark. It's not like I do it every time and don't let them bark. They're dogs. Don't make it sound like that.
he looks like he was okay. So I'm going to speak here for just a minute, and I'm going to kind of tell you where we are with this, and then we'll go from there. So, you said a lot of things already that just simply are not correct. And here's where you're at right now. All right. And so you've been charged. There's three things at issue here. There's two statutes that are alleged to have been violated: violation of a special fuel trip permit, violation of vehicle operator refusing to comply with an officer. And those are both, I think, simple misdemeanors, which carry with them maximum penalties of 90 days in jail and a $1,000 fine. Pleas of not guilty have been entered. And then these cases, they're both criminal cases. And what happens is they either resolve through some sort of plea or some sort of agreement, or they proceed to a jury trial. And now, if you goes to it, since they are criminal cases, it's headed to a jury trial, you're entitled to be represented by an attorney. Look like a previous judge had already ruled that, or found that you were are you going to represent as the trustee of the person of Muhammad Idris, going to be present to contest the criminal charges against the named Muhammad Idris? Are you going to do that yourself, or do you want to have an attorney appointed to represent? I can screen you for court-appointed counsel, or you can hire an attorney to represent yourself.
Do I have a standing to speak?
Yes.
Okay, I object to what the prosecutor has said.
Okay.
And I'm standing on, I am.
You're standing on what?
The trustee of the person is here.
He's trying to remember what he's supposed to say.
Have already been named.
Okay.
It's
I
not a
don't,
trust and it's private.
okay.
And I object to the prosecutor saying that representing myself, I object to that. I object to being the trustor. And I'm not here to give out gifts, reducing the public law or the public debt. Because I'm brought in as a trustor to give out gifts, and turn around, and what the court is doing is coming after me for the commercial promise. So for that reason, I am the trustee. I'm standing on that position.
All right.
Come here, Rox. I've heard a lot of stuff
And I'm not
that
here to give out
babble,
any
but
gifts.
that's not even like comprehensible. I have no idea what
No
he's trying
one's
to
here
say.
for any gifts.
Come here, Roxy.
So I object to that. The trustee of the person is here, and all the beneficiaries have already been named.
All right.
And I'm not talking about the beneficiaries, which is the investors.
I have no idea what you're talking about. When you talk about the beneficiaries, I don't have a clue as to what you're talking about. So I don't even know what that means. I'm trying to figure out, where we're going to go from here. And I have an idea, but in a minute, I'm going to take up some of these. I'm going to take some of these other cases, and then I'll come back to you. But
I'm the only witness on the case.
Yeah, he doesn't know how to respond.
No, you're not. That's not correct.
That's not.
No.
Someone should tell them there's whole channels that, they could learn from.
Give me just a second here. Mr. Newcomb, you can mute up there.
It's just like playing the lottery.
Mr. Idris, and then I'll come back to you here in just a minute. And you can go off camera, but don't leave the Zoom call just yet, because this is going to take some time. I'm going to take care of some of these other cases first. Mr. Newcomb, is your case ready? I don't hear him. And then Ms. Lazarek.
Your Honor, we'll be doing a change of plea today, but I'm just waiting for my client to log on.
All right. All right. So you can come back on the, you can come off the Zoom call there. Mr. Idris, you can come back off of mute. You can come back onto the Zoom call. So here's where we're at here. And I started talking about, and again, at this time, I don't want to hear anything about the trustee and the named or unnamed beneficiaries. My only question is, do you want to have an attorney appointed to be involved and help you with this case? I mean, that's a yes or no question.
The trustee of the person is here, and the beneficiaries have been already named. And I'm asking for the court to dismiss this case because I put myself in the position of a trustee.
Okay. The request to dismiss the case will be denied. I'm telling you that. And I'm going to ask my question again. Do you want an attorney appointed to represent you, or are you going to go it alone?
How can somebody represent me when I'm the trustee?
Okay.
And the beneficiaries have already been named? You can't even continue.
Why do you think that?
Yeah, I'm confused too, Judge. I don't know.
What does it have to do with thinking?
Yeah, that's a good question. Well, I mean, you're just telling me that, well, I've named the trustee and the beneficiaries are named who haven't been named to me. So I don't know who they are and they're really not interested. I mean, if life were that easy, anybody could do that in any criminal charge. Anybody get charged with anything? Well, I'll just name myself the trustee of the person and name some beneficiaries, then you're off the hook. You know, things just don't work that way.
How come they don't do it?
And so in terms of, you know, at some
They
point,
don't do it.
on the, there was a scene where you were contacted by a law enforcement officer, or maybe even more than one. They identified some charges or some statutes you were not complying with, including, you know, the special field trip permit, and you refused to comply with the officers and things of that sort. So they refer that to the prosecutor's office. They're charging a crime. And I've told you what those two crimes are. And now, again, these cases either resolve, and if you've been on the Zoom call, which I think you have for a while, you've seen some of these cases resolve, or they go for a jury trial. And again, you've seen all these other attorneys who represent these folks. I mean, if they could make these cases go away simply by naming someone as a trustee or naming the charged person as a trustee, I mean, shoot, they'd all do it. And then nobody could ever be prosecuted for anything. So that's why I'm wondering why you think that. And now I'm losing my voice, but it'll come back, I promise. So if you're going to keep just
go ahead.
I mean, if you're just going to keep repeating that to me, then not much of a choice other than we'll just set this to a jury trial, and then you can repeat that to the jury and see how that turns out. But I don't really have much of a choice here right now.
I object. Isn't the prosecutor supposed to be speaking and ruling between me and the prosecutor?
Say that again. I didn't understand that.
Like, repeat yourself. Because like, I can't remember what I said.
Would you please repeat that?
How come the prosecutor is not saying anything? Why is the prosecutor silent?
Well, because part of my job is trying to identify who's here. And then the prosecutor did say that they want to figure out whether you're either representing yourself or you want an attorney. And so that started the conversation between me and you as to whether or not you want an attorney or not. And I frankly, I still haven't gotten an answer. When I ask you that question, you just go back to restating yourself as the trustee of the person of Mohammed Idris, and then the beneficiaries have been named. So I want to get through that hurdle. And then, you know, I have some responsibility to do some things here before we really hear from the prosecutor. Prosecutor will, I suppose, if this case goes to jury trial, they'll do that. They can negotiate with you some sort of resolution to the problem if you wish to do that. I can set this over for a period of time to give you an opportunity to do that. But and again, you still haven't even admitted that you're the person who was pulled over by the police officers on that day. So, I mean, we kind of have to get through some of these preliminary hurdles before we can get to that.
But my handbook said it'd be the prosecutor.
The trustee of the person is here, and the beneficiaries have already been named.
You have said.
The beneficiaries have already been named.
Like, they're wasting so much time and resources.
Do you understand that the prosecutor is an attorney who's passed the bar, practiced law in the state of Washington, appears here fairly regularly, and knows the rules of evidence and criminal procedure, and quite familiar with them, given that that's what their job is?
I object to being the trustor.
Okay. Do you understand what a prosecutor's job is?
Maybe he just objects when he doesn't understand the question.
I object to being the trustor.
All right, you can go ahead and mute back up. You can stop your camera, and then I'll come back here in a minute. All right, Mr. Idris, you can come back on the Zoom call, please. Activate your camera. So I'm just going to talk for a few minutes, and then I'm going to tell you what we're going to do here, going from here. It looks to me like your first appearance on these cases was on July 17th, and speedy trial runs through right now, October 15th, 2023. So you are charged, as it looks like you were in front of a pro tem back on July 17th. You're charged, right there, with 2 crimes, and there's 1 infraction. Pleas of not guilty will be entered. Anytime anyone's ever charged with a crime, they have a number of rights. You have the right to be represented by an attorney, which I've talked about. You also have the right to go to trial and call witnesses and so forth. And so hang on, just let me finish, please. Don't interrupt me. I know what you're about to say, but I'm going to talk for a while here. So just please don't interrupt me. At the end of it, then you can say what you're going to say. All right.
My apologies.
So this case has started. This case is headed towards trial, apparently. And if my voice holds out, the trial is going to take place someday before October 15th. You have the right to an attorney, as I said. You also have the right to represent yourself. If you choose to represent yourself, I just want to advise you that you would be at a serious disadvantage. The prosecutor, as I tried to explain earlier, is a trained attorney, been through law school, been practicing law for a while, well-trained, well-versed in the rules of evidence, well-trained, well-versed in the rules of criminal procedure, been through jury trials before, they know how to conduct them. And so if you were to represent yourself, you would be at a huge disadvantage. It would be to your great advantage to have an attorney appointed, or you can hire an attorney to represent you. But as I said before, you do have the right to represent yourself. And normally you go through some sort of conversation with folks. I've been doing this job for a number of years now. I've had several people represent themselves. Normally there's a conversation I've had with people about asking them that they're aware that if they represent themselves, they'd be at a disadvantage. I tried to engage in that discussion with you. You just kind of reverted back to repeating that you're the trustee of the person and the beneficiaries and the name, so forth. But rather than go through the question and answer portion, I'm just going to tell you that's where we're at. So we're going to set this case. We're going to do 2 things here today. We're going to set the case for trial. You're going to get notice in the mail of that. You're also going to set, I'm going to set a status hearing or a pretrial hearing in about 3 weeks. And then somebody else, maybe it'll be me, will probably try and go through all this again. But I'm going to tell you some things that, you said you object to this and you object to that, and you're free to object to anything you want. But I have the ability to either overrule the objection, which means, turn down your objection, or sustain your objection. And I'm having trouble actually understanding what your objections are. And so, and again, I'm going to lay out some of what's going to happen at trial if it goes that far. In a trial, they have a group of citizens come in, both the attorney and defense attorney or the person represent themselves, and the prosecutor has an opportunity to question them, talk about the issues that might come up in the case. Then they can eliminate who they don't want on the jury. And then 6, you will end up on a jury, and then the state will present their case. You or an attorney, or you on your own behalf, or you as the trustee of the person, can present your case or explain to the jury why you think you should be found not guilty of what you're charged with. And so in the grand scheme of things, frankly, the charges that you're charged with are not far from the most serious that we see around here. They're not. But they are crimes, and they are in their own way serious. And so I don't know whether anything I've said has made any impression on you at all, but that's what's going to happen here today. And if you wished in that, so this case is headed for trial. And like I say, we'll do sometime before
Is muted.
October 15th, but we're going to do a intervening, and I'll tell you when that is. Why don't you set just a status pre-trial for like about 3 weeks. And you can think about what's going on here. You can think if you want to take some alternative place. If you want to just come to court and keep repeating the same thing to me when you get in front of a jury, you keep repeating that same thing to somebody else, you know, I suppose there's no way I can stop you of doing that, but I'm just trying to enlighten you on what's going to happen. And, you know, some of, your objections you talk about, see, that's the advantage the attorneys have. The attorneys know when objections are well-founded and when they're not. And I kind of get the sense from you that you really don't have a complete or accurate idea of what this is all about and what's.
But like, since I'm like delirious from sitting here with these lights like shining in my eyes for 3 hours, I will admit that I did watch his really messed up alien astronaut show. It was weird. What? I can't remember what it's called. Now someone's got to tell me what it's called. Yeah. Dang. I won't admit that to most people.
Happening. And so I tried to spend some time explaining that to you as best I could. And I guess I told you I'd let you speak, or hinted that I would let you speak. I'll go ahead and tell you. Do you have any response or any thoughts on this? Or
no, I have to click on them.
You understand this is going to trial, or go ahead. I've said what I'm going to say. I'll turn things over to you. Any response to any of that?
Again, I object. I'm standing at what I said.
Okay. And what specifically do you object to? Just so I can create a record, so I'll make a ruling on your objection. What are you objecting to?
It was called the Orville. It was horrible. The Orville. He was like some outer space monsters. It was weird.
I'm objecting to everything you're saying. It's a hearsay. It's an assumption, a presumption. It's a tacit agreement. It has nothing to do with the facts. That's why I'm the trustee. It has it has everything to do with the trust law. The trustee of the person is here, and the beneficiaries have already been named. That's why I have a trust, and my trust is private, and I don't see your trust. And the trust that you have,
literally,
the trust that the prosecutor has named you as the trustee. That's why you keep asking the prosecutor what they want to do, because they named you the trustee. And you guys brought me into court to bear gift, to give out gifts.
To bear gifts.
And I'm not here to give out any gifts.
Right.
I'm here to object to giving out any gifts. That's supposed to reduce the public debt. Am I wrong?
Yes. Yes, you are.
Yes.
And that's frankly, that's kind of the sad thing, because I'm really not sure completely of what you're saying, but a lot of the things you just said are quite simply not true. And I asked the prosecutor where they wanted to go in the case, because they file the cases, they choose to go forward. Sometimes, as you've seen today, if you've been paying attention, the prosecutor said, "No, Your Honor, we're going to dismiss this thing." And so I dismiss it. So I asked the prosecutor, they filed the case. What do you want to do with this case? They said they want to go forward, which brought about this conversation that we've been having. And that's just one example of one of the things you're wrong about in terms of this whole trustee thing. I don't know what that means to you, but I have an idea of what a trustee and is and things of that sort. And I don't have a trust. I'm not anybody's trustor or trustee. In this court, neither is the prosecutor. And so when you say, am I wrong? The short answer to that is yeah. And unfortunately, and I'm taking some time to try and explain it to you, but I just don't feel like I'm breaking through. But to answer your question, am I wrong? Yes, you're wrong about a number of things, which is really unfortunate that I can't explain that to you or make that clear to you.
What's your evidence?
Evidence is clarity.
I'm sorry?
What's your evidence that I'm wrong?
Well, I mean, you know, other than me just telling you that I'm not a trustee, I can't prove something doesn't exist. I mean, there is no trust. There's nothing else, and I have no documents that saying there's not one, and I don't have any there is no document saying that there is one. And so again, that's on that single issue. That's.
So you're not coming after my personal trust?
No.
So personal
And again,
trust
I'm not
doesn't
sure.
exist?
Well, let me rephrase. I'm not sure what that means. Again, you're charged with a crime. That crime needs to be resolved or either through trial or resolution of some kind. And so in terms of coming after your personal trust, and by the way, you know, I'm not the one who filed the charges. That was done by the prosecutor and all of that. And so what they're trying to do, I think, and I don't know this for sure, and I'm just trying to do this by way of explanation, not because I'm on anyone's side. You know, it's their responsibility. They're bringing the charge. It's their responsibility to prove it beyond a reasonable doubt. It's your or the defense attorney's role to say, explain why the charge should never have been brought, or that there reasonable doubt exists as the charge was ever committed. That's what this is about. This whole trust thing, I think you're just going down a way that's really doesn't have any relevance to what's happening here. And I've tried to explain that to you, and I'm more than willing to continue to. We can't go at it all afternoon, but I'm trying to make this as clear as I can to you. But and again, it's unfortunate. It's a failing on my part that I'm not able to break through to you.
Your Honor, if I might for a moment.
In a minute. So I guess we'll set it for status hearing. We'll set trial dates, and then we'll just go from there.
Your Honor, based on this conversation, the state has concerns about the defendant's competency.
Yeah, we're not going to go down that route right now.
But I legit have
And
concerns.
so
Not
you can raise that, but
because
I'm not
it's all
denying
set,
that without prejudice. But at this time, we're not. For one thing, as you well know, given the nature of the charges and given the schedule, this case will drag everything on we'll be here for the next couple of years. And at this point, I'm not prepared to do that. So you can bring this up again if you wish. But for right now, we're not going to go there. And do you understand what the state just said to me and what I turned them down for?
No.
Again, that's a yes or no question. The representative from the state, the prosecutor, she just said something to me. And I said, no, we're not doing that now. She made a request of me. And so do you know what that request was?
I am the trustee, and the beneficiaries have been already named. So.
All right. Did he been sent discovery?
No, Your Honor.
Okay.
Because.
Yeah, I understand why. I understand why. All right, so what's 3 weeks? What's 3 weeks from today? When's the trial date? We're going to reset this to September 13th. Put it at the end of the calendar.
Okay.
What time?
2:30.
At 2:30. That'll be your next court date. You're free to go.
So I was really surprised because, like, legitimately, yes, soft sets are difficult. They spout a bunch of garbage. There's all those issues, but he really, like, could not comprehend. When he asked him, can you repeat that to me? Like, he couldn't do it. Yeah, sorry about that. The algorithm's bitch. Wait till you get on its bad side. Let me tell you. Okay, so the next hearing is next on Grumpy Old Florida Men. Mr. Dudley was a little perturbed at Mr. Mathis, so he walked over to the car he was sitting in and smacked him in the back of the head. This resulted in a battery charge, which we see here with the fabulous Judge Wade Mercer.
Mr. Dudley, number 4 on the docket, which is 23-355 MM. Mr. Dudley is coming up. Mr. Dudley, listen to Mr. McDaniel, and we're going to see where we stand in your case.
Your Honor, I spoke to Mr. Dudley at 23-355 MM. You know, state's made an offer for him for probation, and we're going to just go ahead and admit that, you know, we're going to go ahead and plead no contest. He's going to admit that he slapped him. He has circumstances that he would like to explain to the court as to why he slapped him. You know, there's various things that I think he just wants to have his say and say stuff and let the court basically decide what to do to him, with the understanding that, you know, there's an offer for probation. But he's hoping maybe he can convince the court that there's circumstances that justify the slap. The victim is here also, so he's going to be able to they just want to have their say so. And
okay.
I'll give the court a little bit of background. This is an incident where all parties were highly intoxicated. I mean, they were all on it. Watch videos. It's clearly a neighborhood of heavy drinking, and you know, they were all seemed to be intoxicated. Seemed to me when I watched, they were all intoxicated.
Okay, so let's do this. Mr. Dudley, I need to place you under oath and make sure this plea is what you want to enter. Do you solemnly swear or affirm the testimony about to give in this case to be the truth, the whole truth, and nothing but truth, so help you God? Mr. Dudley, you've been accused of one count of battery. If you want to plead no contest to that today, you have the right to. It avoids a trial. If you enter a plea of no contest, you're waiving your right to a trial. You're waiving a right to call witnesses, and you're waiving a right to cross-examine witnesses. None of those things will happen because you're ending the plea. You need to understand the maximum penalty for this case, for that charge, is a year in jail, but the state in this case is asking for probation. Is that right, Ms. Bremer? So if you enter this plea, what you're basically doing is what Mr. McDaniel said. I want to plead, and I want to try to let the judge tell my side. I want to hear from the alleged victim if they want to be heard from, and then I'll make a sentencing decision after I hear from everybody. But you need to understand that you're waiving those rights if you enter this plea. Is that what you want to do? Okay, so I need you to sign the waiver of rights form. Put your date of birth on there, Mr. Dudley. So, Mr. McDaniel, I read the complaint. Sort of remember the case. I don't know if I did first appearance or not, but I remember the case. I'm somewhat familiar with Mr. Dudley. I know that he's been in trouble a few times, and every time he's been in trouble, as far as I know, it involved alcohol. Every single time. Mr. Dudley's, my belief, based on him being in court in the past, he's got an alcohol problem. This case here, the complaint says he was severely intoxicated when he was interviewed by law enforcement. He admitted to the battery. But I'm glad to listen to you or Mr. Dudley or any of the witnesses you want me to hear from. The victim.
And the victim who he's with, and why everybody was intoxicated.
Okay. All right.
Just everything you want to tell the judge why.
Sure, go ahead, Mr.
Young. Just everything.
Actually, I'm gonna be honest with you.
I appreciate that.
It's a sad situation.
Start with how you're involved. Are you neighbors? Are you friends? Are you relatives?
Actually, we grew up together.
Okay.
I've been know this man for a long time.
Okay.
If he needed my help, I always there for him. If I needed his help, he there for me.
Okay.
It's a sad situation.
So what happened?
Actually, all because he put a gun on me, my little baby, my wife, and my mother-in-law.
At some point prior to this, he pulled a gun.
Yes.
Was alcohol involved in that incident too?
Well, for him, my wife, and little short midget man, Mr. Amp Mathis. Now, they was the one that were drinking. I wasn't drinking.
You talking about this day or you talking about the other incident?
The other incident.
Okay.
So That's where it began. When he got back to his house, that's when he put the gun.
What's the time frame of that incident compared to this one? Was it weeks or months or day before, or same day?
With this accident, no.
How long before this did the gun incident happen? This,
Within 4 months at the most.
okay, so I'm with you. So there was a prior incident, there's some hard feelings.
Yes, sir. And
Tell me what happened then.
And then I came to court not too long ago. They had me for talking about trespassing. That didn't happen. They got thrown out. All right. So my wife had called his friend, Venice Mathis. And Venice said he was gonna go to the store. And said, well, you meet me at the mailbox, okay? Went to the store.
To get what?
Get my wife a bag of ice, and I think got her some liquor. Well, when he called, he said, meet me at the mailbox. And I said, well, who is he with? And Venice told my wife that he was with Lamar Livingston. Well, we went on down there to 1208 mailbox. I was standing there, and I gave my word to the judge, the lady judge.
Judge Garcia.
Yes, sir. And I said, well, I ain't gonna do nothing. Well, that afternoon, there he was. I was standing at the mailbox with my baby, and Mr. Cruz pulled up. And I asked him one question, because I'm a truthful man. I asked him, I said, Junior, do you think that you don't owe my little daughter an apology? He was looking around in the seat of his car, and I didn't know what he had. And like I said, I'm an honest man. The only thing I thought about was my little girl lied. And I cold cocked him, and I told him I was there for my daughter. Now, if I was a dirty man, I'd probably be in prison. But I didn't do that. You know, I'm sorry for you, but I'm so protective about my daughter.
Your daughter's real young, isn't she? How old is she?
Oh, she's 1 year and 8 months.
Okay. So does she know it? Does she even know anything about the gun incident?
Yes, sir.
Because she would have been.
Trust me, she knows what the gun is. Trust me. Okay. We be watching cowboy pictures and this and that. She'd be asking me, what's all this and all that.
Okay.
But I am sorry. It was all because of my daughter.
Okay.
I'm sorry, Junior. But man, don't be putting no gun in. That's not good.
Okay.
It's not.
Anything
It's
else?
not good. It hurts.
Mr. Dudley,
I was asleep.
anything else you want to tell me, Mr. Dudley? Anything else you want to tell me?
Yes, sir. It hurts, and I don't like it.
Ms. Bremer, any questions for Mr. Dudley?
This time's, Your Honor.
Mr. McDaniel, anything else before we hear from the alleged victim? Ms. Bremer, I'm hear from you or the alleged victim first?
I'm sorry, Your
You want me to hear from you or the alleged victim?
The alleged victim, please.
And you are Mr. Cruz, correct? Mr. Cruz, let me get you to raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth to help you God?
Sir.
Okay, Mr. Cruz, anything you'd like to tell me, I'm glad to listen.
About the accident, what he was talking about me drawing the gun on him. What it was, we had went to Donaldsonville and got some grocery and stuff. On the way back, started teasing a little bit. Then when we got to the house, I got out to go in the house. He got out.
Tell him what he was teasing you about. What was he teasing you about?
Oh.
I'm his sister, you are.
Okay.
He was teasing me about how he had slapped me before. So it started from there. When I got to the house, I told him, I said, you ain't gonna slap me no more. So when I jumped out the car, he jumped out with 2 knives and wouldn't let me go in the house.
Is his daughter present?
Ma'am, let him go through this, please. Come on.
His daughter.
Camera is short.
Well, it's okay. I want to hear it from him, though. I don't want to hear. I mean, I'll gladly hear from you after I hear from him. So go ahead, Mr. Cruz.
So I got out the car to go in the house. He jumped out the car, in my car, with 2 knives in his hand. Say, I'm not gonna let you in. I said, yeah, I'm going in my house. So when I went in the house, I thought about it. I grabbed my pellet gun. It was a pellet gun with no pellets in it because the shad came right there, right after there. And picked the gun, him and my son. So the baby was in the car. The baby don't even know nothing about no gun. Baby was too young. Matter of fact, she probably didn't even see the pellet gun. So he jumped back in the car. Then when I put the gun down, he jumped back out and started again. And I asked him to leave out my yard.
How close do you live to each other?
Over half a mile.
In the same community?
Well, yeah.
Down around Shady Grove? Where do y'all live at?
Oh, Sinai.
You live in the Sinai community, which is just in the close to Shady Grove.
Right.
Okay. What about the second incident?
Okay.
Do you agree with his version of the second incident?
The second accident, anyway, I went over there and picked up the one he said, Vinny, from his house across the branch. Vinny asked me about going to the store, but I didn't know Vinny had to go up to his house to get, he told me he was going up there to get a food stamp card from them, right? So I pulled down to the bottom of the hill from his house. I wouldn't go up to his house. I turned around. Vinny walked up there and got that card or whatever, the money. I sat down to the mailbox where Vinny's mailbox at. That about eighth of a mile. So when Vinny come back, me and him went to the store and got what they wanted. So we come back. I turned off to go to Vinny's house by the mailbox. He done walked down there with his family. He walked past me and come back on the side of my car. I'm gonna teach you about drawing a gun on somebody and slap me again. I'm sitting in the car. Wasn't bothering nobody. I hadn't even said anything to him. Then a couple weeks ago, I was in the grocery store getting some items. Instead of him going to pass to the other cashier, he come directly over there where I was to the cashier, where he holding a conversation with the cashier when he wasn't supposed to be that close to me. And I'm afraid something gonna bad happen. He keep on hitting me. That's the third time.
Okay.
And I can't stand it no more.
When the incident happened at the grocery store, did you contact law enforcement?
When those time called, by time police got there, he was gone.
Okay. That didn't answer my question at all. Did you contact law enforcement?
No.
Did you know most grocery stores have video cameras? And had you contacted them, there'd probably be a video of him coming over there standing next to you. And had I been made aware of that, I would have signed a no bond warrant for his arrest for violating my court order of no contact.
Right.
But I can't do it if you don't do your part.
Right.
Okay. So who all was drinking the second time? Were you drinking?
I had a drink earlier, but I wasn't drunk.
Was Ventus drinking? Or did you know?
Yeah, he was.
What about Mr. Dudley? You know if he was drinking?
Yeah, I believe he was.
All right. Anything else you want to tell me, sir?
Well, I just don't trust him no more.
Okay. You just want to be left alone. You go your way, he go his
Yeah,
way.
that's right. If it didn't take jail time for him, I want that too.
Okay. Thank you. Ms. Bremer, any questions? Anything else you want to ask of this witness?
Mr. Cruz, are you concerned for your safety in the future with Mr. Dudley?
If he keeps slapping me, yes.
Anything else?
Nothing.
Mr. McDaniel? Anything for Mr. Cruz? Wait, for Mr. Cruz. Any questions for Mr. Cruz? Okay.
Mr. Cruz, I I watched the video. Y'all are all highly intoxicated. Everyone seemed to minimize and say, yeah, I may have had a drink. Y'all are all driver, everybody was highly intoxicated. I mean, let's be honest, guys. Okay, sir? I mean,
Is that a question you're asking? You agree with that statement that Mr. He made?
No, I ain't gonna agree. I wasn't drunk. No,
Okay.
I was not drunk.
Ma'am, do you want anything?
Yes,
Okay.
please, Your
I got to place you under oath. Let me get your name, ma'am.
I'm Eloise James.
Ms. James, do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but truth to help you God?
Yes.
Thank you. Ms. James, tell me what you know about it, please.
Your Honor, I would just like to simply say I was not present at any of these incidents. I'm only hearing what is after looking at my brother's situation and when he comes to my house, almost in tears based on the incident that this man keeps slapping him. Now, Isaiah knows that my brother is sick. He's 73 years old in November. If he was the man he used to be, Isaiah would not be putting his hands on him, period. But Isaiah has a habit of getting drunk and taking advantage of the elderly and the sickly and those that cannot fight him back. He has a history of violence and he's constantly fighting. He says that he's so worried about a gun being pulled in front of his child. But I'm sure you have before you domestic violence, where he's a violent person toward his wife in the presence of his child. So he's hollering about what an honest man he is. That is very far from the truth. My concern is, and the entire Sinai community concern is that something has to be done with this man. Because the whole community, every community he's lived in, he was out in Bluntstown, they threw him out from down there, the people got sick of him. He went to St. Rose, the community down there got sick of him. Then he winded up with us in Sinai. Now the Sinai community is sick of him. And I personally am sick of him putting his hands on my brother.
You live in that community, ma'am?
Yes, ma'am. I mean, yes, sir. I'm sorry. Your
Okay.
Honor, but I've worked with corrections for 36 years on the correction side. I've retired from that. And I am sick and tired of this man harassing my brother.
Let me ask.
Chance he does, excuse me.
It's okay. It's okay. I'm just trying to.
Does not have any respect for the court, you all, any of you.
Let me ask this question. The times I've seen him in court, many times, have always been alcohol related. The problems that you're talking about, are they related to alcohol?
Most of them, yes,
Okay.
that I know of.
Right. Anything else you think we need to know?
Yes, as you could see when he came in the courtroom, he could have sat anywhere. But where does he sit? Directly across from my brother. Directly across from
Where do
him.
you think he should have sat at?
He could have came up here to get away from him.
Okay.
But this is the point that I'm trying to make. Wherever he sees my brother, he's going to go there. He's going to get as close to him as he possibly can. And in my opinion, that's a source of intimidation.
Do you understand the problem though when your brother doesn't contact law enforcement like
Yes.
the sheriff is doing?
And did he do that? And he said, no, I didn't.
Because he would be in jail now.
Yeah.
We
And that's exactly what I told him. You should have called.
yeah.
You should have called.
Okay. What grocery store was that?
That's Mac Daniel's grocery store.
How long ago was it?
Piggly Wiggly.
How long ago was it?
Before I went in the house, but
About a week.
it was
You was living there?
about two,
2 weeks?
3 weeks.
Okay.
Yeah, because you was in the hospital a week. So
Ms.
it was
Bremer,
before
any questions for Ms. James?
No, Your Honor.
Mr. McDaniel for Ms. James? Thank you for coming, Ms. James. Thank you for speaking. Ms. Bremer, anything from the state?
Your Honor, based on the information that we've heard today, the testimony from the defendant and from the victim, this is clearly a volatile situation and tensions are high between the parties. The state did make a probation offer for Mr. Dudley. Based on the information we heard today, I believe Mr. Dudley is trying to argue that he was upset because a gun was pulled on him, whether it was a pellet gun or another gun. The information we've heard today makes it sound like it was pulled as a self-defense measure to enable him to enter his residence. He certainly, Mr. Cruz, is within his rights to do that. So it does not explain away or excuse his decision, Mr. Dudley's decision to slap a disabled man. And so the state would ask that whatever the court decides to do today, that there would be no contact with Mr. Cruz permitted, and that it would address the issue with alcohol or drugs without prescription.
I know that you weren't with the state attorney's office at the time this complaint was filed. A
Correct.
battery on a person over 65 years of age is a felony. Do you have any idea why the deputy or the state attorney's office didn't file this as a felony with the evidence they had?
I do not, Your Honor.
Hang on just a second. I'm going to give you a chance. Yes, ma'am.
I even called elderly abuse, and they have it on record,
Okay.
where I called elderly abuse to try to file a claim to see what I could do to intervene as his sister to stop him from knocking on my brother, hitting him, slapping him without a just cause. Elderly abuse advised me that because he was not a caretaker or living in the home with him, that there was nothing that they could do, that it would be a law enforcement situation.
Okay.
But that's how serious I took it when he came to me, because he's too old for him to be beaten on. You see his health condition. He's just now getting over a bout in the hospital from pneumonia. He just got out of the hospital Thursday of last week with pneumonia. He's on oxygen. He can hardly walk a few feet without having to sit down on this thing and rest. He cannot deal with him. He can't. It would be something else if he could defend himself, Your Honor, but he can't anymore.
Okay. Thank you. Mr. Dudley, anything else you want to say?
Yeah. I don't see how he can sit there and say that. Whenever he used to come to my house almost every day to play dominoes with my wife while I watched the child. But it's there, you know? For us hitting on him, no. 99% of the time, I'm home. If I'm not home, I'm trying to make me some money. If I don't make no money, I'm fishing. That's all I does.
Okay.
If anybody need my help, I help them.
All right. Okay, Mr. Dudley, what I'm going to do in
That's
case
it.
23-355 MM, I'm going to accept your plea of no contest. Actually, I've already accepted your plea of no contest. Going to withhold adjudication of guilt. I'm going to place you on probation for 11 months and 29 days, standard probation. You're going to have a condition that you have. Everybody has a condition, no alcohol, and I'm talking more about that in just a second. Court costs and fines for a battery charge are set by state and county law, not by the judge. They are $722 court costs and fines, and no contact with Mr. Cruz at all. I don't know. I'm going to also impose a condition that he successfully complete alcohol counseling, some kind of alcohol abuse counseling like AA. Mr. Dudley, here's the problem. There's about zero chance of you completing probation unless you stop drinking. If you don't stop drinking, you're going to be back before me in a matter of days or weeks at the most for getting caught drinking, and I'm going to put you in the jail for up to a year. You've got to stop drinking now that you're on probation. You don't have a choice. The second thing you've got to do is have no contact with Mr. Cruz at all. If you see him somewhere, you can't talk to him. You can't come within 500 feet of him. Now, if you're on the road passing each other, you can't help that. But if you're in a grocery store and you see him, you need to go to the other side of the store away from where he's at. He's the alleged victim.
That's what I've been doing.
Okay. If you have contact with him, or if I find out you're drinking, then I don't have a choice but put you in jail. So you're going to get a shot at probation. Hopefully you'll make it. But I'm being as honest with you as I can. I don't think you can make it unless you quit drinking. And I don't know that you'll quit drinking. I don't know that you will quit. So, ma'am and sir, if you find out he's drinking, you need to contact law enforcement or contact his probation officer. Mr. Goodson will give you a card, business card. He'll give you a business card. Will it be your case or Mr. Ham's? We'll give you Mr. Ham's business card. If you have any contact with him, you need to contact law enforcement and the probation officer, Mr. Cruz. But especially if it's somewhere like a grocery store where there's cameras, or if there's a witness with you that says that he come up and talk to you, you know, he shot your bird, he drove by your house slow and was yelling at you out the window. I don't care. Whatever it is, if he has contact with you and you know about it, because if we don't stop it now, one thing that hasn't been mentioned is what happens next. Do you finally, you know, do you do something that you shouldn't be doing because you just had your belly full of it?
Exactly.
But then you're the one that's in trouble. So contact law enforcement if you have any problems. Mr. Goodson, I need to keep a closer watch on Mr. Dudley. I need y'all to keep a closer watch on Mr. Dudley than we normally do, because he's been drinking for, I don't know, 30 years, Mr. Dudley, 40 years. and it's gonna be hard for him to quit drinking, but if he can make probation. I have no doubt in that. I don't know that I have doubts that he will quit drinking though. So,
Does that order include phone calls?
yeah, he can have no contact at all. No texting, no voice message, no carrier pigeons. I don't care. No contact
Thank
at
you.
all.
Thank you.
But I can't do anything about it if Mr. Cruz won't contact authorities if and when it happens.
I will.
Okay, Mr. Cruz, I probably would be remiss if I didn't say there's alcohol involved on both sides, at least in this incident. You need to realize that too.
I can't drink.
Oh, you can't drink anymore because of your health? So that's changed since May?
Yes.
Really? Okay. Well, I'm sorry to hear that, but maybe that's a good thing. Okay. It's a good thing. Mr. Cruz, Ms. James, do y'all have any questions? Mr. Dudley, do you have any questions?
No, sir.
Mr. McDaniel, Ms. Bremer, anything else?
Nothing, Your Honor.
Mr. Dudley, see Mr. Goodson with the probation officer. Wish you the best, sir.
Yes, ma'am.
All right, Mr. McDaniel, that was everything I had on my docket, but while you're here, let's take a look at our trial docket and see what we've got left for next week.
Earlier this week, we met Regina Williams over in Judge Simpson's court. She was charged with accessory after the fact, and her attorney argued it was only 5 years. Like, why did she have such a high bond? And he forgot to mention that it was accessory after the fact of open murder.
Williamson's first contact with the criminal justice system, as far as I can tell. However, I do think it's important to note that what happened in this case and what is alleged by the people includes her being an accessory after the fact to open murder, where the co-defendant is Angela Weems, who also has a PCC up later today.
Kind of a big deal. I thought that was the story. Apparently, I don't watch enough SovSit Drama Hour on YouTube like you guys, and quite a few of you brought it to my attention that there was a much bigger story here. Some of you did it nicely, and some of you did it like, you know what. But apparently her accomplice is quite known to the court system, and some call them SovSits. I like to think more of jailhouse lawyers, because I think if you're a SovSit, you have to actually live the lifestyle. These guys are more jailhouse lawyers because all they want to do is tie up the system and think that they know about the law and memorize stuff and ramble it on. But I did a little digging and I found a little bit about her accomplice. Angelo Gabriel Weems was the other defendant referenced in the open murder charge. He was arrested around the same time with numerous charges, one of them being open murder, which resulted in no bond, surprisingly.
All right, and moving on. Court does call the case. People of the State of Michigan versus Angela Weems.
Ashley Lonnie for the people.
Good morning, Your Honor. Robert J. Killawald on behalf of Angela Weems. Mr. Weems, if you're there, would you state your name for the record?
Angela Weems. I'm representing myself.
Mr. Weems, I was asked to represent you yesterday. I was going to ask for an adjournment so I could get the discovery and come and see you.
That's fine. That sounds a little bit.
Probable cause conference will be then adjourned to July 27th, 2023, 9 a.m.
Thank you, Your
Bond
Honor.
continued as no bond. Thank
Thank you, Your Honor.
So I'm not really sure if this guy wants to go back to prison. Like, he likes it. It's fun, structured, daily activities. Or if he's just a couple French fries short of a Happy Meal, because there is no way he's going to represent himself in an open murder trial and be successful. He hasn't even been successful in the minor cases that he has tried to represent himself in the past. Let me show you an example.
Mr. Weems?
Mr. Williams here, and proper persona.
Today is the day and time that we had scheduled for a motion hearing and evidentiary arguments with respect to the motion to suppress in this case.
That's correct, Your Honor. I did attempt to reach out to Mr. Weems via the email address that I had, and I think Mr. Banis also was assisting with a different email address. What I'm
File for dismissal without the complainant being.
Mr. Weems, first of all, if I were to grant your motion, the first thing the prosecutor gets to do is reauthorize the case, and then you end up getting arrested on this particular charge again. So it's a motion, any dismissal is without prejudice. But secondly, my first question is, did you get his request to adjourn this case on May 9th?
No, I don't know I don't know what email you have. I think you might have another email. My email is angelaweems@iCloud.
No, that I'm talking over you for a reason. We're on live, if you know what that means. This is YouTube, so it gets blasted all over the world. I don't think you want the world to know your YouTube that address. So that's why I talked over you. So I don't know if you could hear what he said. His email was.
It didn't sound like the one I have.
Okay.
From what I heard so far.
Okay.
I want to dismiss though, Your Honor.
I heard your request, sir. I did.
Okay, I'm sorry.
Mr. Weems, do you have a valid license yet?
Yes, I do.
Can you confirm that, Your Honor? Do you have the SOS record?
1 second. I'll get that.
I actually got a road test in a couple of days. I just paid my my last few tickets a couple weeks ago when they gave me my license.
We're checking it out on Secretary of State's right now.
Yes, ma'am.
It'll take me just one moment, please. Yes, I can confirm that he has a valid license.
Thank you, Your Honor. Given that, I'm going to move to dismiss the case.
All right. This case is dismissed, Mr. Weems.
Since it was dismissed, is that a win for him? I mean, he did show extraordinary legal skills there.
All right, Mr. Weems, you are, as you know, entitled to be represented by an attorney, and I think I would not be alone in telling you that that is your best course of action. I hear that you do not want to accept an appointed attorney or to hire an attorney on your own. Is that true?
No, I'm here as intervener and authorized representative for Angela Weems. Intervener and as authorized representative for Angela Weems.
I guess, Your Honor, then we're going to need to confirm whether or not this individual who is on the Zoom is actually Angela Weems, as since there hasn't been any filing for an attorney or any other representative, then I believe that it would either have to be Mr. Weems' attorney who speaks for Mr. Weems or Mr. Weems himself. So we just have to confirm that this is in fact Mr. Weems, as I've never seen him before. I cannot determine based on just a screen that is in fact him. And I guess the question would be for Mr. Weems, are you in fact Angelo Gabriel Weems?
No, I'm here as an intervener and authorized representative.
Your Honor, it appears that Mr. Weems has failed to appear. And if Mr. Weems is not here in court today, then the people would be requesting a bench warrant.
Well, let the record show that it cannot be me.
Let the record show what?
That it cannot be me if I'm not here.
That it cannot be you because you're not here? Is that what you said?
I'm here as authorized representative and intervener to settle this matter.
Okay. Since Mr. Weems either is not present or will not acknowledge being present, then I find that he's failed to appear for a pretrial hearing and on 2 probation violations. And I will issue a bench warrant.
Not true.
So what Mr. Weems did in response to the bench warrant was stay on the Zoom call, turn his camera on when she called each subsequent case, then turn it back off when he realized it wasn't his, until finally at the end of the docket, he turned it on and ambushed the judge and got her to speak to him again. It's kind of more child trying to beg his way back into mama's good graces than it is acute legal skills.
Angela Weems here representing myself in proper persona. Sorry, Miss Clunky, about earlier.
Can you confirm that you're Angela Gabriel Weems?
Angela Weems speaking, representing myself. I'm here.
So did he give up on the Sovsit lifestyle? Or was he just so beat down that he falsely confessed to being Angela Weems? Either way, he definitely lost his key to the Sovsit treehouse.
Appropriate persona.
Thank you. All right, Mr. Weems, I was beginning to advise you what a bad idea it is for you to represent yourself. If you do choose to represent yourself, you will be held to the same standard as an attorney, things that people go to school for years and years to learn and to become good at doing. Do you understand that I will hold you to the same standard as an attorney if you represent yourself?
Yes.
And do you want to represent yourself despite the fact that most folks would tell you it's a terrible idea?
Yes, Your Honor.
Yes, Your Honor, but see, the last time I was locked up, Big John over on C Block, well, his uncle's barber's cousin's nephew's math teacher's brother-in-law's barber said that his cousin did this stuff and it worked and he got off. So I'm gonna do it too. Right, because that's smart. So for those of you who are still here, you know, the ones that didn't have an aneurysm as soon as I started talking, oh my God, she's talking on the commentary channel. I got a little bit of information for you. You see, Michigan has this amazing website it's an Otis system, and it's the criminal history for most people, probation and things like that. So as you can see, Angelo Gabriel Weems is on there. He's actually on active probation. His current sentence was scheduled to end now. So he is going to get a heavier sentence for whatever charges he ends up facing if he is charged. Of course, he's innocent until proven guilty. However, if he is charged with anything, those charges are going to be amplified or enhanced, wrong term, by the fact that he was already on probation and then if he has violent felonies. So he's currently on probation at the tail end of a 1-year sentence for carrying a concealed weapon. This also shows the inactive probations historically. And as you can see, a couple years ago, he served time on probation for assault with dangerous weapons, felonious assault, 2 charges of that, possession of controlled substance, marijuana, whatever. But 3 years for that, jeez. Child abuse, 3rd degree. That's a big one. Really bothers me that he did more time for a pot charge than he did for, our system. Controlled substance imitation, manufacture, distribution. So he was making fake something. And controlled substance possession of narcotic cocaine, less than 25 grams, 3 years for each of those. And then another assault with a dangerous weapon, which is felonious assault. And keep in mind that these are just his Michigan charges, and that is just what he ended up on probation for. he's got stuff in a bunch of different counties, a bunch of different courts going on. So he's got a career out of it, whereas he pulled in his partner, girlfriend that they're dating, and got her all tangled up in this, and she literally has no criminal history at all whatsoever. And now she's facing up to 5 years, according to Otis, for the after the fact. So I apologize for not being on top of this and catching it the first time it came through, but I'm not a big fan of the soft sit world, so I try and stay out of it. But I did my research, and this is what I found. Hope you enjoyed it. See you soon.
This is a citation. It was issued on June 1st of this year on 30th Street there in Salem Township, Allen County, state of Michigan. This is a speeding citation on an actual 50 and a 35. However, the officer only wrote you a ticket for going 1 to 5 over. You're here, Mr. DeSmit, on this 1 to 5 over speeder to do one of 3 things. First is you could admit responsibility to the citation, or 2, admit responsibility, but you'd like to provide some sort of explanation to court as to how or why this happened. Or 3, you wish to contest this citation. In other words, fight the ticket at what we call informal hearing. What were you looking to do?
I was looking to fight the ticket.
All right. Then the first thing I'm going to have you both do is raise your right hand so I can swear you in. You swear or affirm that any testimony you'd give here today would be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
I do.
All right. Mr. Smith, it makes a lot more sense for me to start with the officer. He has the burden to establish to me why he issued you this citation. But then after that, you'll have an opportunity to either ask questions or testify on your own behalf. All right?
All right.
And with that, Deputy Miller, you want to pick up the narrative somewhere where it makes sense and explain the issuing of this citation?
Thank you, Your Honor. As indicated on June 1st, 2023 at approximately 12:40 p.m., I was working stationary traffic enforcement in the area of Burnups. This is a posted 35. I was sitting stationary with my vehicle facing northbound. I was just south of 143rd Avenue. It was at this time that I observed a vehicle traveling northbound at a high rate of speed. I then activated my radar in the rear stationary mode, obtained a clocking of 50 in the posted 35-mile-per-hour zone. I then initiated a traffic stop, identified the driver as Mr. Desmond, who's present here today. Speaking with Mr. Desmond, he stated that he's on his way home from playing golf. He was talking to his grandmother on the phone. He indicated that he was speeding, but he did not give a speed as to how fast he's been traveling. In our conversations, he indicated that when he saw the police car, he noticed he was speeding and started to slow down. As a result of this incident, I did issue him citation number SD 19472 for speed. However, I did reduce it substantially off the actual clocking and only wrote him for 40 and a 35. I'm a certified radar operator with the Michigan Speed Task Force. My radar was verified before and after my shift in proper working order. I had a good audio and visual of the vehicle. And then there's no other objects or hindrances that would have thrown off the radar reading. I have nothing further at this time, Your Honor.
All right, Mr.
Go ahead, say that again.
What is it you would like to say?
Okay. First, I'd like to start off by thanking you both for keeping our towns safe, and your efforts in doing so are signs of true leadership and strength. I respect both of you for your positions in the workforce, as they are not an easy role in today's day and age. I have a couple friends in the force too, and I know it's hard. So thank you for your job. What brings me here today, like officer said, was a speeding ticket that I received on June 1st this year in Allegan County on 30th Ave. After receiving the ticket, complying with the officer's instructions and setting up a date to discuss my case, I had some time to drop a map of the situation and to review the reason for receiving my ticket. So let me try to work this in here a little bit. This took a little bit of time. Can you see this all right?
Yeah, Mr. DeSmit, I'm going to be, it looks like I'm not paying attention to you because I'm looking here at a screen as
Okay.
opposed to looking at the camera because I can see it a lot better. All right, go
For
ahead.
sure, of course. Officer Miller, can you see that all right too?
Yeah, I did for the screen on the phone. Yes.
Okay. All right. In my case, I was heading north onto 30th Street. So this black Explorer, we're going to reference as my Explorer. That's what I had. So that's me. And I was heading north onto 30th Street. I had passed Bunker Hill Chill and Grill and the Marathon gas station on the corner near 142nd, which is down here a bit. And then I entered into a 35-mile-per-hour zone. I am aware of the speed limit in the area as I've been through there multiple times. I'm aware of the area. In my situation, I was driving over the hill on 30th Street. So right about here is when it crescents and you go up, and then right after like about here, it starts to go back downhill. I was maintaining proper speed up until this point. Upon going downhill, I noticed a tan-colored car sitting parked on the right shoulder of the road, very close to the lines of the main street. The tan car was facing north, the same direction I was driving. The car didn't have on any lights or turning signals, which in my judgment at the time, I thought someone was either going to get out of the vehicle or it was just parked out in front of a house. With the brown houses and trees in the background, the tan vehicle kind of blended in. So this is the officer's patrol car right here. I just drew that in there. That's to reference that. At the time, I didn't know it was a police officer. Looking ahead into oncoming traffic, I noticed a semi-truck with a trailer pulling equipment, which was heading south, which I have marked right here as just a little bigger truck pulling a trailer. In my safe reaction time, it was clear I had two decisions to make. The first choice was to brake, allow the equipment truck to pass, and for me to avoid getting too close to the officer. My second choice was to speed up, go around the parked car with safe distance, not to interfere with incoming traffic, which I labeled kind of right here with the arrow. And then for me to avoid getting too close to the officer and not allowing me to like slam on my brakes because I was already going downhill. Option two is what made the most sense to me at the time, while ensuring the safety of myself and those around me. Before making my decision to accelerate to pass the parked car and avoid oncoming traffic, I believe I was abiding by the speed limit. So that was the decision I did make, was number two, was to speed up and go around the police officer. And then he mentioned that I was braking after I passed him, and that was because I was going back down to the speed limit after making what I thought was the right decision, which made most sense for me at the time. Upon passing the parked tan car, I immediately began to slow back down to the speed limit until I saw the flashing lights in my rear view mirror. I had no idea the tan car was a police officer. By the time I had safely passed the officer, noticed his lights flashing behind me, I was safely able to pull over on the side of the road. Now the shoulder of the road after passing the officer and going through the intersection of 143rd, there is less than 100 yards worth of shoulder, which I have drawn right here. So after going through the intersection and these guardrails start here, before it goes to guardrails only with no shoulder, there's only about like 100 yards worth or less of shoulder. And I was safely able to pull over where I put the X. That's where he stopped me. That's where I safely was able to pull over. I think if I were to be going exceedingly past the speed limit, there's no way that I would have been able to stop there in enough time for him to pull me over safely. In my 5 years of driving, I've never been pulled over once, never been in an accident, and haven't been asked to watch my speed. I take the law seriously. I'm not a reckless driver. I abide by the law and comply with restrictions when they are given. I know as a driver, it's my responsibility for the vehicle I operate, and I believe I have done that to the best of my ability. I know most people would just pay their speeding ticket and move on, but I truly care about keeping a clean record, and I came here today asking politely for relief of my speeding ticket.
Deputy Miller, were you in a marked patrol car?
I was in a marked patrol car, and at the time I was on the shoulder of the road. It was not nowhere near the road where it would have been a road hazard for people to go out into the other lane to go around me.
Yeah. Mr. DeSmit, I understand your explanation. Your explanation, put it this way. Your explanation that essentially a car parked on the side of the road would be a reason why you would need to speed up, to hurry up and get past it before somebody coming southbound would have been abreast of you on a 2-lane road. That just does not make a lot of sense. And referring to this car all the time as brown and sort of not realizing it's a police officer car also doesn't make a lot of sense. It's a marked patrol car. We all know what they look like. I also suspect that Deputy Miller's radar actually caught you further back than sort of right when you're trying to go around him. But for purposes of informal hearing, I would find, based upon the evidence, that you were responsible on at least the 1 to 5 over speeder that you were written for. Now, because you had a contested hearing, you do have a right to say, I don't agree with what just happened there. I want to take this to what's called formal hearing in front of the district court judges with the prosecutor's office. But to do that, you must ask for that in writing, and you must ask for that within 7 days of today's date. That opportunity to appeal this closes after that time. Do you understand your rights on appeal?
I do.
All right, then I'm going to go ahead and release you. We are all set for what we needed to do here today. Thank you.
Thank you, Your Honor.
It would make Penny very happy if you would like, subscribe, and leave us a comment.